Now 9 o'clock, so it's time for the inquiry to resume. Just the normal announcements. First of all, mobile phones, please make sure they are on silent. And if we hear the fire alarm, what's today, Wednesday? Yeah, we will hear it, won't we? It's 9:15, is it? 9:15, the fire alarm?
Yes.
Yes. So when we hear that, we don't do anything. If we hear it any other time, then we do, and we go out of the fire doors outside the room, down the stairs, congregate in the council's car park, and we don't come back until we're told it's safe to do so. Everybody all right with stairs? Yes, good. Right, thank you very much. The only outstanding thing I think came from yesterday was this joint note that was going to be provided, isn't it?
Maybe we could. Yes, we'll come back to
At some stage.
We've not really had a chance to discuss it
No,
yet.
no, I know, but I don't want it lost. That's all. So.
There is something that I wanted to raise.
Yeah, okay, just hang on. 2 times. Okay. So our job for today is, well, it'd be nice to get Mr. Gearing finished, but if that's not possible, then at least get Mr. Young's cross-examination finished today. And then Mr. Bell has, and Mr. I can't remember. Yeah, it's just Mr. Bell. No, it isn't. Mr. Bell has kindly said that he would be happy to do his cross-examination. Well, not happy actually, I don't think. But anyway, he would do his cross-examination on Friday morning if it came to that, and also your re-examination, so that we can actually hear Mrs. Dickinson's evidence, which must be completed tomorrow.
Yeah, thank you very much.
I don't really see with the time estimates, which, yeah, well, anyway, but with the time estimates, we should be comfortably able to do that and start at 9:30, I think, probably.
Okay. What could go
But
wrong?
if you don't think that that's right, then we'll start earlier.
I don't mind. I mean, I don't mind. I'm happy either way. Happy either way.
Do you think so, Mr. Young? Well, you're only going to be 20
It
minutes.
won't
And you're
be
not
Mr.
going to be
Young
here
saying
anyway, are you? And the first thing, start when you like.
Why not start at 9?
Yeah.
Right, well, because...
I think can we just give maybe on ballot? I mean, we're happy either way,
Okay.
but maybe if we just do one more 9 o'clock start.
Right, we're not going to start at 9 on Friday then.
It's fine by me. No, just because obviously with Mrs. Dickinson there's
All
this
right.
unusual dynamic where we wanted to actually need to ensure that she both begins and finishes on the same day.
Yeah.
So it might even be one of those where people start thinking ahead to a 45-minute lunch break or something if needed.
Well,
or
we're not
whatever.
going to do that.
No, sorry, we've not done that at all. This inquiry.
No,
Lunch
I know.
must be maintained.
Well, I think it's important.
I agree.
actually,
No,
to
I was
have
being
decent
tongue in cheek.
breaks,
I was
just
being
for
tongue
me
in cheek.
anyway. It's not for you. Well, that's very true, and you have to wait. So, yeah, okay. So 9 o'clock tomorrow then, ladies. Thank you. Yes, thank you very much. All right. Now, you wanted to say something?
And I've written out what I want to say, so I'm going to hand it round.
All right. Joe. Thank you very much. Sounds a bit serious, Mr. Simons. All right, okay. We better have this as an inquiry document then, hadn't we? Okay. Have you seen this, Mr. Young?
I've seen it now, yeah.
No, but you haven't seen it before.
He's not seen it before because I've only just finished writing it.
Okay, all right. Well, if you need time to respond.
I'm not asking for a response from anyone
Well,
right now because I don't want to
no.
disrupt the inquiry, but I wanted to say this
But you
now.
might want to respond.
Oh, of course. I'm just saying I'm not
Depends what
asking
you're
for
going
it.
to say. Right, thank you.
So I'll just read it out. It's not too long. The submission to the inquiry reflects the positions of Kent adopted over recent weeks in discussions between Mr. Young and you. The submission is not, at this stage, a cost application against Kent. So first on the principles, the fundamental requirement of procedural fairness in planning inquiries is that a party is entitled to know the case it has to meet and has a reasonable opportunity to adduce evidence and make submissions in relation to that opposing case. That was a case in the Court of Appeal. That position is supported by the mechanisms in the rules and also the Planning Inspectorate's Procedural Guide to Planning Appeals, noting as we do that this guidance applies only by analogy to call-in proceedings, which are not themselves, of course, appeals. It's also reflected in the Planning Practice Guidance on Appeals, which again applies by analogy to this case and which gives, among its non-exhaustive lists of examples of unreasonable behaviour by authorities, introducing fresh and substantial evidence at a late stage necessitating an adjournment or extra expense for the preparatory work that would otherwise not have arisen. It's trite that, in order to act rationally, the Secretary of State must decide planning applications in accordance with evidence. And the court made that clear in the Divisional Court did in a case called the Law Society, where it said that a decision may be challenged on the basis that there's a demonstrable flaw in the reasoning which led to it. For example, that significant reliance was placed on an irrelevant consideration, or, and this is the bit I've underlined, that there was no evidence to support an important step in the reasoning. So next, Kent's positions. Kent's positions at the inquiry have included, but have not been limited to, the following 7 things. First, being neutral on the merits of the proposal while supporting the principle of the roads and saying nothing about viability or costs. That was in its opening in March. Second, raising a, quote, concern that viability may give rise to the need for public subsidy. That was Mr Finch's written evidence in May. Third, suggesting that planning permission should be refused on account of that concern. That was Mr Finch's evidence in chief in July. Fourth, suggesting that such a concern about viability was a matter for the wider planning balance. That was Mr Finch's cross-examination, also on the same day. Fifth, suggesting that its viability, quote, concern represented a showstopper that should lead to both applications being refused. That was Mr Young's comment to the inspector on the 17th of July. Sixth, reversing that position the next day, saying that its viability concerns are a matter for the wider planning balance, which it does not itself seek to undertake. That's to say, Kent doesn't undertake the wider planning balance. That's Mr Young's comments to the inspector the next day on the 18th of July. And seventh, and most recently, suggesting after the close of its own evidence that it would be, quote, beneficial to A, approve the Northern scheme, but B, refuse the Southern scheme on account of concerns about viability linked to an idea about a risk of ransom. And that, of course, comes out of Mr Young's questions to Mr Gearing only yesterday. So on the consequences of those positions, the applicant, we, are for now, and without prejudice to any future cost applications on this, we are content to deal with positions 1 to 6 above through planning evidence and through closing submissions. So that would have been that. But on position 7, which is just for short, Mr Young's new ransom idea, you noted last night that you felt you might not have adequate information to report to the Secretary of State about it. In response to that concern, we note the following things. First, position 7. There's never actually been a position of Kent at any stage of these proceedings, pre-application, during the applications, after the call-in, in its statement of case, in its opening, in its written evidence, in its oral evidence, etc., etc. Second, it's an assertion Mr Young made only through questions in cross-examination for which Kent lacks any evidence. In consequence, it is effectively an invitation by Mr Young, presumably on instruction, I say presumably, we don't know, for you and for the Secretary of State to accept a new point without evidence, and that alone risks, see above, leading to an unlawful decision. You suggested that even though it's unevidenced, having heard it, you may be obliged to report on it to the Secretary of State. With respect, we do not accept that comments during cross-examination from a barrister which are devoid of evidence from any of that barrister's witnesses or any witnesses amount to a matter before the inquiry which requires reporting to the Secretary of State. These are literally unevidenced assertions. Worse than that, they come from an advocate rather than from any of his witnesses. There is nothing material to report. The function of a planning inquiry is not to address every unevidenced assertion made by barristers in cross-examination. These submissions are procedural, as in the ones I'm making now. These are procedural, not substantive. So all of this is without prejudice to what we actually say about the merits of Mr Young's new position 7. And I'd say nothing for now about those merits. We obviously reserve our position on their merits, on their relevance, and we will produce new evidence on it if, but only if, we have to, on which I'm going to get to now. So suggested ways forward. Kent's new position on costs and viability have already added weeks to the inquiry programme and have necessitated prolonging the inquiry into October. That's already led to substantial prejudice to Swale, which has had to allocate a large sum of public money to cover its professional representatives for the extra month. There are all 6 parties who have had to fund a new barrister appearing on its behalf in October, and obviously us as well, the applicant. For the inquiry to be fair, and fair to all parties, and that includes the Rule 6 parties, the Council, and of course us, the applicant, Kent must not be allowed to continue to change its case. It's unreasonable, it's unfair, it's antithetical to the inquiry rules, it causes real prejudice to, among others, the applicant, us. And it is, of course, particularly unfair that it be Mr. Young who is so often the vehicle for these changes of Kent's case, because he has not himself produced a proof and cannot be cross-examined, so the changes cannot be properly analysed or tested. This is not the way planning inquiries are supposed to work. The inquiry has the following options. First, new evidence from the bar, which is to say unevidenced statements from barristers, given only after the barrister's witnesses have finished giving evidence, should be disregarded. That's the procedurally correct and conventional approach. Kent's had many opportunities, including through a late proof of evidence, to develop its case. Changing its case again now without evidence in the final stages of an inquiry is too late. You should reject its attempt to do that. Second, if you're not minded to reject it, despite the risks of procedural fairness that I've already touched on, which is to say if Kent is allowed to change its position again to adopt what I've called point 7 in the list above, then the following steps would need to happen. First, Kent should have to apply formally to make that change. Second, the change to its case should be confirmed in writing, e.g. through an amended statement of case or something. Third, Kent will have to provide some kind of evidence to support the change. Fourth, once that's been provided, we will then have to consider whether and how to respond to the change through our own evidence. Fifth, the inquiry will then have to consider whether and how that evidence is to be examined orally and any consequential impacts on timetable. And to state the obvious, extending the timetable further in order to examine any new evidence from Kent on this risks major prejudice to all of the parties to the inquiry, very much including Swale, the Rule 6 parties, and again, us. And at this stage, we are simply reserving our position on the costs associated with any of those steps. And that's all I have to say.
Before you say anything, if you want to, Mr. Young, I do rather object to the implication in paragraph 1, which rather implies that I've had some sort of discussions with Mr. Young.
Oh, I didn't mean it like that. Okay, well, to confirm on the record, the discussions that I was referring to when I wrote that, I meant the discussions within the inquiry between all of the barristers and you,
right,
not discussions that you've been having with Mr. Young outside the inquiry.
Never behave inappropriately like that, you know that.
Of course, no, I didn't. When I said discussions, what I meant was the back and forth within the inquiry room.
Yeah, well, and the second thing is, I would also say that if there's any implication that I've allowed Mr. Young to bring up inappropriate evidence or whatever, I did, if you remember, step in a couple of times to, talk about the changes in the case.
I do, absolutely.
And it's very difficult because obviously I don't know how things are going to unfold. So,
can I say none of this? I want to.
Wanted to make those
no,
two
well,
things
given
clear.
that this is being recorded, I want to say as well that I used the word discussions inaptly then, because that's not what I wasn't meaning to convey that either of those impressions that you've inferred from it. What I'm not meaning at all to criticise the way in which you've conducted the inquiry so far, because okay. I don't consider that you've. This seems a bit of an odd thing to say, but I consider that the way that the inquiry has been conducted so far has been done in a way that's absolutely, has tried to ensure fairness to all parties. And I don't think there's anything untoward that's happened so far. My concern is really about what happens next, rather than what's happened so far. So I apologise that it read that way, and
Okay.
I didn't mean to
Okay.
give those implications.
That's okay. At least you've clarified that. Thank you. Right. Okay. Well, I mean, it wasn't it? Hang on. I'm not sure it's got. Yeah. I thought it was. Well, usually is.
There should be.
No, don't think there will be. Oh yes. Is that it? Do you think? Yeah. Okay. Now, Mr. Young, do you want to respond? Do you want some time to respond? Don't you want to respond? So 3 options, really.
Yeah, I'll respond if I may.
Do you want a little bit of time?
No, it's fine. So I understand what my learned friend has set out, and obviously if he's going to make a cost application at any stage, then I will respond to that in due course. And obviously in respect of that, we'll look at the way in which the evidence has come forward, the timing of it, the evidence relating to the status of the viability evidence, the issue of the significant risks, and not having any evidence really in respect of the cost of the roads, which is obviously part of the FVA. So we can explore all of that, but only if a cost application is made and the timing of what the applicants have done and what has and hasn't been done. What I would say about the issue of the third-party land is that I put to Mr. Mitford Slade, on the basis of his appraisal, what had he included for the land that this applicant doesn't control. And he said that he relied on effectively Mr. Gearing to provide that information. Could I just invite you to open up his appendices? Yeah, it's his first appendices on page 52.
I think it's 37.13.3. Sorry. 52. I think it's within Appendix 4.
It's the large appendices.
You want the appendices, sorry?
Yeah.
Are you going to that table with the 35?
It's the 3.8 million,
Yeah.
which is at page 52. Does it have page numbers at the bottom?
Yeah, sorry, what page?
52. And this only relates to the northern site, but what it indicates is that he entered a figure of 3.85 million for the third-party land. But he didn't know what that related to. He relies on Mr. Gearing for that. Mr. Gearing gave evidence yesterday, and I asked him about that because, of course, he's the source of that information, and he confirmed that that was other land, not the land controlled by Tremport or Swale. No figure is given for those 2 land holdings, so the evidence is as simple as this. There just is no evidence in the viability appraisals in relation to that land. And that's where the cross-examination gets to. My witnesses couldn't give evidence on what Mr. Gearing had told Mr. Mitford Slade or what Mr. Gearing relied upon for third-party land. So, you can say, well, I haven't called evidence on this. My witnesses can't speak to that. They couldn't speak to that. That's an issue entirely for the applicant. And we have, through cross-examination, established that it doesn't relate to Swales land, it doesn't relate to Tremport's land. And so simply there is no answer to that as to what it is. Our case, really simple. It's unviable. The schemes are unviable regardless of that issue, for all the reasons that are explained by Mr. Spilsbury and also through the evidence of the other witnesses. But that item, the third-party land, we don't have any evidence on that. And so we don't know what the value of that is or how that is to feature. And that's a perfectly legitimate thing to ask in the context of the applicant's FVA. We are not here going to, and the applicant has requested of Kent County Council CPO powers and will underwrite compensation for whatever the cost of acquiring the land, not just the cost of the process, but the compensation, i.e. how much that land is worth. And that doesn't feature in the appraisals. The applicant was given the opportunity yesterday to disclose their promotion agreements. There is a previous promotion agreement which is actually before the inquiry. Yeah, there is a previous promotion agreement before the inquiry. Mr. Bell's.
I think it's CD 1080. It's in the SERDA objection. I think it's Rodmersham Parish Council. I think page 122.
Yeah, there was discussion yesterday about Stokes and Cambridge and what were the implications. We just can't visit that. I'm certainly not calling it a witness on what the value of that land is, because we just don't know. And we've got no idea what would happen through that process and the Lands Tribunal and anything like that. We just don't know. And that's as far as the point goes. The point that I put to this witness is that, well, that might affect what happens with the northern land if granted planning permission. But if the southern land isn't granted planning permission, then whatever that land is worth, those two other landholders, whatever it's worth, wouldn't be tied to the southern site. And that's it. Now, I'm more than happy to reduce that to writing. We've had, in fairness, to deal with various matters in relation to viability which could not have been foreseen before the cost plan was produced. And if everyone wants clarity on that, then I can provide that and can do so on Friday. I don't envisage, after that, the need to call any more evidence on our part. We've just highlighted that there is third-party land to which there is no evidence about its value, but is obviously within the route of the Northern Relief Road. and the applicant obviously has known about it but hasn't presented any evidence on it. That's a matter for them, and I can't make them do it, nor can I suggest that they, or nor can I compel them to release their promotion agreements. That's a slightly different issue, though. That's because at various times in the inquiry, but with not a great deal of clarity, the applicant has referred to funding the road on the basis of a commercial decision about what level of profit it's willing to accept. And I want to explore that this morning because I want to understand really clearly what actually is the applicant's case on that. That was an issue that wasn't raised until very recently, but nevertheless, perfectly happy to deal with whatever Mr. Gearing's case is on that. And obviously, if the minimum land price in the contracts is higher than the benchmark land value, then the contracts reflect a different anticipation of land value than the benchmark land value. But that's a matter for them. Again, if they don't want to disclose, I don't know how the original promotion agreement came into the public realm, but if they don't want to release it, that's a matter for them. I'm simply dealing with the extent of the evidence that we have and what we don't have, and that's it. We decide to make a cost application. If we do, then I'll obviously notify you in advance. I've got no instructions to that effect. We've sought to deal with everything, archaeology, everything of that kind. It's a call-in inquiry, and we've sought to respond to whatever needed to be addressed at the relevant time. But obviously the cost of the road, it is something we've had to deal with during the course of the inquiry, and we've been happy to do that. Same with the highways, we've been happy to deal with that as it arises. Yeah.
No response to any of that, really. I note that there's a suggestion of written clarification on Friday, so perhaps we'll just take it from there. Oh, right.
Is it needed?
Yeah. Well, it's a matter for you, really. But
Why not?
I think for the reasons that I'd set out in my written thing that I've just read out. Mm-hmm. Yes, from our point of view, it would be, I don't know about needed, but it would certainly be helpful so that we could understand what their case is. I think also what Mr. Pereira talked about last night, that from other parties' point of view, like Swale, be important to understand exactly where Kent is on these things. So no doubt a written statement would, I'm not going to say no to a written statement if one is on offer, because I think it could be very useful.
Okay.
Yeah, I made the offer because I think it would be useful,
Right,
and I think it would assist. And yeah, I don't mind if my learned friend wants to recall anybody, if he wants to call Mr. Mitford Slade, but he relied upon Mr. Gearing, and Mr. Gearing has clarified to the inquiry that no account has been taken of any, to use the language of Mr. Mitford Slade, third-party land for those areas. So,
as I say, well, if we see how the way it's put in the written statement, then we can take it from. Happy to sort of leave it there, take it from there, and we'll certainly be clear to you if we consider that on account of whatever's said, we need more evidence. But I'm obviously very much hoping that we won't do.
You said in your note that I shouldn't really be considering this whole issue of these two pieces of land. But
that's not quite. The two pieces of land is something that you can consider. We've had inquiry sessions about it already. We've been over that. We've talked about. You've produced a joint note on it. You've got evidence about
yes,
it.
That's true.
So I'm not in the least. I'm not quibbling about the ability for you to consider the two pieces of land and what mechanisms exist to deliver the scheme over those pieces of land in due course if permission were to be granted. That's not the thing I'm saying you shouldn't consider. The thing I'm saying that you shouldn't consider is the point that I've set out at paragraph 7, Roman 7 on page 3.
Right, okay.
It's specifically that. There's the thing that I'm saying that you shouldn't consider. And that we do stand by because for all the reasons that I've set out. But I think, as I say, I'm content for the moment to leave it until Friday. And then once Mr. Young's position's articulated in writing, I can either come back to you and say, yeah, we're happy that in fact we think you do have evidence one way and the other. I'm not saying it's only, it could be evidence that supports Mr. Young, evidence that supports us, as long as it's evidence, to reach a decision on it or to report to the Secretary of State on it. Then we'll give you a view on that. And if we think that you haven't, then we'll also tell you that. And then we'll have to consider the implications that flow from it.
I mean, the thing is, a call-in is a bit different to a appeal, isn't it? Because you, in a way, you're sort of you have got no reasons for refusal to address, or putative reasons for refusal. So, I mean, I have got some questions on this issue about possible outcomes arising from what I heard yesterday, which went on for quite a long time, so there's quite a lot of it. And I'm just thinking that, if I start with Trendport, we'll obviously be looking at the Section 106 agreement, as you said, and I might have questions as to, what possible outcomes could be there. Now, I hope that's legitimate because, and the same really with the council. They're a public authority. What might their options be? But we haven't really heard from the council.
No, but we might do on Friday, I suppose.
Well, and so I would just like to know, as a public authority, I mean, this would only happen, all of this would only happen if the Secretary of State granted planning permission.
Correct. That's the first thing. Definitely.
So if the Secretary of State grants planning permission, then obviously, the council hasn't raised objections in terms of, as I understand it, viability or highways.
No, they haven't. No.
So the Secretary, if to grant planning permission, the Secretary of State will have had to be satisfied on all the other things that the council has raised.
Yes.
So I'm just wondering, therefore, and I'd like to ask the council, maybe it's some question for Mr. Dygan in October, I don't know, but the extent to which, as a public authority, with obviously the public interest at its heart, the likelihood that it actually would sort of say, no, we're not going to engage. And I think that's a legitimate question. Following on from all Mr. Young's cross-examination. But obviously, I don't want to be unfair or try and bring this within the limits of the thing not being challenged.
No, of course.
So
the point about a challenge. Well, yeah, I totally.
I have to sort of be careful as to what I'm asking. I don't know, but I think it is relevant, given that I've heard all this, and I've heard it for an hour and a half or whatever yesterday. That I can ask these questions, and obviously, if they're not relevant, I suppose you'll have to just say so.
Well, but maybe we take it one step at a time. I don't want to circumscribe the questions that you yourself want to ask witnesses. I mean, that would be a very strange situation for me to be in, and I really don't want to do that at all. If there are things that you're curious about or think are important,
well, I'm interested in it. I mean, we haven't heard from the council at all.
Of course.
I'm interested in what the council has to say about all this. No. Seeing as it's going to be their land.
Yeah. And
how they feel, and I mean, the Rule 6 party might have something to say.
Yeah.
But especially the council, because they are the
landowner.
well, they will
whatever,
be the,
will be the landowner.
I'm presuming the landowner.
Yeah, I'm not seeking to stand in the way of that. The thing that I'm seeking to stand in the way of is more narrow than all of those things that you've talked about, and it's the thing at point 7 on. It's that specific step that was taken in the logic of Kent yesterday that I've set down there in writing, which is why I want to do this in writing so that I could be clear about it.
Okay.
That's the thing. But anyway, I'm not suggesting that you don't ask Swale whether they would stand
I think we
in
could do that tomorrow, couldn't we? In the
Friday. Yeah.
Friday in the section 106, because it is all sort of linked in, isn't it? Or I'm happy to do it in the planning evidence, whatever the council thinks is better.
Without committing to anything at all, apart from what I might commit to in the next few moments, I think I can say that you won't have any clarification at all on the council's position on Friday.
Righty-ho.
And thinking ahead, at the moment, in terms of what you may be seeking, certainly I think we can give you some guidance on what the framework would be, the legal framework for decisions moving forward. We certainly can't. I can't see how we could, at the inquiry, commit the council to a position on what decisions it might take, even on the hypothesis of the Secretary of State having granted planning permission, because there are other considerations that go to the question of conveying land and so on that aren't simply planning considerations.
Well, I'd like to be just briefed on the legal side of
that's that is appropriate and possible, but it can't be done for Friday.
No, that's fine.
Yeah.
Maybe then in the planning evidence, do you think?
Yes, or by way of a note.
Okay.
But we'll have to talk about these things. These things are, as you'll appreciate and has been said, evolving before our eyes.
Well,
so.
Exactly. Mine.
Yeah.
But we obviously wouldn't, just to be for completeness, wouldn't stand in the way of a note like that. That'd be helpful.
Yeah.
And not in the least bit unfair to understand all of that. But I also echo and agree with what Mr. Pereira said about taking it any further than that. You know, we can.
No, I understand that.
Yeah.
Obviously, the council. You can't say what the council's going to do, obviously, because it's council. Council's decision, councillors' decision.
Of course, that cuts both ways. It's the same for us. You know, what this line of questions takes us into a request that you, I don't know, make some sort of have regard to what might happen in respect to future commercial negotiations between us, Kent, and the council at a future date, on the assumption that planning permission has been granted. How that might turn out. And the criticism from Kent is that Mr. Young's just explained is that we've not included a figure that represents the outcome of those negotiations in our FVA, and maybe part of Mr. Pereira's answer to you just now is a reason why that might be the case.
I suppose I'd like to know what the various alternative options might be for the council. Sure. Obviously, not knowing how the council is going would actually respond, but just to understand what options the council would have as a landowner, only on the assumption, and it's completely without prejudice, because I'm thinking, you know, on my feet here, without prejudice to any decision that the Secretary of State will make. Obviously,
of course,
if the Secretary of State refused planning permission, then it wouldn't arise, would it? It would only arise if planning permission were to be granted, and we don't, you know, I don't know what that decision would be, or even what I would recommend at this stage.
Yeah.
But I need to know all the options so I can advise properly. That
makes sense.
That's all. It's not to try and tie the council's hands, because you know you couldn't do that, obviously.
No, and as I've said, the council's hands can't be tied, and these are decisions, if ever they need to be taken, will be several.
Well, they're down the line, yeah.
Potentially several years away. So. Yeah.
Okay, well, let's leave it at that for the moment then. Thank you.
Just if I may then, on that point, I mean, the first thing I'm not going to do is I'm not going to suggest or in any way seek to inhibit what you consider or any threat of legal challenge I think you're probably experienced enough to decide what you want to hear about.
Yeah.
And secondly, your role, obviously, as everybody is aware, is to report to the Secretary of State
Yeah.
on everything that you think is relevant. And in that, you obviously have the right to inquire about all relevant matters. Thirdly, there's no getting away from those parcels of land. They stand in the way not just of the delivery of the road, but the delivery of absolutely everything. So those parcels of land are obviously relevant, and the purpose of my questions yesterday was simply to explore with the witness what accounts had been taken of those in the viability work, and obviously no accounts has been taken of them.
Okay.
And as I said, we've already made clear our position. The schemes are unviable on the evidence. It's not like we're saying this makes this makes them unviable because we don't know what they are. We don't know what they are, but we already think it's unviable. In other words, it's not a tipping point.
No. Okay. Mr. Bell, did you want to say anything? Sorry.
I mean, we agree with the points made by Mr. Young. We think these parcels of land, they are points that we have raised, and I think they're discussed in our planning proofs as well. Although I have to refresh my memory, having ruled myself out of planning, I've slightly forgotten what they say, but I'll refresh my memory of them. We don't have any kind of differences in respect to the points Kent's made. I mean, it's probably important just to reiterate to people listening at home that we're not in support of the road as currently designed, but I don't have anything I can usefully add, I think.
Okie dokes. Right, well, should we leave it at that for the moment?
Just as well we started at 9.
Right, okay then. Should we carry on with cross-examination unless anyone's got anything else to raise?
Thank you.
Right, thank you very much. Mr. Young.
Thank you very much. So, Mr. Gearing, good morning.
Young, good morning, Mum.
The first thing I'd like to do this morning, as we get into all the cost of the road evidence, is just to be absolutely clear about the evidence that's before the inspector, and first of all, what it is, and then we're going to explore how it's presented. So the first thing I think I want to explore with you is your first rebuttal and your second rebuttal, and understand the documents that came in, and that's just the first step, if you like. So you produced a rebuttal, a cost rebuttal it was called. If you take that up, it's 3714.1.
Yes.
And you say in the text that it's a rebuttal to Mr. Birchall and Mr. Finch, yes?
Correct, yes.
Yeah. Okay, and then there are a number of documents that accompanied this. That's right, isn't it?
Yes, 1.13 sets out the appendices that are included.
Yeah, so I go to 1.3, is that right?
1.13.
Yeah, you see, the version I've got of your 37.14.1 has got section 1, 1.1, 1.2, 1.3. See that? And then at one point, you say 13, you've got your rebuttal, and there were 3 documents attached to that. Is that right?
Yeah, appendix 1, 2, and 3.
Okay, so let's just be clear about what they are. The first one, yeah.
Rebuttal.
The first one, yeah.
All right.
And when I go to the documents and I look through it, and somebody's kindly put this together for me, I've got a document from Mr. Bell at Chapter 4 Limited. Is that right?
Yes, that's appendix 1.
Okay. Secondly, I've got the contract expert report. But you see, in my divider there, I've got a copy of KCC's cost plan, which was labelled as document, I think, 3714.2A1. And this is perhaps where some of the confusion arises. That came in with your evidence. Is it attached, or is it meant to be attached to Mr. Bell's evidence?
Mr. Bell's evidence is an appendix, and there are appendices to Mr. Bell's evidence.
Ah, okay, all right.
So they are all within my submission pack, as it were.
So these have all got numbers, and what I've got is I've got your cost rebuttal as 37.14.1,
Okay?
and then I've got Mr. Bell as 37.14.2A2. Is that right?
2A1.
2A1, oh, right, 2A1. Okay, and then the document after that is that I've got are Kent County Council Cost Plan NR1 Revision A, and obviously that's a Kent document. Is that meant to be attached to Mr. Bell's evidence?
Sorry, I'm just going to...
I've got a document that is Kent County Council Highsted Park Cost Plan NR1 Revision A. So not Revision B, Revision A. And I've got that in with those documents.
Just give me a moment, sorry.
Crikey. Haven't got that. Oh yes, yeah. Did you say the cost plan NR1 revision A?
Yeah, that's the spreadsheet,
Yes,
Excel spreadsheet online. Yeah.
And the bit I wasn't clear about was what is that attached to? Whose document is that attached to?
Mr. Bell's document.
Okay, so Mr. Bell has taken the Kent cost plan and he's simply appending it, or has he amended it in any way?
I'm just looking at the document now.
You can see, sorry, if it helps, on the, I don't know how it's been printed, but for those who have it on Excel, there's a summary sheet at the front that's called main summary. I don't know if you can see that. So it sets out a column with Kent costs, and then it says JCE allowances, and then it says difference, and then comment.
That's very helpful. So what we have is the original cost plan, and then obviously Mr. Bell has made additions. Is that right?
So are we in 37.14.2A.3, Appendix 1, Part B to Mr. Bell? I just want to check I'm in the right document. Sorry, I just want to make sure I'm in...
That's quite a list of...
It is, but I just want to make sure I'm in the right document that you're referring to. Appendix 1, Part A?
37.14.2A.2.
Yep, yes.
I honestly don't know what the number is.
I didn't do your printing, so I don't know how you've set it up.
What I do know is that I've got a document that, to an extent, looks like the Kent cost plan, but then has, as my little friend points out, extra columns on the front page, which is JCE allowances, which is Jackson Engineering. Is that right?
Yes.
And the reason I'm interested in that is it's really important with all of your documentation that we know, obviously, what is the document, what is its status, and who is the author of that document. The author of this document refers to Jackson's allowances, yes?
Yes.
Yeah. So whoever wrote it is effectively taking Jackson's figures, yes?
So my understanding is Mr. Bell is using the figures from ADCC and from Jackson's to produce this side-by-side analysis, which runs through his appendices.
Yeah. The author of this document is Mr. Bell. Is that right?
I believe so, yes.
Yeah, okay, using Jackson's allowances. Right, okay. That's helpful. Okay, and then if we go into the sort of Section 3 construction cost breakdown, then we've got the same thing. We've got the KCC cost plan, then we've got the JCE analysis, and then we've got comments as well. Do you see that?
Yes.
So it's Jackson again, isn't it?
I think it's Jackson's and Mr. Bell working together, but yes.
Okay, working together. All right. I get through that document, and then I've got at the back JC allowances. So this last page of that document, I think, you'll correct me if I'm wrong, is just Jackson evidence. Is that right? Jackson allowances.
Is this
Side by side,
is this
isn't
the
it?
tab at the bottom? I mean, you're looking at the paper version, which makes it
Yeah.
slightly more complicated. But there's 3 tabs in the
The final.
Excel version: summary, construction. Then it says 100.
Yeah, series 100 preliminaries.
So series 100 has a look at Jackson allowances, Dadwell allowances, and numbers there. So this was being worked on in the discussions with Dadswell, but between Mr. Bell and Jackson's.
Okay, so we've got, we understand that Jackson's involvement in that. Okay, then the next document I've got is, again, I don't think it's your second appendix. I think it's Mr. Bell's second appendix, because your second appendix is Mr. Goodwin's report,
Correct?
who we've heard from. The general assumptions and clarifications documents, so I've got that, and this version doesn't have any commentary to the side of it. I think, sorry, forgive me, is this Jackson's or Mr. Bell commenting on Mr. Park's assumptions in the cost plan?
Just for clarity, can you give me the CD reference? Because I've got the CD references in front of me.
The one I've got it under is CD 37 14 2A 3.
Grade 3. So this is the breakdown of, as you said, the discussions that were held between Jackson's, Dadswell, and with Mr. Bell as well. And where there are marked up commentary, this comes from the discussions that Jackson's were having with Dadswell, and Jackson's was subsequently having with Mr. Bell, or he was in the same meetings.
Okay. When I go to Mr. Bell's evidence, he has got an appendix 4. So if you go to his document, which is, 37 14 2A, and go to paragraph 4.
Hang on.
Paragraph 4.
Mr. Bell, paragraph 4.
Paragraph 4 refers to Jackson's cost plan, okay?
Yeah, appendix 1, yes.
2, side-by-side table comparison of Dadswell's and Jackson's costs, yes?
Yeah, that's the side-by-side table that we've
Just been
used
looking at.
previously.
And then 3...
no, we hadn't looked at it this morning.
So not the side-by-side, because that's the pink and the blue.
Yes.
Yeah. Okay. All right. So everything we've been looking up to now, although I've got it in different parts, is all the Jackson's cost plan.
It's all appendix 1, yes.
Okay. All right. Even though I've got it as separate documents, so I've got it as 37 14 2A3. Okay.
I think it's because, just to help clarify, I think the first section is a section 1 cost, which relates to the junction 5A, and the second section is 2 to 4 costs, which relate to the Southern Relief Road. So I think maybe it's been broken down in your folder on the back of the spreadsheets.
Yeah. Okay, so then if I want to understand because Learned Friend has been keen to point out, look, Jackson's have produced a cost plan. It isn't just Dadswell's has produced a cost plan. We've got a cost plan as well. This is it, because it's the Jackson's cost plan in Appendix 1. And as a cost plan, if you look at that first sheet, it's got the Kent figures, the JCE allowance, the difference, and the comment. Do you see that?
Sorry,
Yes.
which one are you going?
So I've gone to the first appendix to Mr. Bell.
Right. Okay. Yep.
And what it says is Kent County Council Highsted Park cost plan. Do you see that?
Yes, that's
Yeah.
referencing the Dadswell work that's been dropped in here. Yeah.
Really important for the inspector in her reporting to the Secretary of State and for her own understanding is to recognise this is actually the Jackson's cost plan, because Mr. Bell tells us it's the Jackson's cost plan.
Yes, it's the KCC figures copied through, and then alongside it, JCC allowances, difference and comment. As it says, it sets it all out.
Yeah, it's just the status of it. The status is, as explained by its primary author, who I believe is Mr. Bell. Madam, if you have Appendix 4, sorry, not Appendix 4, if you had paragraph 4 of Mr. Bell's evidence.
Oh, yeah.
Yep.
Yep.
The inspector wants to understand, right, what is the cost plan that the applicants say they provided? Then she need go no further than Appendix 1, and she can see Appendix 1 is Jackson's cost plan, and when we go to Appendix 1, that is it. That is the Jackson's cost plan. Yes or no?
Yes, that's what Mr. Bell states. He says Jackson's cost plan, in brackets, Jackson's costs.
Good. Okay. So then the inspector has a cost plan from Mr. Parks. It's the Dadswell cost plan. Could you take that up, please? So that's his appendices. We're going to come back to the rest of Mr. Gearing's documents, but
You have the document reference, please.
the document is 39.7.2. 39.7.2.
And this is revision B, May 25.
It is.
Okay. So this is the supplementary additional proof of evidence KCC provided after we provided our first rebuttals, is that right?
So I'm ever so sorry. I've just asked you to pick up Mr. Parks's appendix. So
Just
look.
clarifying what it is, that's all.
Yeah. What you're saying is this is after Jackson's cost plan.
After the Mr. Bell document you showed us last time, yes.
Yeah, because there was a
There's a
revision
chronology that's important.
to because he refers to. I see what you mean. Sorry, NR1 revision A, and this is NR revision B. Do you see that?
Which page are we on?
So we're just establishing the documents first of all for clarity. The one that is included as part of the Jackson's cost plan is and labelled Kent County Council Highsted Park Cost Plan NR1 Revision A. Do you see that? That's the document that is Jackson's cost plan.
NR1 revision. Sorry, the one in this appendix is
The heading to the Jackson's
revision B,
cost plan is Kent County Council Highsted Park Cost Plan NR1 Revision A. The one that is provided by Mr. Parks in the appendix to his evidence is Kent County Council Highsted Park Cost Plan NR1 Revision B. So it's the later revision.
Yes.
Okay.
Yes.
So if we open that up, what we can see is Mr. Parks sets out the version and explains the revisions. So that's in the inside cover. Do you see that?
Yes.
Okay. Then we've got a contents page. Do you see that?
Yeah, page 5, yeah.
And then it begins with a section called general information. So that's setting out the drawings that are relied upon, yes?
Yes.
Yeah.
Page 7.
Page 7 of the PDF, yeah, page 1 of the document. And those are all the drawings. Remember, we put those into the inquiry so the inspector could see what was being relied upon, yes?
Yes.
Yeah. And when I go to the Jackson's cost plan, not only is it, labelled as the Kent County Council cost plan, but in addition, there's no reference to the documentation that Jackson's were working off, is there?
I haven't got it open, but if you tell me that's the case, I'd take your word for it.
It doesn't. And then what it does, whereas the Jackson's, the Kent County Council main summary, so if you go within the document to page 6,
This is Mr. Parks' one.
this is Parks, yeah.
So this is the main summary, section 2 on page 12 of the PDF.
Yeah, it's just when it says main summary.
Yep.
And there we can see there's an elemental summary, and it's got costs in relation to junction 5A. Do you see that?
Yes.
highways south, do you see that?
Yes.
Highways north.
Yep.
And then total scheme cost, yes?
Yeah, I'm quite familiar with this document.
So it's total scheme costs, and then it's divided into each of the components, so preliminaries, site clearance, fencing, etc. Do you see that?
Yeah, that reflects the same approach was taken with their initial document that was provided us on the 1st of May, so
Yeah.
it's carried through.
And then we've got a total at the bottom, £366,230,208.
Yep,
See that?
total scheme costs including scope risk allowance, 366,230. Yep.
And then the detail of that, if we see, look at the construction cost breakdown over the page, section 3, it's got the Series 1 preliminaries,
Correct, yep.
general preliminaries, including compound setup, temporary works, etc. And then we can see there is a reference to the quantity, which is, in that respect, expressed as a number of weeks. Do you see that?
Quantity, yeah, 104 weeks. Injunction.
Where does it say that?
So we're in construction costs, section 3, and then the first item under Series 100, preliminaries, is general preliminaries, including compound setup.
Sorry, hang on a minute.
It's the Series 100.
Yeah, I'm not sure.
Preliminaries.
I'm looking, what page is it on?
It's referenced at the bottom as page 7, but it's PDF page 15.
No, I'm on, 7. So where am I looking?
If you look at the top and you see a heading, Series 100 preliminaries.
Yes. got
Okay.
it.
And all I did to make sure we're looking at the right document was read out A, general preliminaries, including compound setup, temporary works, supervision, etc.
Yeah, but you were saying about 104 weeks, weren't you? I was
Yeah,
wondering
and-
where that was.
Oh, against junction 5A,
Yeah.
there's 104, which
Oh,
is
I see.
the quantity.
Yes. Okay.
And then the unit, so obviously what the 104 relates to is the number of weeks. Do you see that?
Yeah.
And then that's got a rate and then a total.
Yeah.
So they've set all that material out. Now, when I go to the Jackson's cost plan, I obviously, as you know, haven't got the drawings set out. I haven't got reference there to a subdivision of the different components, because what I've got there is KCC Highways North cost, and then the total cost of that is 31 million. Do you see that?
I'm just going back to the Jackson's document. If you can give me a moment. Sorry, this is a bit slow.
Can I ask a question, please?
Yes. please do.
So this is on the Kent County Council's revision A, isn't it? So
It is.
the one we've got here, Mr. Parks' cost plan was revision B. So revision A was an earlier cost plan, was it? By Mr. Parks.
Yeah, so Mr. Parks produced, there was an original, there was a revision A,
Yeah.
and then there's a revision B.
There was an original before the revision A.
Yeah.
So okay, just for my note, where would that be?
I will, I'll find the document reference, but
And revision A as well.
yeah, so what you want is the CD reference numbers for the two earlier revisions.
Just my note.
Yeah, no, I understand
Yes.
completely.
Okay, so this one of Jackson's then, they have taken the revision A, not
Revision
one,
B,
revision
yeah.
B. Right.
At this point, yes.
We're going to come on to that in the
okay.
further rebuttal.
So in response to your question,
Just help me with this. Your rebuttal evidence, the second rebuttal, also contains a Jackson's cost plan. Is that right?
it includes updated costs. Yes.
Yeah. Okay. I am going to come to that. And I'm not trying to say, well, you've worked off the wrong version, because
No,
I know
it's
you've
just
got a
complicated to
version.
get it right.
Yeah,
So-
yeah. In terms of the revision A, what they did, as far as the format is concerned, is they isolated Highways North. Do you see that on this sheet?
I think it's actually the junction cost, not Highways North on this sheet. But okay.
Okay, well, there's a figure at the bottom of total construction
31.2.
funds, 31 million. Yeah, and my point is, I appreciate there's been change. I'm not saying that's the right figure on our evidence, but if you look at Mr. Park's appendices and you look at the Highways North cost, you can see a total construction cost there of
Yes.
30 million and 72. And the reason for that is there's obviously been a change between revision A and revision B, hasn't there?
Yes.
Hold
Yeah.
on, I'm not sure where that figure comes from, sorry.
Okay, so if you look, it's my fault. If you look, please, madam, at Mr. Parks's appendix,
Yeah, I've got that.
and you look at the page 6 as numbered main summary,
Right. Yeah,
and you go to the column which is called KCC Highways North,
yeah,
and you go to the total construction costs, which is before professional fees and so on, that figure is 30 million pounds,
right,
72,000, okay?
yeah,
And so we're obviously not talking about the Southern Road, and we're not talking about the Junction 5A, we're talking about the North, and that means the Northern Relief Road, doesn't it?
So, yes, and I think you took me to this document. I've obviously got the Excel spreadsheet here, which has the summary section, which you mentioned, KCC Highways costs, the ADCC costs, JCC allowances you mentioned, difference, comment. And then the second tab, construction, has the breakdown that you referred to there.
We're going to come to, just forgive me, we're going to come to the different components. What I just want to be clear about is the status of the Jackson's cost plan, because it isn't actually set out as a cost plan. What it is, it doesn't detail the documents that it relied upon or whatever. It doesn't rely on the documents. It doesn't set that out. What it does is provide the figures that Kent provided for each item. Do you see that? And then it says JCE allowance. Do you see that?
Yes, yep.
Then it identifies the difference and then provides a comment. Okay?
Yes, yes.
And then what it says about site clearance, for example, is rationalisation. So that's the explanation, rationalisation rates. Do you see that?
Yes,
Yeah.
I think I said in my evidence, Chief, we were given the ADC costs. We had a couple of weeks to try to respond. This is the process we went to respond.
Yeah. And then the fencing, no difference, road restraint
Fencing
system,
0.
and so on. And there's a difference of 192. Removal of
and then a reasoning why there's a difference. Yeah.
yeah,
That's what
removal
comments are
of
for.
central reservation. Yeah.
Yeah, because there was no central reservation on the drawings, for example, and ADCC had assumed there was. So, yeah, this was the process we were going through to try to reach common ground between us. So,
Yeah,
yes.
okay. And so what you're doing is trying to identify that. And then there was discussion with ADCC, wasn't there?
I just said yes, yeah.
And as a consequence of which they considered some of Jackson's points, yes, and Jackson considered some of theirs.
I think that's a fair
Way of
comment,
putting it.
yes. Yeah.
Yeah, okay, all right. On the preliminaries, for example, Series 100 preliminaries, there's no identification of a difference, is there?
Can you explain what you mean by no identification of a difference?
So you see there's a difference column. You've got J. Yeah, this is not a cost plan. This is a commentary on a cost plan with Jackson's figures. But when we get to the difference and the comments, when I look at preliminaries on this sheet, I can't see any difference identified. There is one, but it isn't identified in the difference column, is it?
So in the Series 100, which I think you've just taken me to, JCE set out their Series 100 preliminary allowances. So they have general preliminaries of 5%, staff preliminaries of 8%. They set out their temporary works allowance.
Just look at the first sheet, if you will.
Okay,
Series
sorry. I
100
thought we were looking at
preliminaries,
Series
6.6 million. So if we've got that open, you can see that Kent County Council had got 6.66 million. Do you see that?
So on the summary sheet,
Yeah.
6.6 million for Kent,
If you go-
2.397
Just,
for
if you just
JCE.
take it in turn. So if you go to the next one, JCE, 2.397 million. Do you see
Yes.
that? Nothing is given as the difference. Do you see that?
There's a separate whole tab on section 100 because there's a whole breakdown, so it wouldn't fit in
difference.
that. It wouldn't fit in one line, so there's a whole tab that separates that.
Yeah, so it doesn't identify a difference, but there must obviously be a difference because we can see what the two figures are, can't we?
Yeah, they're broken down in the same Excel spreadsheet under a different tab.
And then when we get to the total construction cost figure at the bottom, do you see that?
Yes.
That's 7.227 million, yeah?
Yeah.
But that, again, doesn't include the difference, does it?
And that is the difference, 23.9 to 31.2.
Yeah, so the so look at the difference on items series 200 to series 3000. Do you see that?
Yes.
And do you see what that adds up to?
7.176.
Yeah, okay. And then if you go down to the total difference below all of that and preliminaries, okay,
Yes.
you've got a figure of 7,227,000. You see that?
Yes.
Okay.
I see your point, yes.
And the difference between the two is about £50,000, yes?
7.176 to 7.227, yes. Yeah.
So the difference isn't reflected in the difference column at the bottom, is it?
No, I presume that's because it's construction costs. You've got 31, but then it shows 23. So yeah, I think it's excluding the difference in preliminaries, which is set out in section 100.
Yeah, so what we know is the difference isn't isn't that figure because the preliminaries are included in the table. It shows a difference, but it didn't identify a difference. And then the difference at the bottom, the total construction cost difference column, which has the line and then the two lines below, only reflects the differences in some items, yes?
So I'm just looking at these figures.
Well, that must be right, mustn't it? It only reflects the difference.
You've got a
If you
below
just
line
have a look
cost.
at it, it's just the difference in some items, not all of them.
It's the difference in the items that are set out in column T. So the series 200, series 400, etc., etc. So yes, some items.
Yeah, okay, all right.
It's
And then
maths for that, yes.
when we go to the construction cost breakdown, what we have, again, is not a cost plan. What we've got is the Kent, or not a Jackson's cost plan, we've got a Kent County Council cost plan, and then we've got a JCE analysis. Do you see that?
Yes.
And then comments against some of the figures. Do you see?
Yes.
So where it says Series 400 road restraint system, it's got allow for minor VRS works. Do you see that?
Yeah, it's £35,000 allowance allowed
Yeah.
for minor VRS works. Yep.
Okay, so that was taken out. All right. And then if we have a look at, the document, what we have throughout the document is a Kent cost plan with Jackson comments on it, yes?
We have a Kent cost plan, we have JCE's figures, and their rationale behind why their figures are different, yes.
Okay, I'm going to suggest to you, first of all, that isn't a cost plan, all right, first of all.
Okay.
Secondly, Jacksons are not cost consultants, are they?
Agreed.
Thirdly, the author of this document is Mr. Bell, but using Jackson's figures.
Working with Jackson's, yes.
Yeah. Fourthly, Mr. Bell isn't giving evidence at this inquiry, is he?
He's not, no. His evidence is an appendix to my first rebuttal.
Mr. Bell is a quantity surveyor, isn't he?
I can check his qualifications, but yes.
Yeah, he's a quantity surveyor. He tells us this at point one. Currently a consultant quantity surveyor. He's a chartered project manager with the CIOB and an associate of the RICS, yes?
Yes.
You are not an associate or a member of the RICS, are you?
I'm not, no.
No, you are not a surveyor at all, are you?
Definitely not.
You are not a cost consultant.
No.
So the cost evidence that the applicants give isn't from a member of the RICS, it isn't from a cost consultant, it's from the applicant itself. You are, in effect, a member of the applicant firm, aren't you?
Yes, and I've explained that the applicant firm does have RICS members, it does have civil engineers, and it does have QSs within
Yeah,
it.
I'm just going on the information of the people I'm relying upon, because
Okay.
I've got Mr. Bell, who
Yes.
isn't giving evidence, who is RICS. I've got Jacksons, who are a contractor, and I don't get to cross-examine either of them. So I've got the Kent County Council presents a witness who is an RICS quantity surveyor, and that is Mr. Parks, isn't it?
Yes, you presented him after your first two witnesses as a late addition, yes?
Yeah, and in addition to that, and he is the author of the cost plan commissioned by National Highways and Kent County Council, yes?
I understand so, yes, with his colleagues.
The author of your cost plan is not giving evidence at this inquiry.
No, he's not.
No. That person who has assembled at least some of the evidence is an RICS member, isn't it?
Yes?
The decision has been made for them not to give evidence at a public inquiry. That decision has been made by
Hang on,
whoever
who's
it is.
that?
Mr. Bell.
Oh, we're talking
Yeah,
about
Mr. Bell is the
Oh, yeah.
RICS quantity surveyor. The decision has been made. I don't need to know whether, who made that decision, what member of the team made that decision. All I need to know is it's right that the decision has been made not to call Mr. Bell.
Yes, we produced our first rebuttal, which didn't respond to evidence of Mr. Parks because he hadn't written it and you hadn't submitted it, and you actively said to this inquiry you were providing 2 witnesses, not 3, and then we were surprised to find an additional witness with a late representation that we had to make a further response to within a week, I think.
Yeah. Why is Mr. Bell not giving evidence at this inquiry?
It's not a yes or no answer, but Mr. Bell provided the evidence that we're relying on in our documentation, and we're happy with that.
Why is he not giving evidence to this public inquiry?
I don't think I need to answer. I think I've just answered that.
We'll leave it there.
I've just said that. He's provided the evidence. We're happy that the information that's fed into our FVA is robust. We've provided written evidence. You've just gone through it. We've provided details of JCE and who they are and what they've done. We've explained how we work with other contractors previously. We've explained who we have in-house, and we've explained what Mr. Bell has done in the main to try to provide clarity to the inquiry on the difference between our costs and your costs.
Yeah, you've chosen not to present Mr. Bell. That's a matter for you. I've asked you why, and you've declined to explain. So just help me with this, please. In terms of your role, you work for the applicant, yes?
Yes.
You are not independent of the applicant because you are part of the applicant, aren't you?
Yes. Yeah.
Yeah. Jackson's are the party providing, as we can see, it's the Jackson's evidence that informs the cost plan that is said to be Jackson's cost plan, yes?
In specific response to the ADCC plan, yes. In our rebuttal, yes.
You have decided not to call Jackson's at this inquiry either, haven't you?
Yes.
Yeah. Not who, doesn't matter who. Why have you not called the source of your cost evidence?
Because they are a construction consultant that have provided input to our FVA so that we have analysed ourselves. They're also, I'm not even sure they could give evidence given the discussions going on with Grovehurst that you're fully aware of. And we've used their figures to inform our work. And we've presented our work. I think that's sufficient.
Just your point about Grovehurst, lest anybody be in any doubt, there's an issue and a dispute at Grovehurst, isn't there?
That's now my understanding, yes.
Yeah, and so what we're doing, we're being careful, I think everybody's being careful, not to make any commentary on what has happened at Grovehurst. Is that right?
I think it puts JCE in an awkward position if they're working on a KCC site to be asked questions about a project potentially that they can't answer, and it's not appropriate for them to answer. And I think you suggest that yourself.
So you spoke to a number of consultants, didn't you? Forgive me, a number of contracting firms, yes?
We've worked with a number, yes.
Yeah, but you spoke to them in the context of this case. You said so yesterday.
In the context of these applications.
Yeah, you said we've spoken to three tier 1 firms. Yeah, one of which is Volkers. Yes.
Yes, we work with them.
What's the name?
Volkers. VOLKERS.
Okay.
Volkers is what everybody calls it. I'm told.
Yeah.
Volker Fitzpatrick, German and Irish.
No.
It's a good combination, really, isn't it, for building?
No comment. No comment.
Okay.
Right. So, of the 3 firms that you referred to, Volker Fitzpatrick are one of them. Yes.
Correct, yes.
I am told that in contrast to Jackson's, they are a tier 1 company.
They meet the definition that Mr. Park said of the higher turnover in particular,
Yeah.
and follow the end-to-end, essentially non-subcontractor. They are the principal main contractor.
Yeah, they are a much bigger firm than Jackson's, aren't they?
Yes, yeah, they are.
Yeah, and they're involved in much bigger projects, yes?
My understanding is that's definitely the case, yeah.
Yeah. So, Jackson's have got a difficulty in terms of their position with Grovehurst. You could have gone to Volker Fitzpatrick, for your costings, couldn't you?
We've previously done work with them, yes.
Not an answer to my question. You could have gone
I ended with yes.
to Volker
Yeah,
Fitzpatrick. Okay, well, if you start with the... Yeah, I don't want to be difficult.
Yeah, so yes, we
Yeah.
could have. We had previously
So
done some
you
work with
could
them.
have gone to a recognised tier 1 contractor to get your costings. Okay?
Between the 10th and the 24th of May, presumably.
Yeah, and did you approach them?
We didn't reapproach them, no.
No. So you haven't asked them to provide costings in relation to these roads and this motorway junction?
We did historically in the past, and that fed into the Aspinall Verdi work, as I set out in my evidence in chief. We've then also worked with Brahini, and we continue to work with Brahini, as I set out in my evidence in chief. And most recently, we worked with Jackson Civil Engineering, in part because we were responding to the updated drawings on Junction 5A. We wanted a further cost, because it's good to have more than one contractor cost, I'm sure you agree. And Jackson's were, at the time of the ADCC work, the company we were working in detail on. So it was a circumstance of the timing to an extent.
Yeah. So the Jackson's cost plan, obviously, that's what Mr. Bell calls it. It isn't the Volker Fitzpatrick cost plan, because you haven't gone to a tier 1 company for your costings, have you?
Not by, well, we went to them previously.
And it's just in the context of this evidence.
Context of this evidence, no, we haven't gone to a tier 1 company as defined by Mr. Parks, but I'm comfortable that they're defined as defined by my first rebuttal proof. I've set out what I see as a tier 1 contractor. There's a definition in there, and that's what I've set it out as.
We
can disagree on that. Though, it's fine.
About
I don't
that.
think it's
but
big deal
that's
to disagree on.
important about the companies, because the assumptions that are made in the Jackson's cost plan is assumptions and clarification. Assume the scheme will be delivered by the developer utilising a tier 1 contractor, and the commentary doesn't disagree with that, does it?
Well, no, because Jackson's clearly were not doing work on the basis that they wouldn't be delivering it.
Okay. Just help me with this then. We get the document that is said to be the cost plan, and we've had a look at that. Mr. Bell also provides, you have to go back to Mr. Bell's appendix, his paragraph 4. His appendix 2 is the side-by-side comparison. And this is the pink and blue document, yes?
Just opening that, yes. Are we in the initial one or the updated?
Just the initial one,
Okay.
so I've got the clarity on the documentation, so has the inspector.
Yeah, 37.14.2b.
Yeah.
Okay. Oh no, sorry, that's not right.
I don't mind if you just go to the appendix 2, that'd be
Yeah, I'm
ideal.
just making sure I'm in it.
Hang on, I haven't got... So which one is it? 2?
Aha, yeah, 37.14.2a, sorry.
37, 14, 2A,
4.
4.
Yeah.
Is it? Okay.
This will be the longest referencing ever, I think, for documents.
That's confusing, that's for sure.
It is.
Sorry, Mr. Gearing, but...
Okay, and we look at this document, and this is the first version of what we would call the pink and blue, yes?
The first version, that's, yes.
Yeah, and what he did there was identify 4 items which accounted for most of the difference, yes?
Yeah, they're in a different colour, they're in blue.
Good, okay. And then Appendix 3 is the Jackson Civil Engineering Summary of working for KCC. So this is the document where they say the projects they've done, yes? Like
I think so, yes. It includes project experience.
yeah, okay,
So,
like
yeah,
Key
talks about
Street,
some of the, so
Key Street for 4 million and so on. I understand all
Love
that.
2 at Folkestone that Mr. Birchall raised, Key Street 4.3, Grovehurst 22.6.
I don't need to go through it. I just need to be clear we got the right document, because I think that's a document that we then see again in your well, forgive me, that's the document that is part of Mr. Bell's evidence attached to your evidence.
That's the third appendix to Mr. Bell's appendix.
Yeah.
Yes.
Okay. All right. And then if we go back to your proof,
Yes. Give me a minute.
quite a lot to
Actually, I've got a paper copy. That'd be easier.
yeah, quite a lot to work with. In the end, everybody comes back to the paper.
I think I'm hybriding here.
Mr. Simons is a 21st century barrister.
I'm trying to avoid it, but yes.
Yeah.
So his first rebuttal, yes?
Yeah.
So this is the June 2025 cost rebuttal, CD 37.14.1.
Yeah. His document this morning was in paper, obviously, but yeah. The position is there's then a Mr. Mr. Goodwin. It's because it was important. That's why. Mr. Goodwin's report. Now, Mr. Goodwin is one of the people we've heard from, isn't he?
We did hear from Mr. Goodwin, yes.
Yeah. So he gave evidence, and he is a specialist surveyor. Yes. Not a member of the RICS, but he is a specialist surveyor.
Yeah, he went through his qualifications in evidence in chief.
And then we have the evidence of Mr. Wilde, and we know who Mr. Wilde is. We remember who Mr. Wilde is.
We do now.
Mr. Wilde is the highway witness, yeah.
Yes.
Good, okay. So the only member of the RICS who's giving any surveying evidence on your side about the costs of anything, and well, anything about viability is, of course, Mr. Mitford Slade, isn't it?
Yes. Yes.
There's no other surveyor and no other cost consultant giving evidence on
No.
the costs?
No.
Okay. I'm going to suggest to you that's very unsatisfactory. The inspector is here at a public inquiry. She is expecting expert evidence to be given by independent experts, and in truth, nearly all your cost evidence is being given by the applicant itself, and that is unsatisfactory.
Is that a question?
Yes, it is. I'm putting to you it's unsatisfactory.
So we gave viability evidence via our chartered surveyor. The cost evidence that fed into that, we've provided as part of our rebuttals the details of the evidence that has fed into the work of Mr. Mitford Slade. We've explained who the in-house team are through this inquiry. We've explained, and I think it was Mr. Goodwin who explained the type of people who work for Jackson Civil Engineering, the qualifications they have as well as estimators and cost consultants. Well, not cost. They have their own in-house people who do that kind of work.
They've got people.
Sorry, just let me work through this. So they have people who do their work that have the relevant experience to provide costings. Mr. Bell is appropriately qualified to review those costings. We have our own in-house team that has appropriate qualifications through those costings, and all that has fed into the work that's been produced by Mr. Mitford Slade, who is a chartered surveyor.
Yeah, so let's unpack that and let's see what the inspector has got before her by way of relevant experts on the relevant evidence, okay? No question that Mr. Mitford Slade is appropriately qualified. He's a member of the RICS, isn't he?
He is, yeah.
But you remember I did put to him breaches of the RICS guidance and the RICS professional requirements. Remember that?
Yeah, he responded to those.
Yeah, and
questions.
so we've got 3 allegations about that professionalism, and that's a matter for closing submissions, but they've been put to him. As far as the evidence on cost is concerned, he relied upon sources of evidence which include Jackson's, yes?
Mr. Mitford Slade, did you
Yeah.
say? He relied on the evidence that we provide into his cost plan.
Yeah, so
and that relied on evidence including from Jackson. So
Yeah.
there's a slight difference, but yeah.
Okay, so yeah, he relies on the applicant for all his cost information, yes?
That's what he said, yes.
Yeah, okay. And we've established the lack of independence there. What we also know is that there is a cost consultant, Mr. Bell, but he doesn't give evidence, yes?
That's correct. His
And
work is provided as part of as an appendix to my first rebuttal.
you appreciate
second.
that in not being able to cross-examine him, the inspector will of necessity need to consider what weight to give to his evidence. You'll appreciate that.
To be honest, I don't know the answer to that
Okay,
question.
all right, that's fine. That's a perfectly acceptable. It's a matter for submissions then. In terms of what's called the Jackson's cost plan, if somebody from Jackson's, I mean, it should have been a cost consultant, but we've already made that point clear, an independent cost consultant. But in its absence, we had the contractor providing the information. When the contractor provided the information, what I'm told, or what I glean from your evidence, is actually it isn't just Jackson's, because the cost evidence is your cost evidence, Quinn's cost evidence, but wasn't just informed by Jackson's. There are other parties involved. So those other parties that are involved are, you've got your own quantity surveyors, unnamed, who have contributed to the costs in the Jackson's, what's called the Jackson's cost plan, yes?
I mean,
Is it just a yes or no on
yes.
that?
My approved evidence sets out, working with the Quinn team, a number of points, and mentions previously that we have worked with other contractors. Yes.
Yeah. You see, if you
It's
called
set
an
out.
independent cost consultant, this would have been the position. The independent cost consultant would have been able to say, I take ownership of these figures. These are my figures. Mr. Simons, Mr. Young, contests those figures, and he can challenge those figures, and he can look at the evidence behind them, and that expert has to stand by those figures. Do you understand my point?
Yes.
Yeah, that's why we have experts, really. We have experts so that the evidence that they put forward in their name with their declaration is what then gets tested. And of course, that's what we've done with the evidence of Mr. Parks, isn't it? We've put forward an independent expert.
You've put forward a business case approach for...
Just focus on the question, if you can. It's an independent expert from an independent company, yes. You might, I think Mr. Goodwin suggested, oh, well, they're very close to Kent County Council, so, you know, maybe it's a bit biased. But at the end of the day...
We had no...
Just let me finish.
Yeah.
He's an independent consultant from an independent practice from who is a member of the RICS. That's what our expert is, yes?
That's your view, yes.
And that's my view. That's what he is.
Well, he said he works solely for KCC, and he works on all KCC projects. So if you'd asked us, could we appoint an independent person to look at your costs? I'm just...
Understand me?
No.
Hang
But
on,
if you'd
let's-
said that, would I have said, yeah, go to the person who works solely for you and does all of your projects? I don't think I would have said yes.
Okay.
So
what
you know,
you're saying
there's a view on independence here.
yeah, you question his independence. Yeah?
Yes, because
But he is
all
in
his
it-
cost costing is based on Grovehurst and Surrey, which are KCC delivered projects.
Okay, so he's an independent in an independent consultancy. He's not somebody who works as an employee of Kent County Council, is he?
Correct. Yes.
Yeah. Okay. He is a member of the RICS. Yes.
Told us so. Yes.
Yeah. So Mr. Simons has been able to cross-examine him. Yes.
He has. Yeah.
Yeah, and things like, you know, what is the source of your evidence are all questions that could be put to him, yes?
They were. Yes.
Yeah, so for example, Mr. Simon's case this is the barrister's submission, presumably on instruction. There's no rationalisation for any of your scope analysis or your contingencies. Do you remember that?
Can't remember that exact question, but okay.
Yeah, but, you know, he explains that the scope analysis wasn't 44%. Do you remember that?
Scope analysis 44%. I can't remember that exact
There was
point.
a the suggestion of optimism bias at 44%. Do you remember that?
Yes, sorry. So he said that he explained that he didn't use a 44% optimism bias. He used 23% optimism bias, and he explained why, but also that he didn't think it was appropriate, but he'd been asked to put it in.
Yeah, he said National Highways had asked to use the phrase optimism bias.
He did, yes.
Then explained that he didn't think that was appropriate.
He did, yeah.
He then referred to the 23%, but in the cost plan, the final cost plan of the figures, The actual figure is 10%. Are you aware of that?
That's the scope risk allowance.
Yeah.
Yeah,
So
because
scope
the inspector asked in the break to come up with what a scope risk allowance was, and there was no answer because it's a new concept.
The scope risk allowance was the scope of the road, and if there was any doubt about that, because it was suggested to Mr. Birchill by my learned friend, oh, there was no explanation of that. Mr. Birchill said no, he did explain it, and for the avoidance of doubt, it's the scope of the road not being defined, and because it's not defined, because it's a concept, because it's just illustrative drawings, because there's no detail, the scope of the project is uncertain. So they've added 10%. All of that was explained.
I think I disagree on that point, but okay.
Well, Mr. Birchall explained that.
I
The
disagree with his answer
suggestion
then.
that somehow Mr. Parks hadn't explained it when, you know, he had. But look, advocates saying there's no rationalisation doesn't mean there's no rationalisation. You have to look at the evidence.
If it's going to be put like this, sorry to interrupt, I asked Mr. Parks if there was a specific rationale. It was a question, and he confirmed in his evidence that there was not a specific rationale, but he'd based it on his feel and his experience of other projects. So the idea, and I understand, I suppose this is a response to some of the things in my note from this morning. It's with respect not a fair response, because my question was supported with live evidence from the person who I was asking it about, and he confirmed that there isn't or wasn't any specific rationale, but he thought that it was a matter of his experience, as he said, and his feel from other Kent-delivered projects in the area.
Yes, and it's also been made very clear that it's about the nature of the road and the scope of the road being undefined at this stage. And for the avoidance of doubt, Mr. Birchill, who also talked about the contingency and the scope allowance, explained that. Okay, he explained very clearly it's about the nature of the project as it sits now and the fact that it's undefined, because it is right. And you've made
it isn't undefined, though, is it?
Forgive me, it isn't. Well, okay, let's have a look at your proof.
So, for example, scope risk allowance, from my understanding with speaking to Mr. Wild, is where a scope of an entire project could change. So that's where the scope is in, you know, we're building this road, we might change what we're building. So that's something that's used in business case. This isn't in my evidence, but this is just through discussions.
We are going to talk about the business case this afternoon and your arguments about that. But just go to your proof, your main proof at 5.2.
Yeah.
First one, please.
Yes. Yes.
The applications, we looked at these yesterday, being outlined in nature with all matters reserved, have not sought to provide a detailed cost for the delivery of 5A, Junction 5A, SSRR and SNRR. This is because there would have been no benefit to formally costing a preliminary indicative design that's not been subject to detailed design. So there is no detailed design. It is only indicative. It is only preliminary. And in the words of Mr. Wild, it is just a concept, yes?
Yeah, or high level, yes.
The scope, therefore, is broad, yes?
Scope could only really go downwards, but yes.
Yeah, the scope, well, we're going to come on to that. This is your argument about, well, let's deal with it now, actually.
Well, only on the basis of Mr. Wild's evidence of saying that this is we tested a worst case road for ES purposes.
Let's have a look at...
That's not been challenged.
It's not been challenged.
Let's have a look at Mr. Wild's evidence,
okay.
What he says and what that relates to. So, in your second rebuttal...
Yes.
We've got Mr. Wild's evidence where he tells us what it is.
Do I need to get Mr. Wild?
Can I have the references, please?
Get evidence. What? Could someone? I haven't got it here. So could someone give me the CD number, please?
Actually, it's the technical. I think we're still dealing with it. I think it comes after the Jackson's notes.
Oh,
it's the first one.
It's the first appendices, and it's a note dated June 2025.
It's Appendix 3, CD 13.14.2C, Mum.
oh yes. Hang on a minute, just to set them, please. Just a minute. Right. Yep.
You go to page 3. There's a if you go to page 3, there's a heading, Concept, Design, Purpose. Do you have that?
Yeah, 3.2.
And 3.2.2, as the name suggests, the design package is concept in nature and has not been prepared for determination within these planning applications, which is correct, yes?
Yep, I'm reading that sentence, yes.
The drawing remains, just that's your understanding, I should say.
Yes, yeah.
The drawings remain illustrative in nature as a result, yes?
Yes.
Okay. Drawings of this detail are not necessarily required for an outline-only planning application determination, but were developed and included in the package of the following reasons: to demonstrate deliverability of the proposed infrastructure. Do you see that?
Yes.
Noting the reliance is placed on it in the transport assessment.
Mm-hmm.
And then 2, to inform the environmental impact assessment of the proposals, including but not limited to the overall scale and massing of the infrastructure for evaluation in landscape terms. Do you see that?
Yes.
In this regard, and as is appropriate for environmental impact assessments, so that's the scale and massing, the proposals have remained worst case, discussed further below. This applies most notably to the areas of highway beyond that associated with the motorway junction, so the 2 relief roads, yes?
Yes, and Mr. Wild gave evidence on that as well, yes.
And 3.2.3, whilst the concept drawings have been used for cost estimates, it's important that in doing so, regard was given to the above. So the regard to the given to the above is that in the concept of the scale and massing of the infrastructure and for the environmental impact assessment, the worst case scenario was considered, yes?
Yes.
Yeah. So what he has to do is provide details of a road which he doesn't think will be any larger or longer or more extensive, yes?
Yeah, and for the earthworks as well, yes.
Yeah. So
within that corridor.
Yeah, so the position is none of it has actually been designed in detail.
It's been actually designed to quite a high level, but it's not for approval in detail. But yes.
Yeah. Well, let's have a look at special structures then, where he talks about special structures on page 5.
Yep.
And he says the concept design, sorry, madam, 3.5.1.
Yes, I know as well, yep.
Just wait a minute. The concept design makes an assumption that the road will be lifted out of the current overland flow route. And what he means by that is the water, yes?
Yeah, to the east of Junction D.
East of
Highsted
Junction
Road,
D.
yes.
Clearing the entire extent of the flow area shown on EA indicative surface water flood mapping, yes?
Yes, yep.
Okay. The solution was to be subject to a full preliminary design that was to follow at determination stage. Then he says, 3.5.2, this concept design, that's for the bridge, has not been based on any hydraulic modelling to ascertain the nature of the flow and the storage in this location. So
yes, I've discussed this at length with Mr. Wild, yes.
There's nothing in relation to hydraulic modelling backing this up. And then 3.5.3 says...
So no, it's not quite that, but essentially it's utilising the high level EA modelling, which is a worst case scenario, to back it up. So,
yes.
So yeah. Yes.
So what he's saying is, when you look at the surface water flood mapping, we've gone to the EA documentation, yes, which is, as you rightly observe, is high level.
Yes.
Yeah.
And I think there's
It's just worth reading the full paragraph, though, because he's explaining what he's...
Okay, the whole of 3.5.2.
I don't quite know what... he's explaining exactly what he's saying at 3.5.2, but it's not perhaps clear if one reads only the first clause of it.
Okay, that's perfectly fair, such that to design a simply assumes, I'm at 3.5.2, it will be protected in its entirety. In the concept design, this gives rise to a structure comparable or even onerous in cost to the motorway or railway bridge. In the latter case, it's practical to assume that there is no VE, value engineering, is that right? Exercise will eliminate the need for the bridge structures. This is not the case where the road crossed the overland path. What happens is, if you've got a flooding issue, and we've all got a flooding issue right now, and the EA map is showing there's a problem, what you can do is further hydraulic modelling to identify the actual real-world extent on the ground, yes?
Yes, you can model the flow path, but also look at storage as well.
Yeah.
At the moment, the EA just combines flow paths and storage, so it's generally a very large area. And this is a fairly standard procedure through planning.
Yeah, and something that everybody is enduring at the moment because everybody's having to do a sequential test, even for a puddle. But
Yeah.
3.5.3, in practice, with the benefit of hydraulic modelling, it's likely that a considerably more rationalised solution, i.e. more reduced solution, should be secured that would use culverting, yes?
Yes, that's what it says. Yeah.
Now, a couple of things out of this. First of all, there is a culverted solution then suggested, which is £19 million cheaper, yes?
That came out of discussions with ADCC, yes, because when we suggested we could provide a culverted solution or a smaller bridging solution or anything like that, they said, well, we need something to cost.
Yeah.
So we produced the drawing, we costed it, and we shared it.
They didn't suggest the culverts. You suggested the culverts. They said if you're going to produce something, we need to see what it is. You produced a sketch plan, as I understand it, of the culverts. But the point is here,
It's attached.
what he's saying is, I don't have the hydraulic modelling. You need the hydraulic modelling to ascertain the nature of the flow. That's 3.5.2. We don't have that, but one option might be, he says, a considerably more rationalised solution. But without the hydraulic modelling, we don't know whether that rationalised solution will be acceptable, do we?
So two things. Firstly, the surface water drainage strategy and all that information.
Just answer my question first.
So
without the hydraulic modelling, we don't
rationalised-
need. Just listen to the question.
Yeah.
If without the hydraulic modelling, we don't know whether the culverted solution would be acceptable, do we?
No, because the culverted solution that's been provided is not based on surface water modelling. It's a like-for-like solution that's been provided. A rationalised solution is something different, which would be a far smaller structure. So what we've provided is ADCC costed a structure that cost more than a motorway junction.
That's the 30 million.
The 30 million,
Yeah.
which also then massively added to the prelim costs and the contingencies.
Just to be clear, that was in your plans. Your plans.
It's written as indicative, though, subject to detailed design.
But to
No
be
one,
fair,
no one
please,
asked you to
Mr.
cost
Gearing, just be fair. You produced some drawing, or Mr. Wilde produced some drawings which showed a bridge. Yes or no?
He did, because it was to show the worst case. Yes.
Yeah, and so he showed a bridge, and that was costed, and
Yes.
that bridge was a significant expanse because it went over all these overland flow routes. Yes.
It's a 50-metre long bridge. Yes.
Yeah, and that was the suggested solution. When you've come back to the detail,
It wasn't a suggested solution.
The
It was
bridge
it was an illustrative solution.
illustrative solution. Okay, yeah, because you're right. There's no actual detail
Yeah.
to follow. But the point is, when you've then looked at it, you suggested a culverted solution. Yes.
We suggested that if we were going to, before we did any updated flow path surface model modelling that we do for the detailed design, an alternative for this phase of costing, which wouldn't need us to do that work, would be to show what a culverted solution would cost that doesn't take into account any further modelling.
Yeah. So.
And then we provided that.
I'm sorry.
And then we provided that as an appendix, and we costed it.
Yeah, so we then got a culverted solution. Okay, there's no hydraulic modelling to back that up, and the EA.
It's not needed because it does the same thing. It's exactly the same.
No, you haven't got any hydraulic modelling to suggest anything smaller.
We haven't suggested anything smaller,
No,
but yes.
you've suggested instead of the bridge that was originally, or the bridge concept, we've got a series of culverts. How many individual culverts is it?
I don't want to count them, but it's a lot.
Yeah, it's a lot. Individual next to each other.
They're stacked horizontally and then vertically through the.
Yeah,
the
and have you
illustrative
presented
drawings.
that? Have you presented that to the Environment Agency?
It's a surface water flow path, so it's nothing to do with the Environment Agency.
Okay, so in terms of that diagram,
So it's the
to
lead
be
local
fair,
flood authority.
Kent County Council were presented with that. Is that right?
Mr. Dygan shared it with them, yes.
Yeah,
Very recently.
And they've said that's fine.
Yes.
Yeah. Okay. So what we have is a situation where there's a concept, and the concept is indicative, and as far as that is concerned, you present that and make clear it's a worst case scenario for EA reasons, but for all reasons. You know, this is as bad as it gets. Yes.
Yes.
Yeah. And the reason for that is there are multifaceted reasons, or there's a number of different reasons why you've done it, but the outcome of which is to say look, the road won't be any more onerous in its design or any more significant in its design than this, yes?
Yes, so to allow the inspector to assess for the ES purposes.
Yeah,
Yeah.
okay, all right, that's helpful. Now, just go back then to, we were trying to negotiate our way or navigate our way through your appendices
Yes.
on the first document, and after the Jackson's document, there's an appendix which is Mr. Goodwin, and after Mr. Goodwin, we have Mr. Wild. Is that right?
The one we were just in, yeah, Mr.
Yeah.
Wild, yes.
And those are the documents that make up your cost, effectively your evidence on rebuttal on costs, yes?
The first rebuttal, yes.
Yeah, okay,
Yes.
all right. And I put to you about the experts. We
You
then
have, yeah.
get a second rebuttal.
Time for a break
That
or
would
not?
be a great time for a break.
Time flies.
It does. We need a coffee, I think. So good. All right. So it is 10 to 11, I think. Isn't it? 10 to 11. So we will have a break till 10 past. Thank you very much. 10 past 11. So it's time for the inquiry to resume. Thank you very much. Mr Young, if you'd like to carry on, please.
So, just in terms of the second appendices, then, what we have is obviously the contents of the
Second rebuttal, you mean?
second rebuttal. We have the contents of your text. You're responding mostly to Mr. Parks in this one, and then what we have is a second version of Mr. Bell's quantum cost report. Is that right?
Yes, so we have the second cost rebuttal, 1st of July, quantum cost report update, and then part 1, 2 and 3, which are the budget sections we've gone through before. Appendix 2, quantum report updated side by side. Appendix 3, JC projects.
I'm sorry, just to take it. Sorry, I just want to be clear about Mr. Bell's report. So let's just take it stage by stage.
Yes, sorry.
Mr. Bell, because the figures are changed, Mr. Bell produced a further statement. It's different from the first statement. Is that right, or is it?
It's an update report. Yeah,
an update report.
Version,
okay,
yes.
yeah. Then we get Appendix 1, which is the Jackson's cost plan, but this time it's updated against revision B.
Yes, and in response to Mr. Parks's proof.
Okay, what it does.
Broken down into 3 parts.
What it then does is, obviously, if we have a look at the assumptions section, so if you get past the actual text, which is page 11.
Yes.
Sorry, page 13, and then you get assumptions. In this version, it's certainly very clear when printed out. You've got the assumptions and clarifications on the left-hand side, which are the text from the Mr. Parks's version, yes?
Yeah, 1.0 general information, assumptions and clarifications, yes.
And then comment is agreed or disagreed, but you can see that that's the addition that Mr. Bell has added.
Mr. Bell and JCE, yes.
And JCE, okay, all right. So assume the scheme, let's look at the first one. Assume the scheme will be delivered by the developer utilising a Tier 1 contractor for all works. Mm-hmm. That's the assumption they've made, yes?
Yes, JCE.
But the person informing that is Jackson's, yes?
Jackson's and Mr. Bell, yes.
Yeah, and we made clear our point. Jackson's are not a Tier 1. So what you've got is, you've got a lower tier, a Tier 2 company, providing the costs, but what is being claimed by Mr. Bell is they're a Tier 1 company. That's what's happened here, isn't it?
No, I don't think anyone said they're a Tier 2 contractor, because a Tier 2 contractor is a subcontractor. I think there was a discussion at length about a main contractor. Mr. Goodwin said Easy is a Tier 1.5 or a small Tier 1 contractor. We don't agree that they're a Tier 2 contractor. But we agree with Mr. Parks that they don't meet his definition with the large turnover of 500 million.
Yeah, because he's made clear the costs are more expensive in those type of firms, and there's reasons for that. Just let's explore that then a little bit, because the position with Jackson's is we've got major road infrastructure projects, strategic road infrastructure projects, and Jackson's have, I think we've agreed, never designed or built a motorway junction.
Not that I'm aware of. They are currently building for Kent a major junction on the SRN, yes.
Yeah, so the SRN bridge, right, is, where's that?
Grovehurst.
Yeah.
The A249 is essentially the strategic road network, though it's not
Okay,
motorway.
so you're drawing a parallel between the two. They're saying, look, they're doing a,
It's a
they're
big,
doing
big
a
project.
junction.
I think everyone's agreed it's a big project.
Yeah, and so you're drawing a comparison with the type of work they're doing there with the type of work that's proposed for the motorway junction.
Not the exact type of work, but the scale and it's a big project.
Yeah, so the scale and the nature, yeah.
Yeah, it's work on the
Okay.
SRN. This
And-
involves bridging the SRN.
And other similarities would
It's a dual
include...
carriageway. They're both dual carriageway roads, etc., etc.
Yeah, I mean, you're running ahead of me, but that's fine. They're both dual carriageway roads. They're both active roads, yes?
The M2 is an active road and the A249 is an active road. Yes,
So,
but the growth
so that's a yes.
the
They're
growth
active.
has-
Just focus on the
still-
question. Yes, they're active roads.
Yes, they're active roads, but the works is very different. But yes.
Yeah, except the M2 is obviously a trunk road, a national highway, whereas obviously the
249.
249 is not a trunk road, is it?
I don't think there are trunk roads anymore.
I don't know if that definition is right or not.
Okay, a
Sorry.
national road which is under the control of national highways.
I might have to look that up. Yeah, it is under the control of national highways.
Yeah.
Yes, they're both. Yeah,
But they're
Okay.
not called trunk roads, are they anymore? Oh, they are called trunk roads.
I think the point I think is that the A249 and the M2 essentially are for the same thing.
Okay, they're the same thing, all right?
Yeah.
So the same thing, and they're both strategic roads. We might have called them trunk roads in the past. They both involve a bridge.
Yes,
Over-
so a second bridge for it's the Grovehurst works are modifications involve a second bridge being provided to essentially make a gyratory system over the A249.
Yeah, and involves obviously work above the carriageway because it's a bridge.
Yes.
Yeah. Good. Okay. And what you're saying is, basically the same sort of project.
Different because we've made the case that we can provide a junction because of the nature of the junction we're providing, which is a specific design. It can be largely delivered offline, but yes, they both involve connecting. That and the Grovehurst scheme
I
also
suppose
involves widening the.
it's similar type
A249.
projects. Is that the right sort of phrase?
Not an engineer, as you know, but they're both large-scale projects.
Yeah.
Yeah, and the fact that JC are doing that project for Kent, have been appointed by Kent on the national, on the SRN, suggests that they are perfectly suitable to do a similar project on the M2.
Okay. A similar project. So similar large-scale projects.
Yeah.
Yeah. Okay. All right.
There's no evidence before the inquiry that they wouldn't be.
No. So let me just help you with this. When it came to the costings that were provided by Mr. Parks, he looked at two particular projects, one of which was Grovehurst, yes,
Yes, he said that.
which you've just agreed is a similar large-scale project. So what he did was look at a similar large-scale project to inform his costings, yes?
I said it was a similar scale project. But we have discussed at length the problems that have occurred with Grovehurst to do with things that may not exist for our project.
Yeah,
For
similar.
example, utilities, the fact that it's working on an existing road, that there's huge levels of traffic management. We've all gone through this.
Yeah, but I'm sure the inspector can take a judgment in light of you agreeing it's a similar large project, whether that's a useful comparator that was used by my witness. Which useful comparator? And of course, what he says is it's his judgment. He has access to all the data in relation to all Kent's projects. His firm does work for house builders. So, he's not valuing or putting a value on or putting a cost on the housing. But look, that's the database he's had. Now, Jackson's, which were the parallel projects that they drew as their comparisons?
I don't have that level of detail to say
No.
all the projects. They have certainly referred to when I've had discussions with them, they've discussed the Grovehurst project they've worked on. They've also provided 3 appendices of other large-scale projects.
Well, that's interesting. So they used Grovehurst, obviously not some of the delays that caused the road to. They used Grovehurst as one of their examples.
They were certainly able to understand.
I think you
perhaps-
just said that, didn't you? They
Yeah,
used
they would have done,
Grovehurst.
of course,
Yeah, good.
because
That's
it's
fine.
a live active project of theirs.
Yeah,
but
good.
they may have a very different view on why the cost would be different from Grovehurst, and that would put them in a good place to know that.
Yeah. Now, the thing about the Grovehurst road, not over the motorway, is that the Grovehurst road is not as long as the new motorway bridge, is it?
I don't know the length.
Okay.
That's not my area of expertise.
And the width is not the same.
No, I don't think there's any particular dispute over the structure cost of the.
I'm not asking about
element.
disputes about the dispute. I'm just saying about the nature of the
No, but-
project. I think it's a bigger bridge. Yeah.
If we look,
What is
should we-
Grovehurst?
should we want-
No,
should
no.
we look at the
The
side-by-side
motorway.
costs?
Sorry,
That'd be
madam. The motorway junction, the new motorway junction, is a bridge which I think is wider. And I'll just need to check the length.
This isn't something that's been raised before.
No,
And I don't
I-
think there's been any arguments over the
That's
Jackson
not the
structure
purpose.
costs that are in their sums.
That's not the
the
purpose of the
bridge?
question. The question was just
Okay.
to look at the comparison. I'm perfectly content with the answers that you've provided up to now, but what I just want to be clear about is whether actually the road is, bigger. For example, the bridge at Grovehurst is 44 metres long. The M2 overbridge, I think, is 44 metres long, so similar length.
Okay.
Okay. Width, I think, is different because the M2 overbridge is 30 metres wide, and at Grovehurst is narrow. It's 19. But the point is this. Okay. You've been keen to emphasise Jackson's role in that project. Jacksons are involved in that project. My client has gone to an independent cost consultant who has looked at a project, and that project is one that Jacksons are involved in, or Jacksons are doing, and it's a start-to-finish project. So Jacksons are start-to-finish contractors, yes?
The main contractor.
Yeah,
Yes.
okay, and there'll be subcontractors as well, yeah.
Yes, I understand so.
The costs plan from Kent assumes a single tier 1 contractor for the northern, the southern, and the motorway junction, doesn't it?
That's what it says, yes.
Yeah. Jacksons have never done anything on that scale before, have they?
All three elements or broken
Yeah, all
down?
three elements, yeah.
I don't think they've ever had a single contract for all three elements, no,
No.
of that scale, but we've also never said they would.
Of that scale, yeah, good. Okay, and so what we're into is uncharted territory with them in terms of something that scale, but it's
Well,
that's what you just said. You
no, I
just
said-
accepted. No.
I said-
Let me put that to you. It is uncharted. We're in uncharted territory. Jackson's doing a project that scale.
if
But I thought we were told by Mr. Gearing, I think, in evidence in chief, that there wouldn't necessarily be just one contractor working on the whole thing, that it might be two or three or
But
even
that's the
more.
difficulty, madam, if I may say so. Can I just take you back to the document we looked at a moment ago?
Do go to the document, obviously, but just to say at some point that he was put this thing about uncharted territory or whatever. So just to say
Oh, right.
at some point, just to answer that. But obviously, do go
Okay.
to that document by all means.
If we go to the document we were looking at about the what's called the Jackson's cost plan, and we look at the assumptions and clarifications, do you have that? Yeah, and then the commentary is obviously from Mr. Bell or Mr. Jackson's. Assume the scheme will be delivered by the developer utilising a tier 1 contractor for all works, okay? And that was agreed, see that? And the project is the whole lot, so for all the works.
Well, it doesn't say necessarily one, it's an A tier 1 contractor. Oh, sorry.
For,
A tier 1 contractor, it doesn't say it'd be the same one, does it? Or I
well,
don't know.
a contractor would be a singular body, and
Okay.
it's for all works, so
I
all
don't
the
think
works.
we agree that point.
Okay, well, then I
Anyway.
need to know your case,
That's what I
but let me
heard
just
him
put the...
say,
Well, you've heard my. It's in my.
No,
it's been
just,
both
I've got to
my-
put the point that
Yeah,
my learned
so-
friend raised. So I would say that, I need to put this clearly to you then.
Yes.
Jackson's doing a project, if it was them all on their own of this scale, would be uncharted territory for them.
I think my answer to that is no, because they build junctions, they build roads, they build bridges.
Okay, well, we're at odds there then about what their experience. But
So it's not
What's-
uncharted. Uncharted territory would be suggesting someone who's never done those things by
What's
that
the- what-
definition.
what's the biggest project that they've done, start to finish?
I don't know the biggest project, but the Grovehurst example is a £38 million project. The
Yeah.
other examples in our appendices are large areas of Link Road, of Relief Road. So, as I think Mr. Goodwin said, building roads are building roads. You know, if you're building a 4-kilometre road or a 5-kilometre road, essentially you're doing the same job.
Yeah, but a £38 million project,
Yep.
which is Grovehurst, which Kent County Council have employed Jacksons on,
Yes.
is wholly different to a project of 366 million, or on your figures, 213 million.
But that-
It's a
that
whole,
wouldn't be
just
the
let me
cost-
finish. It's a wholly different scale project, isn't it?
That's not the contractor contract, though, is it? No one's suggesting that you'll be paying any contractor 366 million.
No, but the scale of the project. You know,
But we- as-
Gravehurst is not the scale of all of these works, is it?
No, Gravehurst is a comparable scale to building a junction. It's not, and equally they have experience of building roads. So if I was to take your line that we were appointing a single contractor on a single contract for, and I'm not going to replicate the number because that includes all the commuted sums, professional fees, everything else, that would be what was your word? Uncharted territory, I think.
Yeah.
Something like that. But that's not, we haven't suggested we're doing that. So
Okay.
You're putting something to me that we're not suggesting
Yeah,
we're doing and asking for an answer.
Okay, I understand your point, because your point is, well, there'll be a number of contractors and Jacksons might get
There may be a number of
might get part of the job, but just take up, if you will, please, Mr. Park's cost plan. So that's his appendix.
This is a revision B we're talking about, isn't it?
Yep, and page 2 is the general information, assumptions and clarification.
Is this 39.7.2, appendix to Mr. Parks?
Yes, it is.
Thank you. So do you have a page number?
I've got page 2 on the document itself, but if it's the PDF, I saw it's several documents on.
Yes.
Okay.
Assumptions and clarifications?
Yeah, and then what he's put is assume the scheme will be delivered by the developer
Yes.
utilising a tier 1 contractor for all works. Okay,
That's the assumption Mr. Parks has made.
yeah,
Yeah.
which
The
is
exercise
agreed.
completed for KCC.
Which is agreed by Jackson's in Jackson's cost plan.
Well, under our definition of tier 1 contractor, we will use it. I suppose if we're going into semantics, it should say utilising one or more, or a or other, but I don't think that is explicitly saying that you would only ever have one contractor doing the whole thing.
Okay, so
And also, obviously, these were discussions that are ongoing. I don't think Mr. Parks asked us, are we appointing JCE to do the whole job? I don't think that's ever been suggested in any of our evidence or his evidence.
So what is your case then? What is the case on who will, because there are cost implications of having more than one contractor. So what is your case
Not
on
necessarily.
the contractors? Well, we've explained why, Mr. Parks explained why. I just want to know your case. What is your case on the number of contractors?
So we will obviously need to tender for this project in the future when the road's designed, and you know, there's all sorts of decisions to be made on that in the future.
Yeah.
And that will determine the approach taken, whether we have a single contractor or you may have an amalgamation. I think we heard from Mr. Goodwin, you often have contractors working together now on projects, or we may split it into different parts. I mean, clearly the Northern Relief Road is not going to come forward at the same time, so it's not going to be a single contract for that. So you would definitely split the Northern Relief Road from the Southern Relief Road and Junction 5A, and that's just logical. I
Yeah,
mean,
because
it's
you
an
wouldn't have the
assumption anyone would
same
make.
you wouldn't have the same compound for those.
No,
It'd
exactly.
be a completely different location.
I'm not going to. I'm not here to talk about compounds, but you know, those decisions clearly you wouldn't have the same compound for works each side of the M2, would you?
No. So the position is that's yet to be decided about
Very
how
much
many
so.
contractors
Yeah,
are be involved in subcontract and so on. Okay, all right. Next, then, please. If you look down at the assumptions, this is in your.
These are your assumptions.
Yeah, but it's whether you've agreed them. That's the thing. So if you have a look at the fourth one, all rates and allowances have been calculated based on tender returns for major civil works in Kent. Yes.
Okay. Yeah.
And that was agreed. Yeah. So major civil returns would be the return information on major civil engineering projects.
So I think that was Jackson's agreeing that the costs that ADCC used are based on that. So essentially, we're agreeing what ADCC have told us. Yes.
Yeah. Okay. That's not your account.
My
yeah.
account.
Yeah, because you're saying, although it says agreed, it's not agreed. We're just agreeing that's what Jackson's have done.
No, Jackson agreeing what ADCC,
ADC have done.
Yeah.
Yeah, okay, so when we read agreed, it doesn't mean you agree with any of it. You just agree that's what they've said. But then why would there be comments if this isn't setting out clearly what you've agreed?
So where we've agreed, this is what, reading through it, so you have agreed, as in agree with the assumptions that are in the ADCC work, and where they're not agreed, for example, paragraph 22, allowed for a TSCO for works on the M2, however we assume this will be not utilised by the developer for the remaining works. We've said need to add item in, so that's obviously change. And then there's elements that are not agreed.
So you said a moment ago, where it says agreed, we've agreed the assumption. So the assumption is all rates and allowances have been calculated based on tender returns for major civil works in Kent. That assumption is agreed.
We've agreed your cost plan uses that assumption.
Yeah. So, yeah, I struggle to see that where
What are you?
where your forgive me, where your agreement is and disagreement is. The reason I ask this is because Jacksons are not the only contributors to the Jacksons cost plan, are they?
No, we've already discussed at length that Mr. Wild's been involved in discussions with Jacksons. Our technical director, who's a civil engineer, has also been in discussions. We've got the in-house team, which involves QSs, chartered surveyors. Mr. Goodwin was involved in some discussions as well. He's a QS, he's a civil engineer as well. A wide-ranging team, yes.
So Mr. Wild is obviously the highway witness, the highway expert, and I don't trespass on that. But as far as
also
the value,
the designer for the
design. Yeah, you're absolutely right. The design of the road. Yeah. So he knows what the road is and knows what he's doing in terms of what that looks like and so on.
Yes.
But just help me with this, please. In terms of the people contributing, it would be wrong to say it's a Jackson's cost plan because actually it's a cost plan. I mean, it's not even a cost plan, but leaving that aside. It's a document that has been the subject of contributions from Jackson's, first of all.
Yes.
From Quinn.
So the Jackson's costs have had contributions from Quinn, yes.
Yeah. And then Mr. Bell, he's just...
Yeah, Mr. Bell, because he's looked at some of the... he's set out where he's looked at some of the costs and he's provided commentary on that, yes.
Now with Quinn...
Yes.
we
and Mr. Wild.
And Mr. Wild, yeah.
Yep.
With Quinn, what we've got is a series of people who have provided figures which may or may not be different from Jackson's figures.
So the Quinn team didn't provide their own figures, but they've looked at the Jackson's figures and they've looked at Brahini's figures and they looked at the earlier figures from Volker's and input into those throughout a process. It was a back and forth. So
the contributing factors here aren't just Jackson's, even though it's called Jackson's. Volker's have contributed to this as well.
You need to think of the timeline, I think.
Which is just help me with the question, if that's okay. My question was, is Volker's contributing to the Jackson's cost plan?
No.
No, okay. Is Brahini contributing to the Jackson's cost plan?
No.
No. Quinn, you did say, is contributing to the Jackson's cost plan, and you said that a moment ago to Mr. Bell and Mr. Wild.
The discussions with Jackson's, yes.
Yeah, so what the inspector's got is not only not a cost consultant, and not only does she not have Mr. Bell, and you don't have a member of the RICS, and I think he's like an associate member, a chartered. I don't think he's chartered actually. Okay. I think he's a quantity surveyor, but he's not chartered.
He's associate.
Yeah. So, being chartered is
We're making a point about that.
Yeah, but we're just trying to understand the nature of the expert, albeit he isn't here. And so, the components of this are that this is a sort of amalgamation of lots of different people's work, and those people, Jackson's, Mr. Bell, and the other people from Quinn, so the ones who are quantity surveyors, none of whom put their name to this, Mr. Bell put his name to it, but none of whom appear as witnesses.
Correct, yes. So we had a wide, as set out in my evidence in chief and my proofs, the Quinn team has significant experience. I think that's set out, and that's wide-ranging with different technical disciplines, and that the purpose of this is to input numbers into the FVA.
So the cost document...
So we're making sure that the figures in the FVA, in our view, are robust and appropriate.
Yeah. So the cost document provided by the applicant can be characterised, I hope, in this way. It is the amalgamation of work from Jackson's, Quinn and Mr. Bell on the costs, yes?
Yes, so Jackson's produced. Yes, yes.
Yeah,
let's make
it's
it-
an amalgamation. Okay, all right.
Scrutiny in particular, I think.
Gosh, that gave me a fright. Sorry, Mr. Young.
Let's go, don't worry. And, okay, an amalgamation. The only person who presents evidence on it is yourself.
Evidence in chief, yes, but there's evidence before the inquiry in
Well,
writing.
Or, yeah, okay, oral evidence.
Yeah.
And you are not independent. You are from the applicant company.
I am, yes.
Yeah. Okay. And in terms of knowing what each person did or the input, Jackson's are a standalone business. They're a standalone contractor. Is that right?
Yes.
And they haven't worked with Quinn before.
We haven't done any projects with them, no.
No. So you might say, well, they're an independent contractor. They're independent of you. And
entirely, yes.
they're in a different firm, yeah. But I don't know, do I, when I look at these figures, what influence Quinn have had on those, because it is an amalgamation, as you've agreed. Quinn have been involved in it. It is an amalgamation, and Quinn have been involved in it, haven't they?
I said we scrutinised the figures, and if we go back to my earlier example, I think from yesterday, for example, where we felt the figures were too low, for example, on the junction 5A, which were the costs that you referred me to, we knew they were too low because we'd already done some detailed work looking at costs with other consultants, and so we were in the process of scrutinising and working on those costs when the ADC cost plan was received.
So Quinn have inputted into the figures, and where they disagree with Jackson's, they've substituted it with a Quinn figure.
No.
No? So in that example you gave, Quinn's involvement didn't affect the number.
It was through the process with Mr. Parks, actually. We were re-looking at some of their assumptions. You can see there's some figures that said excluded, for example. More information was provided by Mr. Wild, discussions with Mr. Wild. All of that information to do with the geotech work, everything like that, has gone to Jackson's. They had all of that in March. And that meant they revised their costs. So it wasn't a position I think you're trying to suggest where we just crossed out their number and put our own number in or something ridiculous like that.
Yeah, okay. So Quinn's involvement is in a process whereby Jackson's have changed some of their numbers in light of the discussion with Mr. Parks.
Yes,
yeah.
And also in discussions with us.
Okay, and in discussions with you. So those are the two reasons why they would change.
And they've only gone up, but yes.
Yeah, they would change. Yeah, and this is the confidence about Jackson's figures. So we looked at the ducts, didn't we? The drainage and the ducts, and it was over £1,000% increase. And
yes, between the preliminary costs on the left and then the middle version, and then there was a final version of the costs. Yeah. There was an ongoing process of scrutiny.
Why were they so far out, please, initially? Why did they think so little drainage was required?
I don't know the answer because I wasn't there, but my civil engineer and Mr. Wild was at meetings with them to, I'm sure, discuss that point, and I think it was discussed with Mr. Parks as well.
Okay.
But of course, those figures weren't in our FEA.
Okay. When we have a look at the actual content of the second Jackson's cost plan, because it continues to be referred as that by Mr. Bell, we see a series of numbers.
Hang on, where are you going now?
Series
What are we looking at?
Series 500. Sorry. So you have to go past all the assumptions.
We've said 3714A2. Just want to double check I'm not on the wrong version.
I've got this. I've got the cost plan, which is your appendix.
Side by side thing.
Not the side by side, madam.
I think it's this spreadsheet, but I just want to...
In this subsequent document, we get to Mr. Bell's appendices. And Mr. Bell's appendices, it's set out at paragraph 5 this time, begins with the Jackson cost plan.
Transfer rebuttal. Sorry, give me a moment. This is the further cost rebuttal appendix to Mr. Bell.
Yes.
Thank you.
Hold on, so which number is this?
So appendix 1 to Mr. Bell's document, which is the second document, which is known as 3714 4A1.
4A1, the quantum cost report, that's his report. That's the one you want me to open.
Yeah. I'm just trying to make sure you asked me where have we got to, and I think we're still in the Jackson's cost plan.
Okay.
And we'd looked at the assumptions, and then when you get beyond the assumptions,
So we're in part 1, the Excel spreadsheet.
yeah.
I'm
And the
sorry, I'm in what you said,
Yeah,
3714 4A1.
yeah. Have you got the assumptions
which
that
is
we were
Mr.
looking
Bell.
at? Yeah. Mr. Bell's Appendix 1 is the Jackson's cost plan, but this is the second version of the Jackson's cost plan.
So, assumptions and clarifications.
And if you go through that, which I've got it in hard copy, it's all in landscape format.
That's 4A2, not 1.
I've no doubt that you're right. I haven't
Well,
got
am
tabs
I?
in this bit. You obviously have. And then when you go forward beyond the assumptions,
Yep.
you get to the summary sheet.
Series 500 drainage and service ducts. Is that
Yes, yeah. And before that is a separate sheet
where? Yep.
which says Section 1 summary.
Yep.
Do you have that?
Right,
Yeah.
yep.
Got that.
Okay. And this is said to be part of the Jackson's cost plan. That's right, isn't it?
That's how Mr. Bell described it, yes?
Yeah. But what we can see is we've got basically it's a comparison chart rather than a cost plan. It's a comparison chart with Jackson's numbers, Dadswell's numbers, difference, rationalisation,
I mean,
revision 2.
it contains exactly the same information as the Dadswell cost plan.
Yeah.
So it's just presented in a spreadsheet.
Yeah. Okay. And then when we go forward, as the inspector says, to the drainage section.
Series 500?
Yeah.
Yep. Drainage and service ducts. So we've got a...
What are these series numbers?
I think it's the categories like preliminaries,
Oh, I
and then
see.
it's the different elements of the construction broken down into different costs,
Oh, I
essentially.
see.
I presume it's because they could be different packages for subcontractors and things like that.
But is it a standard thing that Series 500 is always drainage, for example? Mr. Parks, looking
certainly-
at you because.
yeah.
I think no one suggested otherwise to me.
Okay, right.
It was
Anyway,
everyone who was talking about it was using the same terminology.
okay, thank you.
It's in the standard method of measurement for
Oh, is it?
highway
Right.
works.
Okay, thank you. Learn something every day. Right, drainage and service ducts.
Right. So what we then have is a series of figures here, and what you're saying, I think, is that the primary source of these figures is Jackson's, but in this version, Jackson's cost plan, as it's called, sort of version 2, is after a dialogue with Dadswell's. Sorry. After a dialogue with Dadswell's.
That's
Is that
right. Yes.
So a whole series of things have changed, yes?
Yeah, there's a revised drainage costs in line 58.
Yeah, well, mercifully, I'm not going to take you through every line of what's changed, okay? Because there is only so much time in life available, all right? But
So my understanding is they met, they went through their assumptions, there was a discussion, and Jackson's then provided the updated costs, which reflected the discussion and where they felt ADCC were right.
yeah, there's been a lot of movement on the part of Jackson's, hasn't there?
I haven't got the exact cost in front of me, but yeah, it looks like it, yes.
Yeah, and I would suggest to you what that shows is Jackson's quite appropriately deferring to Mr. Parks because Mr. Parks is an experienced cost consultant and he is particularly experienced in respect of roads and he's got far more data available to him than Jackson's. That is right, isn't it?
No, I think it was two professional and well-qualified people having a meeting and finding agreement where they could, and where they didn't agree, they set out where they didn't agree. So I think that's not quite the same as deferring, I'd say.
Yeah, okay, well, I
So
put my
there's certain
point...
points where they heard what the AGCC have said, we disagree and we used our rate because we think is suitable. So
Yeah.
I would say they're using their professional expertise to reach their own conclusions based on discussions with Mr.
Yeah.
Parks.
They changed their position on lots of items,
They updated their position, yeah.
Yeah, good. And just so we're clear then about what happened, Mr. Parks has access to all of the data that we've identified before. Jackson's only have access to their own data, don't they?
I don't know the exact data they have, but I would presume they would certainly have access to their own data.
Yeah, good. Okay, I'm going to suggest to you that's a lot more limited than that is available to Mr. Parks.
Well, Mr. Parks suggested all his data.
Just
was
answer
Kent
that
project.
question. It's a lot more limited than the information available to Mr. Parks.
I don't know,
Okay.
because I don't know what projects he has available.
He
and
has
how comparable
all of Kent's schemes, because you've been keen to point out there's lots of work for Kent.
Yeah,
and
no,
you're
yes,
right.
I agree he has Kent
He's done
schemes.
lots of work for Kent, and in doing lots of work for Kent, he's got access to all of the data from all of their schemes and all of the costs. So he has a far greater and superior set of data to work from.
I can't reach that conclusion, no, because it's data from, I presume, his company's data from costs of Kent schemes that they've delivered, so they'll be delivered in whatever way Kent choose to deliver, and they will inform him. Jackson's will be using their data from projects that they've delivered themselves, so they'll have a very good idea of what their expected costs will be.
Yeah, the position is that what's available to Mr. Parks is obviously tender information. They'll have access to that, yeah.
Yes?
They'll have access to ongoing project costs, the projects that are ongoing at the moment.
Yes?
They'll have all the data associated with completed projects, yes?
Completed projects they've worked on, yes.
Kent County Council's database, they have access.
That he's worked on, yes.
Yeah, because that's what they do.
Yeah.
They go to his. Okay, all right.
But he won't have any data from projects.
Jackson's.
Yeah, he won't have any data from projects he hasn't worked on.
I wouldn't have thought so. And in terms of Jackson's data, well, where they've worked on a project for Kent, he'll have access to that, won't he?
Are we talking about Mr. Parks?
Yes.
I presume so, yes.
Yeah. And he'll be able to look at their tender information and then the final information, won't he?
I think he does exactly that in his proof.
Exactly. And what he pointed out was a significant discrepancy, a significant difference between the costs at the tender stage and the realised costs.
He did. And then he explained, as did Mr. Birchall, that they were largely down to changes during construction. So design changes and dealing with utility issues.
Unforeseen circumstances.
Yeah.
Good.
It sounds
Okay.
potentially foreseeable, but not foreseen in that circumstance.
So what's informed his decision making is to see what Jackson's, as it happens, tender prices, what actually happened, the reasons why it happened, and then that, of course, has informed his views together with all the other projects he's looked at on issues of contingency, risk, and scope analysis, haven't they?
It does appear that way. So I think I think his costs are. He's looked at the Grovehurst project. He's identified there's been lots of problems with that project that's pushed preliminary costs up as built, and then he's used those with additional costs for our project.
Nothing better than empirical data. Both my learned friend and I appear to agree on this.
I think it depends on the data source.
Is it the case then, as we go through this, that we don't in any way think that Jackson's figures are based on any other drawings or information that you haven't provided to the inquiry or to Mr. Parks?
No, Jackson's costing is based on information that Mr. Parks didn't consider that he could have considered.
Okay, so Jackson's information, they relied on the drawings, presumably?
Yes.
Yeah, the same drawings, or have you got a different set of drawings?
And the model.
Okay.
The model that, yeah.
In terms of the earthworks, let's have a look at what Mr. Wild says about the earthworks. So if you could turn up his proof, that's in your original rebuttal, if that's the right word, original rebuttal. I've got that as 37, 14, 2C.
Sorry, give me a moment. I've got a lot of tabs open.
Yeah, no, don't worry. Just take your time.
2C. Yes, Mr. Wild, yes.
Okay, and if you go to the section on earthworks, that's page 4.
Yes,
Madam-
section 3.4.
Exactly that, yeah. So, Madam, when you get there, paragraph 3.4.1, page 4. It says the proposed road infrastructure will be brought forward in the context of a wider mixed-use development site. There will be considerable opportunities across the site to make use of material from across the site to make up necessary fill, open brackets, embankments, etc., as well to dispose of materials arising from cutting and road formation that are unsuitable to use in structured fill.
Yes.
It goes on to say, this could be achieved across the site through use of borrow pits. It is of note that a considerable portion of the development area of the open space, including parkland, which is proposed to be landscaped and reformed, do you see?
Yes.
And then as proposed, just under 300 hectares of the development would be open space compared to approximately 40 to 50 hectares of the infrastructure corridor. Accordingly, it's evident that the scope of extraction and disposal of materials for earthwork construction across the site are considerable. Now, just to consider the difference then in the costs in earthworks, the position that Mr. Parks adopted is that 50% of the material that is excavated for the road would be capable of being reused, yes?
I believe that was a discussion point that we had.
Yeah.
Yes.
And the position in relation to the importation of material is that he then says, well, half the material that you need to use is imported, yes?
I think that's the difference between us.
Yeah, because to import material is 45 pounds per square per cubed metre, okay?
Can you take me to where I take it, but is that you taking that from one of the cost plans?
It was the information that informed the earthwork calculation, okay? I mean, this is to your advantage because if you just use the material on site, I think it's just £5.
Yes, and our
a
assumption
cube
is
metre.
we can use material fully on site.
Yeah,
Yes.
and then so that's the difference. That's the
huge
the
difference, but yes, yeah.
Okay, and then there's also the cost of disposing material because he's talked about this disposal material. I think that's 34 metres cubed.
And again, that's disposal off site, which adds to the cost. Yes.
Yeah, and as opposed to the 5 metres
Yes.
if you dispose in the borrow pits. Yeah. Now, just a number of things in relation to that. You have said, look, we think we can get all the material, first of all, because of the size of the site. And Mr. Wilde has set that out, hasn't he?
That's one of the factors. Yes.
Yeah. Secondly, he says, well, the material on site is suitable, yes?
We've made a worst case assumption of only 50% is reusable, but yes.
Yeah, and he
likelihood
does-
is it should be higher than that, but again, trying to be worst case.
And I think the suggestion is, well, that is all capable of being ascertained from the geotechnical information that supported the planning application, yes?
The civil engineers who've looked at it have felt that it's comfortable to reach that conclusion at this point. Yeah,
Not from the borehole information.
they've reviewed that information. Yeah.
Okay, all right. So what Mr. Wilde says is this could be achieved across the site, could be achieved through the use of borrow pits. There's no commitment to borrow pits. It's not obviously part of the
It's
application.
an approach that he's used elsewhere and is often used in delivering roads, and I don't think that's disagreed with.
So the position is, he says, it could be achieved doing that.
Yep.
So if we think about that then, if there is going to be extraction and there is going to be movement, because this is effectively material for the construction of embankments and other parts of the earthworks
Yes.
for the road, then
And obviously we are costing earthworks on a worst case scenario already, so the extent of material needed at this stage is far higher than it may well be. But
okay.
yes.
So where's the document setting out the approach to your calculation of the earthworks then? Where's the document for that?
The earthwork calculations are in the JCE costings.
Okay,
but
let's
that's
go
it.
to that.
So we need to go to the not the side by side, sorry, give me a moment. If we go into the series 600 costs.
Yeah. So just have to help the inspector find
Yeah.
that.
So I'm in 37.14.2A3, Appendix 1. Yeah, I think we
I'm
are.
just musing whether we are in the
I thi-
second rebuttal.
It should be in the second.
14.4a point.
Sorry.
I've got the option of 1, 2, 3, 4, 5 or 6.
2A3.
Right.
Appendix 1, Part B.
So 4a.
It was a page that we were looking at before because the earthwork, if I just help you, madam, the Series 600 earthworks is on the same page as the Series 500 drainage and service ducts.
We're looking at a lot of things, aren't we?
And we're looking
cost rebuttal, and then we go into 37.14, and we could go in. It's probably Part 2 is the best one to go into. 30, that's the biggest difference in earthworks. 37.14.4a point 3. Part 2, Appendix 1 to Quantum Cost Report, Section 1.
Right. Hang on.
Sorry, that's,
Hang on just a minute. Sorry.
there we go. So
37, 14, 4a.
A2, sorry, A2.
2,
2, not 3.
not 3.
Yes.
Ah, yeah.
Sorry.
Okay. General information, assumption and clarification. So go on in that.
You go along, there is a Series 600 costs, and there are discussions that were held over the
Yes.
revised allowances.
Got it.
There's a lot of information on there, and that has the rates and the quantity of materials that were used for the purpose of the side-by-side comparison between ADCC and JCE.
I'll tell you what would be really useful, and that's if there were consecutive page numbers of all this document, wouldn't it?
It works a lot better in a spreadsheet, I have to say.
Well, yeah, okay. Right, carry on.
I'm on the paper copy. I annotate all over it generally. I find that easier. But
This is where you've...
so
asked me
if you
to
just
take
find the earthworks and the K, and what I'm after is the document that explains all of the information that informs the calculations and the process, because what it says is excavation of accepted material, and then we've got quantity 269 cubic meters. Yes, this is for class 5A, and then you carry out the unit figure, the rate, and then you get the total. Yeah.
I've got 44,000 cubic meters. Are we on the same document?
Well, I've got your second rebuttal,
Yes.
and I've got your cost plan,
Yep.
and I've got your Series 600 earthworks from the document that you sent out.
Yeah, I'm in the same document. Which one? That's split into 3.
Okay, okay, I see what you mean, because of the roads and all the rest of it. Yeah, yes.
I want to make sure we're in the same one.
Yeah, this is
I think
where
the principle's the same, but it's the
page
making
numbers becomes so important, don't they?
Would be helpful.
Yeah.
So I'm on the version that's Series 2 to 4, which is the Southern Relief Road, not
Okay.
the junction.
What I'm going to need, just because it's the one I've gone to, is the one that's got excavation 269 cubic meters. If you could try and work out which one that is.
Yep, I can try.
600.
600.
May well be the same document.
269.
269,
That's
which is a
quantity.
cubic meter measurement.
I might just need to move into a different... 260.
It's just after that, when we looked at the summary,
Yeah.
it's the next page. So you've got the general information, assumptions and clarifications. Then you've got this summary, and then you've got this table, which starts with Series 500, drainage and service ducts, and goes on to Series 600, earthworks.
And this is for which section? Above that, it should tell you the section of the road.
No.
Okay, mine does. It's a slight worry.
Well, you must be looking at something else then.
Yeah, that's what I'm worried about. So I'm in the Series 600 cost scheme, but each of mine say, so Series 600 earthworks online, does yours say that?
I got Series 600 earthworks. Series 600 earthworks.
Sorry, enough. Do I see the document you're on?
Yeah, of course, this, look here. See, so we've got that, that's the assumptions, which
Yes.
we've been talking about, and they're gone there. And then we've got that, which we've also talked about,
Yeah.
and then this.
And then we go into the Series 600 earthworks
But it
costs.
doesn't tell us what.
Okay, I may be in the... I'll see if I can find it. I'm not quite sure why I'm not able to find it.
Have you got it?
I
No.
actually don't at the moment. I'm
Oh,
curiously looking, sorry.
that's weird, isn't it?
I've got the breakdown you've got, where we've literally got this, but I think that's the Series 500. I've got each of the series numbers here.
Series
broken down.
600, but we don't know whether it's all of it. No.
I just need to know which of the. I mean,
Well, yeah.
it'd be easier if we all use the. The problem is I didn't produce this.
You
document.
produced mine.
Yours, yes. Okay, but I didn't personally. Sorry.
So presumably it's your evidence. I'm hoping it is.
Yeah.
That we've been able to follow that. This is what the inspector's got.
Volume 2.
Is your
Volume 2. Sorry, second.
Oh, did you say what was the number again? 260?
9.
Yeah, okay, so I think, okay. So, have you got
I'm on the electronic version.
37.14.4a.2?
Yeah. Then
Okay.
part.
Okay, go all the way in the tabs to the left-hand side. I think these are M2 overbridge.
In part 1.
Yeah.
Okay. All the way to the left-hand side.
Left.
So-
Mine, it's the first, sorry,
No, it's helpful if you can find it.
Then section 1 summary.
Section 1 summary, and the third is M2 overbridge.
Yes.
And in the third, if you scroll down, there's the second heading is Series 600 Earthworks, and it says,
Oh, okay. So this isn't actually the Series 600 tab. This is the overbridge.
the M2 overbridge.
Yes.
tab.
Okay.
So should-
Sorry, I was in the tab that follows this.
I think, because I see on there, just to say, there's a tab, it says 14, excavation of acceptable material, 269, so that must be it.
Yeah. So
Should we put M2 overbridge on the top of the page?
yeah, I think
This
so.
is specifically for the breakdown of the overbridge.
The overbridge.
Right.
Okay. Now, what I can see immediately under the heading Earthworks, Series 600, is the words have kept the bridge earthworks the same as Grovehurst.
For the bridge, yes.
Yeah. So what they've done is
But,
Jackson's.
sorry, where do you see that?
It's below the word Series 600 Earthworks, but before the word excavation.
So this, yeah.
I see.
Yeah.
So agreed that for the bridge alone, because we're talking about a specific element of the scheme here, not the whole junction 5A works.
but what's interesting is they've drawn a parallel specifically with Grovehurst, yes?
For the bridge overworks, yeah. Earthworks, yeah.
Good, thank you. And then if we go to the excavation, what my questions are really about is about the nature of the project for the disposal and excavation of material, or the excavation and then a deposit of material. This is what you've directed me to, this section, yes?
You directed me to it, but yes, okay.
Yeah. Well, no. You said it's in
Yeah,
this
it's in-
document.
sorry,
So
yes.
you
I
directed
directed you to
me.
Series
It doesn't
600.
matter how we got there, but yeah. And
I direct you to the Series 600, not
Yeah.
that section.
okay, this still doesn't really answer my question, but that's my fault. You were asked about what document explained about the excavations. So we've got borrow pits. If we've got borrow pits, we're going to have haul roads. Yes.
So you asked me which section, I said Series 600. That isn't where you've just taken us, just to confirm.
This is the earthworks section.
You know, the Series 600 is...
The Series 600 tables go into a lot more detail
yeah.
about how much
That's
is...
where I've taken it.
Okay, forgive me. So when we
I'm
talk
like
about borrow pits, okay, where is the work that identifies where the borrow pits are?
That hasn't been done.
No. And if you don't know where the borrow pits are, then you don't know where the haul roads are, do you?
I presume you would make assumption. Yeah, there's an assumption there. Yes.
Yeah. So we don't know how long the haul roads are. We don't know where the material is being taken to in this relevant section of the road, do we?
Well, we do know where the country park is, and we do know where the majority of the earthworks are, and they're in the same area. But yes.
Yeah, we don't have a borrow pit plan, so we don't
No,
know
we
the
don't.
borrow pits, so we don't know. So in terms of the importation of material, yes, it is more expensive, but what we haven't got from you is any information about the cost of moving the material, excavating the material, where that material is being excavated from.
Sorry to say, he has said there is that information, not about where, but he has said repeatedly that it's Series 600, which we've not gone to.
We can go to that then electronically. It can be provided to me as well.
So So that section essentially sets out the excavation, the amount, excavation of acceptable material, excluding Class 5A,
Yes,
about deposition of fill, disposal of material, imported fill, compaction of fill, topsoil and storage of topsoil. So it breaks down all those elements. What it doesn't do is show where the borrow pits are or
that's
where
the point. The whole point is we can do some exercise that says, well, we're going to take the material out of the ground. You don't know where the borrow pits are. You don't identify where they are. You don't know how far you've got to take the material. You don't know how many haul roads you're going to need, all of which are specific costs, aren't they, if you're going to use the material on site? They are specific costs if you're going to use the material on site.
They would be part of those costs, yeah.
Yeah, good. Okay. All right, let's look at structures.
There are assumptions that we've made in our cost plan based on experience.
You haven't made assumptions about where the borrow pits are, and you haven't made assumptions.
We've made assumptions that we could have them.
Yeah.
And we can reuse material.
You just don't address this. Those are costs, do not feature in terms of how far you've got to haul the material and where the borrow pits are.
No, that's not included. No,
Yeah,
not, to my knowledge.
Thank you.
Because we don't know where the borrow pits are. We know we have the information we've got. We're comfortable that the material is reusable, and we can essentially work to a net position, which I think Mr. Park said is what everyone should aspire to do anyway. I don't think there's any evidence to suggest we can't do that either before the inquiry. So there's no evidence to say, well, no, you shouldn't be using borrow pits.
I don't think anybody is suggesting that. What it's suggesting is there's lots of additional costs that you haven't accounted for. Okay.
So I can't go into the exact detail right now as to what assumptions are made in those rates over whether that includes an estimate of movement costs to do with haul roads, for example.
Okay.
I don't have that detail.
We have a number of items that we're in dispute about. We've looked at the earthworks. The earthwork figures that you've provided don't refer to any structural support, do they?
No, because we're using 1 in 3 slopes, and we've got a large, wide corridor to deliver a road, so we wouldn't need structural support.
Okay.
I think there's reference to geo, and I'd have to find the exact word. There's 2 different types of geo, because I'm not an expert, but if we read it.
The road will go through cuttings, and it will be on embankments. Is that right?
That's proposed, yes.
Yeah.
The exact scale of those cuttings embankments isn't for approval, but yes.
Yeah, and we don't know, when you say it's not for approval, we don't know what the final extent of embankments and cuttings is, do we? Because we don't have that detail.
We just have a worst case.
So just help me with this. The road is completely flat through the landscape, is that right?
No.
No, it follows the contours of the land?
To an extent, yes.
Okay, and then what actually takes place by way of the extent of the cutting, how long the cutting is, how deep the cutting is, where do I go for that information?
That information isn't in the application.
No, okay.
So the 3D model that we produced was shared with Jackson's and used by Jackson's, but we've already said we don't have a detailed cut and fill or earthworks model at this stage.
No.
That question was raised by your highway witness when he asked, and we confirmed that in March.
So these are costs associated with embankments,
So
and just let me finish. These are costs associated with embankments, costs associated with the cuttings, the detail of which we don't have because it's a concept. The actual height of the road we don't have, which then informs the cuttings and the embankments.
We have the worst case.
As a consequence of which, forgive me, you keep saying you've got a worst case, you don't have the detail to know if it's a worst case, do you?
I think we do, yes.
Okay, where do I go?
Sorry, are you saying we don't have the detail to know if the design of the road is worst case?
In terms of the vertical alignment, yeah.
I'm deeply disappointed that question wasn't put to the designer of the road, who spent hours in his evidence in chief explaining the concepts that fed into that. I mean, he really, fair and square, I asked him in chief all about this and took a really detailed note of what he said. Trying to put that to Mr. Gearing does seem a bit misconceived. I mean, I think you were here, for all of it. You heard what he said. And so, it does seem pretty unsatisfactory that when Mr. Wilde gave evidence on it.
Mr. Bell, did you want to say something?
I did. I'm slightly loath to jump in, but I did put to Mr. Wilde that he couldn't know that it was the worst case scenario, particularly in respect of the earthworks and the stability of the ground, effectively not having done the geotech that was required. So We on this side did put to Mr. Wild that he couldn't be sure it was a worst case scenario in terms of the design.
The point that I'm putting to you.
So what did he say? Sorry. I've got the mic.
Sorry, Chris.
Oh, no. What did he say, though, Mr. Barker?
So, Madam, he obviously disagreed with us. Effectively, he said it was the worst case scenario. And as I say, we focused on the fact that he hadn't done, or the level of detail that we said needed to be done in terms of being able to assess the ground for the size of the earthworks required, particularly in respect to the roundabouts, hadn't been undertaken. So how could he be sure that it was the worst case scenario?
It's a perfectly fair series of, topic for the inquiry to consider. Don't get me wrong. It's just a question of who considers it. And we've had a witness who's given really detailed evidence on it, who's quite literally the expert out of anyone in the inquiry to what this road is or isn't and the specification to which it has been designed.
Yeah, Mr. Wild has provided the information in terms of that. You're right, we haven't challenged what he said in relation to that. All I'm asking this witness is, where when Jackson's looked at the vertical alignment, where did they go for that?
They met with Mr. Wild, and they met with my civil engineering team, and they looked at the information in with the application, which included, let me finish, which included all of the boreholes and geotech work that was done to a specification set out by Mr. Wild.
Okay, where's the document?
Unfortunately, your witness didn't look at that.
Where's the document that explains that?
There is no document.
There is no document. Where's the document that tells the inspector? Where's the document that tells the inspector and shows the inspector the vertical alignment of the road for all the cuttings and all the embankments?
In the TA for the worst case.
Yeah, and it's got every length of the road and how high the embankments are and how high the cuttings are.
It's got the worst case ones, but yes, for the indicative
of
scheme.
those.
Yes.
Yeah. Okay. Well, let's just go to it then. Let's just have a look at the drawing.
Really? Okay.
Seriously, though, I do repeat.
To accept if that's the drawing. That's
But no, I know.
Right.
But
Can you put your microphone on?
are we not in a game of diminishing returns here? I mean, the John Wild could have been. I mean, he has given detailed evidence on exactly what was done, and we are. It's not that I don't mind. Obviously, Mr. Gearing knows a lot about what was done, and you can take him through it, and we can look at the drawings. But the inquiry's in a situation where we're not really getting the best evidence from the right person, which is a bit He was on for days.
He was on for an awful long time, wasn't
And
he?
it's not like this didn't come up. You'll remember this literally came up quite extensively, and we went through. Do you remember we went through every single junction in a tour, as it were, and he described at each stage, this is this, that is that. I designed it, all of that, and we went also through the concept of is it worst case, and in what way might it be said to be all of that. It went on for days. And I don't mind Mr. Gearing going to. I'm not saying it's unfair or anything. I'm just saying it's a bit. I do query what the point is, because Mr. Gearing is not going to be in a position with the best will in the world to assist the inquiry to the same degree as the person who's already addressed the inquiry and was responsible for all of that material, and who, on an unchallenged basis from Kent, fed into this costing process.
So.
Mr. Young.
All I want to know, the only thing I want to know is where is the drawing that we go to? That's all. And this is the cost witness, and the cost witness can just confirm the drawings, that not all of them, is just identify the series that he relied upon to inform the cost information. That's all.
So the drawings that were used to rely on for the cost information are, as shared with your witness, the highway drawings that are in the technical appendix, but also our team, including JCE, used other information, and that information I've explained in chief. I can say again, but it includes information within the application, all of the information, application documents, the earthworks, sorry, not the earthworks, 3D model.
I don't doubt you. I don't doubt you.
So I think
all I'm asking is, can you? Sorry.
I think it's important though, because you're specifically referring to drawings, and I get your point, because that's what your witness looked at. My team looked at that as well, but they also looked at all the other information they had, and that may be why our costs are different.
Yeah. All I'm saying is, just take us to the drawing okay, that
Do you want
is
me to
the...
go to the TA and open up those drawings, or should we just say it's the drawings
No,
in the
just,
TA?
just show me what the drawing is that you're referring to, or the drawings, which just tell the inspector, okay, this is the information that informed the cost decision or the cost input for the earthworks.
CD?
The TA.
TA latest drawing versions.
Is it the south or the north?
Should we
Well, it'd
do you
be
want
the
us to go
south,
to
wouldn't
both?
it?
I'll just
All I need is just the example of the drawing.
Example.
And use an example of the drawings.
one of the general arrangement drawings. So
Okay.
sorry, thank you.
I don't think the northern one is really has the same.
Going to be
issue.
so helpful, no, but maybe the southern
Just have a- someone
TA.
I can give a reference if it helps.
Yes, please, yeah.
Core document.
Don't forget your mic.
Core document, sorry. Core document 7.31.6 is the May 21, that's probably out of date anyway, but the May 21 southern, it's not the wrong one.
You need to find the updated ones.
Sorry, cancel that.
They are the drawing numbers that helpfully are listed at the beginning of your ADCC report. So
Oh,
you know,
okay, I have to try and find them.
no one's just the drawings are the drawings. So other than finding the CD reference and bringing it up, I don't think anyone's disagreeing over the drawings.
The old TA reference.
Let's have the drawing numbers then.
Let's see.
Yeah.
It is the ones that were, maybe we've got them as were they added as an inquiry document? You know, the ones that you handed round.
I don't think we're at odds. Strangely, I think this has been a very cathartic exercise because what we like to do is make sure the inspector knows exactly the information that was relied upon.
I just need to find the CD reference. That's the problem.
Not sure that those. So Mr. Young handed round a few days ago those ones, A3 drawings. I'm not sure that they've actually been added as inquiry documents, but they obviously should
Seem sensible if they were.
I'm sure they are somewhere in the CDs, but I just can't find the reference.
They haven't been added in yet.
They haven't,
They haven't,
but we could do.
All right. So yes, that's when you say my team were looking at other information, or our team, and maybe that's the reason for the difference. Obviously, all of these drawings were known to Mr. Parks because Mr. Parks did the correct thing in a cost plan, and he set out all the drawings that he referred to. Yeah.
Yes, correct. And when we were presented with his cost plan, we reviewed those to make sure he had used the same set of drawings we used.
Yeah, and what I'm saying is I've looked at those drawings, I've looked at the detail, the inspector's seen them, we thought it was particularly important she had a hard copy so she could see, if I can put it this way, madam, see precisely what we were talking about, rather than opening up lots of documents online, checking you over. There's a complete set here. What they don't give us, do they, is for the length of road, the vertical alignment.
They give an indicative alignment, I think, only.
Okay, and that's our point, you see. In terms of the earthwork calculations, there's a difference in terms of the calculations, and we've done it on the information, Mr. Parks has done it on the information that's available.
I don't think our calculations are different over the extent of earthworks. I think that they purely come down to the figures you set out there,
okay,
how
again,
they reuse.
Well, this is again helpful, no doubt, for the inspector, which is that in terms of the difference then, it isn't the extent of the earthworks, because actually nobody knows that yet, because it's an indicative concept.
Correct. We've both been robust and costed a worst case.
It's a concept. Yeah, okay. And so the inspector says, well, I'd quite like to see what the vertical and horizontal alignment is, and then know the extent of the cuttings and the height of the cuttings and so on. That information obviously is not available to either party.
Only the worst case in the indicative drawings.
That information not available to the parties because we don't have vertical alignment for the length of the road, do we?
We have an indicative worst case vertical alignment, yeah.
Well, just yeah, okay. Show me the alignment then, because I'm looking at the drawings.
So we've got this is the, there's essentially the sections. So I just need to find the drawing reference.
Okay.
It's the chainage drawings, yes. The Southern Relief Road, we have a horizontal alignment, and then we have chainage drawings that show, yeah, exactly that. And as I've been taught, they are not to the same horizontal and vertical scale.
Yeah.
Mr. Wild went into this in a lot of detail.
Yeah, and he was his evidence was given. He explained about why that route was identified, where it connected with other junctions, and so on. He gave us that information, and we're working off this. We can see that there are embankments and cuttings required. Yes.
Indeed, and that's what's informed the costings.
Yeah, in a 2D drawing, but then the profile is in inset drawings. Yes, and in the chainage.
There's a profile, yes, and then there's some sections. When you look at the horizontal alignment, there's a number of sections shown to give an example of what it would look like at that point that refers back to the chainage. Okay. And of course, there was a 3D model that was also used.
Okay.
Well, we used anyway.
Yeah. Okay. Then preliminaries. If we just move on to the preliminaries, the position with preliminaries is that these are the initial costs of a project.
They are the non-construction costs. I think we went through that in detail what the definition is. So there's ongoing costs, there's weekly costs that ongoing, but they are the costs associated with things that aren't the actual construction.
Yeah. No, we've
So
had the whole.
we've got into that.
Yeah, we've had the whole discussion about the NEC contract. We had Mr. Goodwin to give evidence about that. I don't want to trespass that because that was a witness I was able to cross-examine. However, in terms of the approach that is referred to in Jackson's included a document where, for example, they referred to the costs on the West Sussex project as preliminaries at 17%. Do you remember that? Or 18%?
Yeah, there were. This is an appendix to
Mr. Goodwin.
To Mr. Goodwin. And this is the example of 3 projects, all in West Sussex, 1 for Homes England, 2 for West Sussex County Council, from Jackson's. They're all highway projects, quite comparable, though slightly smaller. And they've set out their prelim allowances, or the prelim amounts for those projects. I think no one raised any concerns with 2 of them, but Mr. Parks raised the 3rd and said his understanding was that costs may be higher.
To work out what the 18% was, where is the information from Jackson's that allow us to do that?
It's an appendix of project examples, and there isn't a detailed breakdown provided.
No. Okay. Well, I can't.
Nor was it requested.
Well, it can't be worked out on the information you provided. That's the point.
Okay.
Where is the 18%? Which project are we talking about?
This is 37.50.
Is this a Western Bridge Link Road?
Yes, there are three projects in here. There's the 2,300 corridor works, which are for West Sussex County Council, 2.5-year project, 21 million to deliver a 2-stage delivery of a fairly large road to north of Burgess Hill. That goes through all the detail of the work they did, what work they did to minimise costs, and so is a staff and prelim cost of 16%. That hasn't been disputed at all.
Okay.
You've got the A284 Lynminster bypass, which is a recent project, I've driven actually. £32 million contract to West Sussex County Council, NEC3 option C. Talks about earlier contractor involvement, talks about the variable ground conditions they found there, how they dealt with it through piling, temporary works, surcharge. They built a viaduct as part of that scheme, many other structures, staff and prelim 17%, not contested. And then the 3rd example, Western Bridge Link, it's a smaller project, 13.4 million, Homes England. This, and at that time, this shows a circa 18% cost. At the time of Mr. Park's evidence, he said he thought it was higher. And I think we said we would try and look into that. So this is live evidence. I did have some correspondence with Paul Bennett from Jackson's.
Yeah.
And he said this was originally envisaged, actually I need to find exact words, give me a moment. I made a note of it this morning, so give me a second. That's it. So he said This was originally a larger project that got split into 3 phases, and then it was a design and build, hence the higher contingency costs. So he said there may be maybe one of the reasons that there's a difference between the costs that ADCC have and those costs only relate to the first part of the project.
Yeah.
So there may be, and I don't know the answer because obviously this is all live, that may explain the difference. I'm not saying it does definitely explain the difference, but that might be the reason behind the difference.
So just help me with this. There's no other figures to allow us to calculate that provided in the Jackson's in the document sheets, is there?
No other figures.
And that applies to all 3. I mean, it happens that Mr. Parks thinks that Jackson's are wrong about that because he's spoken to, I think, a fellow director in relation to that, and he thinks that Jackson's figures are just wrong.
Yeah.
I don't have the information to know whether the others are wrong or right. All I know is that Jackson's appear to be using the wrong number. However, the point is, the point is we don't have the information to work out whether that calculation is correct.
No.
No, okay. Just help me with this then, please. In terms of preliminaries, how much of this is attributable to the use of the NEC contract?
It's not something that makes a difference.
It doesn't make much of a difference? No, okay. So the NEC contract, and if the local authority use it, wouldn't be a big reason for the difference?
As we heard at length from Mr. Goodwin, that NEC is a standard contract that is subject to significant variations, and so that comes down to the client making such changes. Secondly, obviously, there's the whole difference between the internal procedures when contracts are in place as well. But the actual concept of an NEC contract isn't something that is the be-all and end-all. I mean, as we said, KCC use bespoke NEC contracts. We may choose to use an NEC contract. We may use a JCT contract. We haven't agreed the type of contract yet. And it may well be that different parts of the project have a different contract, depending on requirements.
Could you go to Mr. Bell's rebuttal, which is the rebuttal in your second rebuttal?
Okay.
3714 4A1.
Give me a moment. 3714 4A1. Yes.
Okay, and if you go to page 6, he's dealing there with junction 2, J5A.
Yeah.
And if you go to prelims, that's paragraph 22.
Thank you.
Do you have that, madam?
Yep.
Okay, and point B, he says, Table C in Appendix 2 of this report identifies that the difference is almost solely down to prelim costs. He's talking about one aspect of it.
Yes.
This difference can be attributed to the local authority-led manner in which the Dadswell's costs have been produced and the assumptions made over the weekly running costs. The local authority will let these contracts under an NEC contract, which is a resource-heavy type of contract which suits the variety of stakeholders involved in a KCC-led project. Okay?
Yes. Yeah.
So he's identifying the sort of heavy nature, if you like, or resource-heavy nature down to the NEC contract, yes?
As well as the weekly running costs and the local authority-led manner, yes.
Yeah, and so I had understood your case, correct me if I'm wrong, that the NEC contract was a problem, was a difficulty.
It was part of our case that if you use, and you are required to use NEC contracts, that may make costs higher, yes.
Okay.
But we haven't said we would or wouldn't use NEC contracts, and obviously that's a future decision to be made.
Yeah, he assumes, perhaps correctly, that the local authority will, i.e. Kent, I think he means, but will let the contracts under an NEC contract. He assumes that, doesn't he?
Mr. Bell assumes that KCC use NEC contracts.
Yeah.
I think it's based on his experience, but yes.
Yeah, good. Okay, all right.
And he says for your own contracts.
And he says it's a resource-type heavy contract. So what he's saying is there's a lot more resources invested in it. And we talked, didn't we, with Mr. Goodwin about programming.
We did at length, yes.
And the position with the programming is Mr. Goodwin confirmed that he hadn't asked his programmers to look at the program produced by Mr. Parks. Remember I asked him? Mr. Goodwin gave evidence, and I asked him.
I do recall
Asked
that.
him
Yes,
whether he
yes.
looked at it.
Sorry,
yeah?
yes.
And
Took me a while to get back there then.
and he hadn't looked at it. Was there a reason why he didn't look at it?
Mr. Goodwin wasn't there to cost ADCC's work.
Okay, so
But
In terms of the-
you could have asked him that, I suppose.
in terms of I did. Yeah, the program. I asked him where he did. He didn't. The position with his role is not to look at the detail of the costs. He's just really was talking about the NEC contract.
He was talking about contracts in general.
Yeah.
He spoke about the NEC contract, and he said that, and he showed, I think it was that the NEC contract was well intentioned. He said that it did actually encourage early working with contractors, which was contrary to what Mr. Park said in his proof. And he said that in practice, I think that he said that in theory the NEC contract should work, but in practice there's been lots of problems that when it goes wrong, it can get very expensive.
If you go to point,
I'm paraphrasing. We all heard what he said.
Yeah. If I go to point I, which is page 7, so 22I, we're still in Mr. Bell's evidence.
Yes.
Oh, hang on. Right. Sorry. Yep.
Page 7. Excuse me.
So that refers to H above as well, and G and...
Yeah.
yes.
So he's talking about, compared with a private developer led approach where decisions can be made much quicker, immediate access to in-house design teams and so on. And then he says, this is the main reason for the difference in prelim budgets, slow and arduous compared to slick and efficient. What he's doing is describing the private sector as slick.
Yes.
Yeah. And what experience do Quinn have of managing major road projects?
So we've managed, of a major road project of this type of scale, we don't have experience. We have managed road projects that are smaller, and there was discussion by Mr. Birchall about the deal scheme. I think also it's quite relevant that we have worked in joint ventures with local authorities whereby we have to work within their procurement and sign-off and approval processes compared to our own. So we have got first-hand experience of the difference in time and cost of having to work between public sector-led and private sector-led.
Okay, you talked about Beeston Park. That's the site in Norwich, is that right?
It is, yes.
Okay, and you referred to there's a section of road to be delivered, is that right?
Yes, an east-west link.
And how long is that section of road?
I will have to measure it. It's probably a couple of kilometres at most.
Okay.
Yeah.
And then also there's an additional issue about a water treatment works, yes?
It got caught by nutrient neutrality, so we've had to deliver an off-site, brand new Severn Trent Connect, you probably know about them, wastewater treatment works, and a wetland, and all the foul drainage connection to that.
And in broad terms, what's the cost of that wastewater treatment works?
In isolation or with the foul drainage as well?
I suppose just isolation first of all.
I think it's around about 15 to 18 million.
Okay, and then with the other bits?
Over 20 million.
Okay, and then the road, how much is the road broadly?
I think the package for the road, part of the roads are being delivered as part of, in conjunction with the house builders, so we haven't got all the roads, but certainly some of the phase 2 roads are 10 to 12 million, I would think.
Okay, all right. Now those are pieces
over £30 million package of works we're doing at the moment.
Okay, now you came into that project, I think, in 2023, is that right?
I think it was a bit earlier, but actually publicly then, yes.
Yeah, so in 2022, but publicly 23. Does that sound right?
It may have been 21. I need to double.
Okay.
It's
Right.
essentially. I can double check. I need to check. Does it matter?
And it's 3.5. No, it's not 3. I just want to understand roughly your position because you were talking about this at length, and I just want to understand the nature of the project. We've talked about the infrastructure works. They're not on the scale of the road schemes or the infrastructure required here.
No, there's off-site works, there's on-site works, but they're not of the scale of this project. Correct.
Okay. And in terms of the nature of the project, you've got to build, effectively, a wastewater treatment works, is that right?
We've got to, essentially, yes, in conjunction with Severn Trent Connect, 'cause obviously they're the wastewater treatment works company. I probably can't go into too much contract details, but yes.
No, don't worry about the contract detail. Okay, and the position is you'll need Environment Agency approval.
EA permits for the discharge, yes.
As far as that project is concerned, I think you were highlighting the fact that Barratt and Persimmon, or two house builders, have already entered into a contract with you.
Yes.
Yeah. I think, in fairness, what you indicated, they paid down deposits. That's the amount they paid so far.
Yes, a small deposit, yes.
What is that small deposit? I think you said in the 100,000s.
I'm not going to say what the deposit is, obviously.
You said in the 100,000s.
It's a low deposit, yeah.
Yeah, it's not millions.
It's not millions. I think
Okay.
the point was it's not money that's going to be significantly funding strategic infrastructure.
It's just a...
It's a deposit.
It's a deposit on a contract, on a contract, and nothing compared with the value of the contract.
No.
Okay.
Well, I'm sure it is linked to the value, but as a comparison,
It's
no.
a very small percentage, yeah.
Yes,
So that's what they've paid.
Yeah.
And then going forward, what we know is obviously there's 4 payments to be made, you told us?
Yes, correct.
Yeah. How many of those payments have been made at this stage?
None yet, because we're still waiting for the final technical necessary consent to come through.
Okay, and that's from who? From the council,
EA.
Severn Trent? From the EA?
Yes.
Right. So what's the timescale on the EA providing that consent?
The permit application's been in for nearly 2 years, so it's already about a year late, and it's due in the next coming weeks, I'd say. Well, it was due in the coming weeks for a number of weeks.
Okay. Did you anticipate? Well, when you bought the site, obviously, I think you said you didn't anticipate the nutrients problem. It landed on the day you bought.
A day we exchanged.
You exchanged it, yeah.
Yeah.
And so far, that delay has been 2 years.
Well, we've also had all sorts of other necessary consents to deal with. But yes, essentially, it's not the only approval process. But yes, there had been delays because of nutrient neutrality from when we exchanged.
Yeah, it was an unanticipated problem,
Yes, yeah.
and it's added to your costs
Yes, undoubtedly, yeah.
significantly.
Yes, yeah.
Yeah, and the consequence of that is the house builders don't pay any significant sums until you get your technical approval from the EA.
Well, all the necessary consents, but that's the outstanding one, yes.
Okay, all necessary consents. Right, and so the house builders, obviously nothing's been built on the site.
We've commenced the development, so we've built a junction.
Okay, but sorry, you're quite right. But in terms of the actual house building, no house building taking place.
No, reserve matters have just been submitted.
Okay, and then the house building itself, when is that going to happen?
During the the house building itself will obviously happen after reserve matters are approved. There is a slight... So essentially, during the house building will happen between the third and fourth payment, I would envisage.
Okay, all right.
Or
And
the
how
second and third payment, around those mid payments.
and how far away is that roughly?
I would say, well, the reserve matters applications are in with the council now, so
Yeah.
they will obviously need to be approved.
What, the house builders doing those? Or you?
Yeah, the house builders have put them in now. Yeah, so they're in for phase 1 and part phase 1A and part 3, phase 3A, 1A.
Yeah. Okay. So
So
Phase
once
one-
they can commence development once the technical approvals are in place, they're able to then commence development on site.
yeah. Okay.
But at the same time, we will be building the wastewater treatment works. I haven't gone into this detail, but essentially within the 106, there's a tankering provision. So if, for example, the wastewater
It's not
treatment works is
ready.
not quite
You
ready,
can tanker it. You can tanker it.
The idea is to try and avoid tankering, but also you need a minimum of 50 occupations on site before the wastewater stream works can be commissioned, because it needs a certain amount of flow. So there's a slight, there's a budget there to work to make sure that we bring
Okay.
the infrastructure exactly the right time.
The question I suppose I'm really after is, or the answer I'm after is in relation to, we've had no significant payments, none of the instalments.
No, but the contract positions are there.
None of the big instalments, just smaller sums of money, that just the deposit amount in the whatever hundreds of thousands.
Yeah, because
Then-
they're dependent on the technical, as I set out. Yes.
Then you got the reserve matters have already been submitted. So my question is, when do you anticipate the houses will be built?
I think within the next 2 years.
Next
3
2 years.
Yeah.
Okay. So at the moment, they haven't paid anything by way of any substantial sum, and the houses will be complete in the next couple of years.
They are in a contractual position to pay that money, subject to us meeting those requirements. So
Yeah.
it's not quite the same, but yes.
But it's just 2 years. That's the point.
Well, it's 3 years, I said, but yeah. So 2
Okay,
to 3
because
years.
the position is, we just want to be clear about this, and the sums of money that they've paid are in relation to the 2 sites, the Persimmon and the Barrett site.
Yes.
Yeah, they're not waiting for, something like the Southern Relief Road to open or anything like that. What they're waiting for is obviously the EA approval, subject to the 50 dwellings that can be occupied.
No, they're waiting for they were waiting for a number of technical approvals, but that's the last one. So they
Yeah.
were waiting. So
I suppose at this point in time.
So at this point in time, the only outstanding technical approval is the EA permit, because the EA permit is for the wastewater treatment waste as a whole for
Yeah.
3,500 houses.
Okay,
So
and
it's not for 50. That's
Yeah.
that's a red herring in terms of technical approvals.
okay, I didn't think it was restricted to that. I think you were just making your point about the flow. So what I'm interested in is the period of time between making any serious payment by the house builder and actually being able to occupy the homes. Is there a Grampian condition on the east-west link?
No,
No. Okay.
because it's
So-
delivered in phases.
So what the house builder needs to be mindful of in terms of what's stopping them from occupying is only the EA approval, yes?
Yes, there are certain infrastructure requirements that they will need to deliver. So they're as usual for any large scheme. So
Yeah.
junction improvements by a certain number of occupations, but they're not. It's not a. All the prior to commencement ones have been dealt with.
Yeah, so it seems to me there isn't really any delay because they haven't paid you any substantial money and the EA approval is due in a couple of weeks, after which presumably they make their first payment,
Yes.
and then the houses will be occupied in 2 or 3 years' time.
Well, then we crack on building the infrastructure that is funded. So very much like for like comparison here. So
This is
if we do the comparison, I suppose we've spent time getting the technical approvals that allow us to commence. And in contract, we have the technical approvals releasing funding. We then have further funding coming in while we deliver the infrastructure. Alongside the delivery of that infrastructure, reserve matters are coming forward and house builders are preparing themselves ready to start building.
Yeah.
Then their final payments come in alongside occupation. So that's the comparison.
Yeah. So having not paid anything up to now, then there's no real delay. I mean, house builders needing to get their reserve matters approved and not building for a couple of years or 2 or 3 years, that's just normal. But they haven't actually paid you anything substantial yet, have they?
I'm confused to see what
They haven't actually paid you anything substantial yet.
not money received. No.
No. So
We're doing the first technical years of approval at risk.
They're
which
not
is the
out.
same.
They're not out of pocket.
No, they're not.
And they're just going to put their reserve matters in. I think you've said they've gone in. Is that right?
Yes.
Okay. So that hasn't delayed them. They haven't paid you anything yet. And then the normal period for the reserve matters would be a couple or 3 years anyway, wouldn't it?
Well, it shouldn't be, but it often is.
Yeah. Okay.
So it's the same situation, though, isn't it?
But it isn't, is it? Because the difficulty you've got is you're saying to the inspector, look, we're going to have 100 and I think it was £18 million provided up front. And in doing that,
I haven't said up front.
well, this is before the road opens.
Yeah, it's not up front of what? Sorry.
Okay, up front of the road actually opening and anybody can
Up front of
obtain
houses
an
being,
occupation.
so
Yeah.
by the point of houses being able to be occupied,
Yeah.
I said that we would have sold the equivalent of 1,500 plots and been paid in full.
Yeah, so it's the scale of the operation, Beeston Park and here. You're drawing the parallel, you're saying we get these payments in. You appear to have effectively not taken any substantial, well, you haven't taken any substantial money, and the only period of delay for the house builders is the normal reserve matters period.
I'm slightly confused because we wouldn't get paid on the Northern Relief Road until we have the technical approvals, which is the same situation. So if you and the Southern Relief Road. So if you look at the timeline, that first payment comes in, then there's two years or so in the middle, then the final payment is the same.
You pay them, but some of the payments are in year 2.
Yes.
And then no occupation until year 5.
Yes.
Okay. Whereas what you've got with the situation in Beeston Park is you've had no money up to this point.
We're already at year 2, essentially, aren't we?
You've had no money, and then they're going to be able
Occupying
to
in
submit
year
their
5.
reserve matters. Yeah.
Yes, as they would
Okay.
be.
Nothing stops them by way of the road. There's no Grampian. We've agreed that.
No, but they've got another Grampian with the wastewater treatment works, so it's the same problem.
You've got to build that.
And have it operational.
Yeah, but you're not building a £100 million road or a, whatever it is, £60 million junction. What you're building is, I think on your evidence, a £15 to £18 million water treatment works.
And the connections to it. And
Yeah,
the other
which
things
you
I
said,
set out.
okay. So
It is, but
nothing like on the scale, is it? Nothing like on the scale, nothing
No,
like
I don't think I said it was. I said
Okay.
it's the nearest comparable project in scale. It's 3,500 houses and it involves upfront infrastructure being delivered and phased payments. They're
Yeah.
the comparables I made.
And you explained to us that the reason that your firm went there was because of the nutrient neutrality issue being an issue in Kent, and that didn't.
That was a kind of off the hand comment, but okay, yeah.
No. I just understand why that project was adopted. It was adopted by your company in a way of looking for sites that didn't have that kind of nutrient neutrality problem. Yes.
It was one of the many considerations, but actually it's just it's a good site we thought we could unlock.
Yeah, and you are bringing that forward.
Yes.
Yeah. With the only real impediment being the water treatment works. Is that right?
Outstanding impediment. As I said, we had land acquisition. We had to bring in extra land. We had a planning permission that didn't work, so we had to resolve that. We've done.
Sorry.
We've resolved the affordable housing amount because that wasn't fixed at the time. We've had approval for off-site section 278 works. We've had planning permission granted for a wastewater treatment works and a wetland. We've had confirmation that the wetland meets the RPS 260A requirements. We've designed the phase. We've had reserve matters approval for the strategic infrastructure in phase 1. We're working up the phase 2 strategic infrastructure approval. We have done a lot of work, basically. We've discharged a lot of pre-commencement conditions.
And those house builders, I mean, I don't imagine, I don't know, viability was an issue on that case, I don't know. But the point is, they've made payments to you. We can't measure whether there's any discount for early payments because we don't know what the plot, it's parcels of land, I think, is that right, as opposed to plots?
It's essentially on a plot basis, but it's parcels of lands, yes.
I can't ask you about any kind of discount because I can't measure it against an undiscounted plot amount.
No, you can't ask me about any kind of discount.
Okay, all right. So we don't know on that issue. All right. Next issue is contingency. Madam, this is going to be a bigger topic. I don't know if you want to break now.
Good idea. How are we doing?
We're doing better than I thought. So it's difficult to predict, isn't it, when it's over a day?
Well, yes.
But at the moment, I think we're going to finish this witness before the end of the day. And that would obviously...
We had to do that, don't we?
You mean like...
But not at the end, you mean?
Yeah, for Mr. Bell to go on
for
as
Mr.
well.
Bell
Yeah.
as well.
Yeah.
And re-examination, that would be great.
Yeah, I mean, I've got a few questions, but not mega, so...
Okay.
So if
we've done, I think, is this right? Preliminaries, earthworks and structures, so I think we're on contingencies, basically.
yeah, there's a bit more, but a few other topics. But what I mean by that is the whole issue about Mrs. Dickinson and worrying about breaking this witness. I think we're going to avoid that. Sorry.
You might have broken him already, actually. But
That was Mr. Birchall's great the comment that was made to him. Anyway, can I just check with Mr. Bell, if I may, the sort of in terms of the time scale.
said half an hour or so, didn't he? Didn't you?
I can't. I think it was longer.
Did I say half an hour? I think I might be able to reduce it by about half an hour, possibly. But I think my time estimate was 2 hours. We are covering a lot of the points that I would have been able to have dealt with in kind of headline as opposed to the level of detail, and that in turn knocks out some of my questions. I'm going to kind of have a chat with Councillor Bonney over the lunch break, and I think I probably can reduce my time.
So what I'm going to do, if it helps, is I'm going to try and we're going to have our lunch now.
Yes.
We'll be back at 1:45. Or
No, well, it's 10 to 1 already, but it depends how
that-
long you
that's-
talk for.
Eating into the lunch break.
that,
No, it's not. No, we haven't started it yet.
Cardinal sin. Okay, I won't touch the lunch break. And then try and finish my cross-examination before the afternoon break. because that means
That'd be
there's
good.
a realistic prospect of finishing.
Okay.
Are we on a time limit to finish this evening?
Don't think so, but you know, we did start at 9. But anyway, okay, let's see how we get on, shall we?
I just because I'm about to be involved in Section 106 session, from my point of view, I'd obviously rather finish it if we can. Even if we went on later.
Yeah. Okay, well I'm
quite happy to.
let's see how we get on, shall we? Let's try. Okay, well, well done. So it is 10 to. So we'll resume at 10 to 2. 10 to 2. Yes, thank you.
It's getting warm. I'm going to turn the air on as well.
Oh, thank you. 10 to 2, so it's time for inquiry to resume. So we're going to talk about contingencies next.
That's absolutely right, madam. We passed the 1 day mark for Mr. Gearing's cross-examination, but the end is in sight, Mr. Gearing. Okay, could you turn up, please, the North Essex Authority's Shared Strategic Plan Inspector's Report? You'll find that in Mr. Spilsbury's original appendices, and it's the last one.
PDF 258.
Yeah. And what we've got in there is a series of reports, and I've got it as a document that starts with the 10th of December 2020 report from Inspector Roger Clues. It's Appendix P. Okay. It's the beauty of the hard copy, isn't it? Just saying.
Sorry, could you confirm the CD again? 39 point. Okay. Yes, working online, but not in hard saved version.
Okay, well, whichever journey you take, if you get to Appendix B, it's the report on examination of North Essex Authority's Shared Strategic Section 1 Plan. Okay, and in particular, what I'd like you to do is go to the end of these appendices, because there's a series of reports. The one I'm after is the one that begins with the Inspector's report of the 15th of May 2020. So, madam, if you go to the document, the last document in that, if you just go to the back of the appendices, I suppose, and then you should have numbers that finish at 55, 56.
So it's
And what we're on, I just want to go to page 1, but that's just to try to help you find it from the back, if you like. So you've got 55 at the back. There's several, what there were was several reports. And
Thank you.
It's also a PDF just for
page 1 of the section that I've asked you to go to. So if you've got page 56 at the very last page in the, okay, does it say 15th of May 2020?
So you've not got the right page one. So that, madam, is a clip of a number of reports all back to back to back. So you go right to the final one, right to the back, and then work your way from the back to page 1 and back.
Can we just check what the PDF page is?
322.
322. Thank you.
One of the interim ones. Okay. Okay.
Sorry, not page you're exactly going to, but I've got the document.
Okay, and what the inspector say wrote to the heads of service, heads of planning for the different authorities, Braintree, Colchester and Tendring, and he says at paragraph 1, my letter to the North Essex authorities 8th of June 2018 set out the shortcomings which on the evidence available to me at the time I had identified in the submitted section 1 plan, and it's evidence based, and then he goes on to explain that. What I'd like to do, if we may, is just go forward in the document to viability, which is on page 40. So I just wanted to sort of orientate ourselves, madam, within the documentation. Page 40 of the section you're in now, if that makes sense, and there should be a heading viability.
Page 40. Yes.
And what Mr. Clues was saying was, starting with the national policy and guidance, which there's going to be some discussion on tomorrow, he's looking actually at what was the previous or the original version of the MPPF, which said at paragraph 173, as he says at 192, the 2012 MPPF advises that to ensure viability, the cost of any requirements likely to be applied to the development should, when taking account of the normal cost of development and mitigation, provide competitive returns to a willing landowner. That's the test that we used to have. Okay. At 193, it says the PPG on viability makes it clear that understanding local plans viability is critical to the overall assessment of deliverability. Now, two things. First of all, obviously, here we are not in a local plan, very obviously.
Correct. My understanding of this example is it's from North Essex. I was working on Otterpool when this was published in my
Just
former
take the
job.
questions one at a time. It's my fault.
I'm going to answer it. I'm getting there. So yes,
Yeah, it was a series of new settlements
three.
across a number of authorities. So there's three mentioned. I think Uttlesford also features for. Okay. Now, what I want to do is just look at what the inspector says about contingencies. Because if you go to paragraph 44...
Paragraph 44.
Sorry, page 44, my fault, paragraph 214.
Yes.
What the inspector says is, in the 2019 update and supplementary information, 10% contingency scenarios, a 10% contingency allowance applies to all the infrastructure items. In the 20 to 40% contingency scenarios, the higher contingency allowance is applied only to the base costs of those infrastructure items in the scheme-wide other itemised categories, with the contingency allowance on the other items remaining at 10%. This, he says, approach appropriately reflects the fact that in the terms of that category, which are most likely to be subject to unknown additional costs, in considering what is an appropriate level of contingency allowance, it's necessary to recognise that the Section 1 plan represents the initial stage of planning for the proposed garden communities, setting out broad parameters and high-level infrastructure requirements for them. The exact amount of development that each GC will contain and the precise nature and scale of the infrastructure requirements will be established through strategic growth DPDs and master plans, which have yet to be drawn up. So the distinction he's drawing there is, look, this is a local plan. We don't actually know the scale of development, yes?
I think you're right. Yes, there were, I think it was envisaged for around 43,000 dwellings, but only broad locations were identified at that time for where those dwellings would be located.
Yeah.
It's very much a plan-making exercise rather than a red line area.
Yeah.
And they had really low-level idea of, or low level of knowledge of what the infrastructure requirements would be.
Yeah, and then he says at 216, in general terms, the level of contingency allowance as appropriate varies according to the stage of planning the development project has reached. And you would agree with that sentence generally. The amount of contingency should reflect the stage of planning a development project has reached.
Depending on the project, but yes.
Okay, costs are likely to be underestimated, a phenomenon known as optimism bias, if an adequate allowance for contingency is not made at an early stage. In the early stages, when the project is less well defined and there is greater uncertainty over the factors influencing the eventual outturn cost, a higher level of contingency allowance is usually appropriate. And again, as a general proposition, you'd agree with that.
The inspector's interpretation of optimism bias there is on the basis of the unknown cost. I think there's also, from a business case point of view, it's also used to make sure that the benefits of a project aren't overestimated too.
Yeah.
So, yeah.
As planning progresses and uncertainty is reduced, the level of contingency allowance may be reduced accordingly. And that, again, would appear to be a fairly sensible and obvious proposition, wouldn't it?
That's what it says, yeah.
Yeah. Good. Then at 217, the Treasury's supplementary Green Book guidance on optimism bias advises that an upper bound optimism bias allowance of 44% for capital expenditure on standard civil engineering projects provides the first starting point and a reasonable benchmark. It reflects the average historic optimism bias which research found to occur at the outline business case stage. So it's a business case phrase, yes?
Yes, that's my assumption. I think that's covered in the appendix of Mr. Wild as well.
Yeah, and the 44% is what it's advising at that business outline stage, yes, based on research.
the upper bound optimism. So it's what it's saying is that the upper bound limit of optimism bias is 44% for capital expenditure on standard civil engineering projects at a first starting point. Yes.
Okay.
First starting point's key there, I think.
And then at 218, whilst the Green Book guidance specifically applies to public sector commissions, in my view, similar considerations apply at the stage of planning that the garden communities have reached. At this early stage, and particularly when account is taken of their large scale and very long build periods, it's inevitable that many uncertainties remain over the infrastructure's requirements of the proposed garden communities. As discussed above, for example, decisions yet to be made on which of the options for water supply and wastewater treatment will be pursued at each garden community, nor has there been any specific analysis of the risk to infrastructure delivery. So what's being highlighted there is, first of all, you need to look at the stage it's reached, obviously. Secondly, you need to look at the scale of the proposal. That's another factor. Do you agree?
That's what the inspector said, yes.
Yeah, but do you agree that's a relevant factor?
I think stage it's reached and scale, yes, are both important. Yes.
Yeah, okay. Long build periods, that would be relevant, yes? That's a relevant factor.
Depending on the stage it's reached and the scale, yes. And
Yeah.
the amount of information you have, yes.
And then, say, uncertainties about, wastewater treatment works. Are we at the stage of this proposal, in a position of knowing what the extent of wastewater treatment works are required for this scheme, for example?
We've had discussions with the wastewater provider, and the discussions led to a view that there would be sufficient capacity with the usual type of upgrades that are required within the network.
Okay.
There's an appendix, there's technical appendices on that in the ES.
Yeah. 219, moreover, I've set out above the base costs allowed for the RTS in the 2019 update and supplementary information for well below the minimum figure I consider necessary. Adding a 40% contingency allowance to the base cost for the RTS would only bring it up around the minimum figure, with no significant margin for additional costs that may well arise, such as structures or land acquisitions. Okay?
Yeah, I see that in the case of the 3 garden communities with broad locations and very limited information about infrastructure. Yes.
Those would be relevant considerations, structures or land acquisitions, yes?
Relevant to this case, yes.
Yeah, relevant to any case, looking at the cost of a future project.
Well, not necessarily. I mean, this isn't a like-for-like comparison. This is an inspector's report on an examination of a local plan.
Okay.
So I think we would need to know the entire context of the evidence that the inspector looked at before just picking out paragraphs out of this.
But do you not
this
agree as a
document?
general proposition, the structures that need to be delivered? Let's imagine that you do need a bridge in that section where the overland flow is.
We know we don't, but we do know the structures. We know that we've already tested the upper limit of structures that do need to be delivered and costed that. So I think we've come to that point off.
And the land acquisition, the land you don't control, would that be a relevant factor, do you think?
I don't think so. We've got a process built into Section 106, which includes CPO, and the CPO procedures are quite clear on those matters, and we would be working within the legal requirements of CPO.
Okay, so you don't see land acquisition as an additional risk factor with this proposal?
Mainly maybe to the delivery, but I think we've mitigated that through the agreement with your client on the CPO approach.
To the cost, I mean, not to the... Yeah, so you're hoping, obviously, the council, we can't bind ourselves in the same way that the borough council can't bind itself to what it does with its land. If it isn't able to reach agreement with the applicant, then we're in the world of a CPO, and obviously the decision to take a CPO will rest with the councillors, and my clients obviously can't say at this stage, can they?
No, but the CPO would be within the requirements of the CPO regulations. I think we'd agree that, and the requirements of the Levelling Up and Regeneration Act. So I think we know the framework we'd be working within.
Be a little bit careful looking at your phone while you're giving evidence. Sorry.
This is messages I've sent myself. I can happily show that.
Yeah, no, don't worry. I don't think there's a problem with that, but just best to avoid.
Just wanted to get the terminology right.
Picking up your phone and doing that during evidence. Yeah. Okay.
See it as a computer.
I'm fine with it. Don't worry. Just perhaps not again.
So we would be working within the CPO legislation, which has its own. CPO has rules and it has approaches to land value, and those are set out in the legislation for CPO. And we've agreed with Kent we'll be working within that they would progress the CPO if it's needed. So it's important to note that we're always working within the Section 106 requirements here. The Lura essentially from 2023 also has references in CPO as well. As Mr. Simon said, I'm not a CPO expert. I think we may have to provide some evidence on that.
Just get Mr. Pereira, I think.
Mr. Pereira, I was looking at whether to buy a copy of his book last night, actually.
He'll come back.
He went off to find a coffee, I think. But yes, so I listened back and noted that down. No, so yeah, but I think there's agreement between us on a way forward that, as you set out yesterday.
I suppose that wasn't my question. That's probably my fault. My question is about the fact that land acquisition and uncertainty about it is a relevant factor to the issue of the appropriate level of contingency, isn't it?
I don't think so in this case, no.
You don't think so? No, okay. And you say, well, follow procedures. Yeah, well, I mean, I hope we do it will, actually. I hope that Kent County Council, if they go down the CPO route in whatever year that is, they do follow the statutory procedures. You sort of expect that and all the guidance. But, of course, the actual value of the land or the actual issue of what the land value is for that land, we just don't know, do we?
No, but we know what CPO requires for land value.
Yeah, we don't have that. Okay, well, I can suggest to you that would be a relevant factor just in terms of the risk. And overall, what the inspector was doing there was talking about optimism bias. The National Highways, that is a phrase that they use. You're aware of that?
I'm aware it's a phrase used in business cases by across the public sector. So yes, okay. I presume it will be used by National Highways as well. Yeah,
okay. But Mr. Parks was careful to say, although there was a request to use that phrase was used, what he's described with not his 44%, the 10% is a scope risk, yes?
Yes, there was a 23% optimism bias in the version 1, which we know, and that was removed. And it was replaced by the scope risk, which was a 10% sum. Yeah, so we're nowhere near 44% here because we're not dealing with optimism bias, are we? No, but I don't know whether when you deal with optimism bias, you would also include the 15% and the 10% as well. I'm not an expert on optimism bias. Yeah, there's all kinds of issues that why it might not be appropriate to apply contingency allowance, and so we've moved away from that phrase. As far as the costs are concerned, could we take up the pink and the blue chart that is provided by your witness? Yeah, there was one. No, yeah, we can. I think we can. Yeah.
Where are we going now?
Core doc reference to it's the blue and purple, most recent blue and purple.
Yes.
So it's an appendix to Mr. Bell's appendix to Mr. Gearing's second rebuttal. So it's a core document 37.14.4a.5. Just to say again, 37.14.4a.5. It's the most up-to-date blue and purple.
So the pink and the blue.
Yes.
What we can see is, if you look at the junction 5A, Jackson's applied 5% risk to the construction costs.
Yes.
Yeah. Which I assume is a risk that the cost of materials and things is more expensive. Is that right?
It's a risk allowance.
A risk allowance. What does it? But the inspector may be interested. What's it relate to specifically?
I don't have that information.
Okay. And then the Jackson's contingency is 20%, yes?
Yep.
So together, obviously, that's 25%.
25%, yes, on
Yeah.
their base build cost for the
On-
summary
on the
vote.
37,997,000.
Correct, yes.
Okay. All right. And then in terms of anything else, that's it then. They don't apply any other contingency, anything else to do with risk or scope, do they?
They do not, no, but we have discussed previously that a number of the sums in the total non-construction costs are duplicated in the FVA, and there is a a contingency allowance of 5% in the FVA that relates to some of those costs.
Okay, if you look at Dadswell's figures, then their figure is 5% on the construction contingency.
10%. It was
Sorry.
5, it changed.
You're quite right, it's 10%. That's me reading across, yeah, and it was 5%. Mr. Parks was asked about this, and he said it was in relation to considering the project. You can look again at the top.
I remember, yeah.
Yeah, good. Okay. And this goes to sort of, the suggestion that there's no rationale behind this. The rationale is explained on the basis it's the nature of the project. If, for example, this was a project of smaller scale, if the timescales were clearer, if it wasn't such a long period, if there was more certainty, then the contingency the risk could go down, couldn't it?
It could, but just to counter that, all of those questions may be valid, but there was no difference in information between his first cost and his second cost that made that change.
Okay, well, he said the nature of the project. So he was getting information about the project, yes, that was being provided. And this is a difference between the revisions of his cost plan, yes?
Okay, so between the version 1 and version 2, when he spoke to our team and had more information,
Yeah,
the additional information of like you said, which would normally bring costs down, they made his go up.
yeah. But some of the information that Jackson's provided revealed that Jackson's didn't really have a good handle on some of the costs, did they?
So where he disagreed on some of their costs, he didn't adopt them and he put his contingency up. Is that the suggestion?
Yeah, because I think what Jackson's did was give rise to concern about the information they're relying upon, and the information they relied upon in many instances increased significantly. And all the time that Mr. Parks is working on this, he's getting more visibility about what Jackson's did and didn't do.
I understand that, but he didn't apply that contingency to the Jackson's costs. He applied it to his own costs.
Yeah, so his own costs are.
But he
the
was
costs-
happy with his own costs.
Well, he reduced some of his costs, remember?
Oh.
If you look at the blue.
So he reduced them
you
but added a contingency to them.
So just so you're clear, he did reduce some of his costs.
Yeah,
Did you not know that?
No, I did. I do know that, yeah.
And they had meetings and
I
there
know,
was
I know.
dialogue, and although Jackson's moved very significantly, the 1,000% and so on, there's also figures in there that were originally 20 million, reduced down to 16 million. So he was prepared to adjust that. But of course, in doing so, he's obviously thinking about the risk that's applied. And it's right, isn't it, that the risk that was applied by your client is a combination of risk and then separate contingency, whereas what he's described it as construction contingency, yes?
He's got construction contingency, and then beyond that, total construction, non-construction costs, he then separates out risk.
The risk figure, as far as Jackson's is concerned, is separate from contingency, isn't it? That's clear.
Yes.
Yeah,
Yes.
okay. Whereas he's talking about just contingency, and obviously at half the level. But then what he does is he also looks at other costs, professional fees, and so on. And I just want to explore that because he's applied 15% there, right? And in doing so, if, for example, the design of a project changes, okay,
Yes.
you're going to have to use the designer is going to have to make those changes, yes?
Yes.
And then there'll be a consequent knock-on in terms of the construction costs because, of course, not only do the drawings change, the actual proposal changes, the actual project changes.
Yeah, you could have the cost going up or down.
Yeah.
through
Now
that
there is an
exercise.
element. There is an element in here of us both wanting to make clear that there isn't double counting going on. That's going to be a separate note, and I don't want to trespass on that. What my instructions are, and obviously you can check this, and Mr. Mitford-Slade can check this, is that when there's items in terms of the road costs here, then there hasn't been an addition of fees in relation to that when they appear here. Okay. But again, it's one of those matters where I think the experts should be applied. So that's why I've applied it, because the risk allowance, because then the design changes, the project changes, with utilities, for example, or the construction changes, the utilities, what happens at the junction, Grovehurst, how could I forget that without the S? Grovehurst, is that the utilities became an issue. Is that right?
They did. I think my understanding is we're working on the SRN, and utilities are run alongside the SRN, and they are widening the SRN. So utilities are going to be a fairly significant issue there.
Yeah, okay. But the utilities were an unforeseen issue in relation to that project.
It appears so. I mean,
Yeah.
whether that's where that blame lies, I think, why was it an
I
unforeseen
definitely
issue?
don't want to get into that, okay? But there we have it.
I think
okay?
the point I'm making there is obviously you've agreed we're on a greenfield site, and we would have to do a lot of utilities work up front before commencing development, so that may not be an issue we would face.
Commuted sums. Now this is slightly curious in this drawing because they appear in the total at the bottom as being included, but they're excluded, or they're included in red for the KCC. So they're included for National Highways Junction, but they're excluded, hence they're in red, or for Mr. Simons, that they're
Just to
the
confirm
15 million.
15
okay.
and 1.5.
Yeah, and those two actually do appear in the bottom line. Yeah,
They do. They're highlighted in red because they are points that in my proof we are raising concern and challenge to, which I addressed in my editor in chief.
Now, you raised a number of things about that. First of all, you raised the issue about that the money might not be ring fenced. In other words, if you, Quinn, pay a commuted sum, then it might be spent doing potholes in
Probably quite
Faversham.
likely, yeah. Yes.
Likely, you think?
Oh, I don't know.
Yeah, you do realise that the solicitors, it's not beyond the wit of the solicitors to draft terms which require the commuted sum to relate to the project for which it is sought.
I mean, I'm referring to the adept guidance that your client relied upon and appended.
Just try and answer my question if you can. You do realise that the solicitors can draft it to make sure that the commuted sum relates to the projects which we're talking about.
I should think so. Yes. I mean,
you've worked in local
authority.
authority.
If so, are you suggesting that under the Section 38 agreement that would be something Kent would look at? Because obviously
I'm
we haven't
suggesting
heard that
at this stage you make a commitment to paying the commuted sums, that it appears in your Section 106, and in so doing, because the sums can't be agreed, you make the commitment, and equally my clients need to make the commitment that the money collected as commuted sums would only be spent on the basis of the projects to which it relates. That would be a fairly normal thing to do, wouldn't it?
I don't know if it's a normal thing to do because I'm not sure if it's been done before and it's not been suggested before, but I think in my proof I've suggested we need to discuss commuted sums in more detail, so that kind of discussion sounds welcome, yes.
Yeah, I mean, it seems to me that, I think we've been fairly clear that the commuted sum figure can't be calculated, and indeed Mr. Birchall said he anticipated it may well come down.
But the figure that's in there is the one you did calculate.
Yeah, absolutely, because we've got to try and produce something. And
you didn't have to produce a commuted sum at all.
No, we didn't, but we have for the viability exercise because you need a figure, okay?
Yep.
In the same way, everybody's tried to cost your road just on a concept. But in terms of the commuted sum, a commitment in the Section 106 could be made by your clients. Are you resisting that?
I don't mind that being, but I wouldn't. I'd prefer, if it's all right, to come back to that question with our 106 team in the room. As in by that I mean the partner at Town Legal who's working on it. Happy
Well,
to,
Happy to answer that.
happy to have the
on that
debate,
basis,
but I do
if
want,
that helps.
I want her input, and she's
Well,
not here.
commuted sums is on my list to discuss. So.
I think.
No, I mean, we can
It's on
talk
my list to discuss on Friday.
on Friday. No,
Yeah.
that's what I'm saying. I'm saying we do need to talk about it clearly. I just want to be careful about talking about it too much without her here, but she'll be here on Friday, obviously.
If you're comfortable, I think my answer was going to be, I think that's a discussion point on Friday. Is that okay?
Yeah.
Is that okay? Is that
however
okay
we
for me to
arrive at
defer
it,
that
if
forward?
you want to do it on Friday, we'll do it on Friday. Luckily, all our team will be here as well, so we can talk about that. But just tell me, okay, all right. Well, we can perhaps park a lot of that issue. Mr. Bell can start warming up his pencil in a minute, because we're getting through the issues quickly. Yeah, okay. So just in terms of the commuted sum then, we obviously have guidance, and in the technical document that accompanies the design guide, the Kent Design Guide, there's reference to commuted sums, isn't there?
There is, yes, I refer to it, and yes, the appendix.
The ADEPT document.
No, so the
Kent
appendix
Design.
before that.
Okay.
We could. Is it worth going to? I think it might be.
Well, I'm trying to just get to the point about where we establish whether we've got any guidance on it.
Okay.
There is guidance that specifically refers to commuted sums, isn't there?
There is, yes.
Yeah. And highways is included in the topics that are relevant to that.
Certainly is, yes.
Yeah. Okay. Your client, you, Quinn, if I can put it that way,
Yep.
have made commuted payments on other projects. Is that right in Kent?
Yes, and I think you'll see in my proof of evidence I've said we would expect to be making commuted sums on the usual state roads and others, but we were querying the strategic roads.
Okay, and I think part of your case, I mean, turn the guidance up if you want, because I think it's the wording that you've been looking at, refers to the sort of nature of the project. So if you get to, Madam, if you go to Mr. Birchall's Appendix C, he's got a big set of appendices as well, and if you go within that to...
It's 39.5.2, Mr. Birchall's Appendix C, but it's the one where you will remember a couple of times you put in a post-it note right at the back, because it is right at the back of a big old bundle.
There's about 10 pages from the end.
From the end, but the inspector has been there before a couple of times. It's 39.5.2. Sorry, I'm just telling Mr. Gearing.
39.5.2.
2, and then
Yeah, thank you.
PDF 264.
So it's Appendix C. So it's 2 in from
So,
what's this thing? It's saying legislation at the top.
so the page before says the Kent Design Guide, Making It Happen, Technical Assessment and Adoption, Commuted Sums. And my assumption is this is the 2003 KCC policy on commuted sums, but it's not clear. But I did drop an email to your client to ask that last week and didn't have a response, but I think that's the case.
Yeah, I'm sure you're right. I'm sure we'd be looking at the right thing, but if we're not, you can just point that out. And if you look at background, the need for paying commuted sums can be divided into 4 broad categories. And then I think under this category that you may be asked to pay a commuted sum, it said alterations to the existing highway network carried out under Section 278 agreements that are required only to serve the development and provide no general public benefits. So if you're making an alteration to the public highway network, I mean, in truth, what you're doing is building new roads, aren't you?
Yeah, I think that's very true. Yeah, the majority of our works are under Section 38.
Carried out under Section 278. So if we go to the Section 38 section, highways generally constructed under Section 38 agreements where additional adoption areas and construction materials, the result from the overall development layout, are over and above what would normally be required to satisfy safe and operational requirements, yes?
Yes.
And you rely on that to say, well, look, that is under section 38, and it will be adopted, and only things that are sort of over and above the normal, yes?
That's what the guidance says.
Yeah, so the bridge structures, if they're, you have to remind me, are they actually going to be any bridges in the end?
We don't know yet, do we?
Okay, we don't know.
So, well, there are certainly be 2 bridges at least. So there's a bridge over the Northern Relief Road, there's a bridge over the M2, and then in specifically about the culvert or bridge structure, that may well be a bridge, it may well be a culvert, because we need the detailed design.
There was discussion on instruction, I hasten to add, about a bridge for the public rights of way that Mr. Ruskin raised. I think you're going to
Green Bridge.
You're going to put a blue plaque up if it appears. I hope. Yeah, it's just he identified a bridge. He talked about a bridge. There were discussions.
There is the other. There are
bridge.
the other bridges along the road that have all been agreed. So yes, there's the other green bridge. The actual one that forms part of the highway design is agreed. Yes.
Okay, so
these are structures that are part of the road. Yes.
Yeah, so they are. That is a bridge. Yes.
Yes, essentially it's a bridge that provides the access over the road.
Yeah.
Yes.
There's no. Is there in the section 106, and you may not know, is there a commitment to actually build that, or might it end up as more level crossings?
No, it has to be built because it's the access on and off the road. So you wouldn't be able to get in or across to the science park without it.
Okay, so it's not a pedestrian bridge.
No, it's a vehicle and pedestrian bridge.
Okay, you described it as a green bridge, is that right?
Yeah, it has this was through, I think, Mr. Wild, and a long, long time ago, Mr. Sutherland spoke about this with Mr. Murdoch. So there was some detailed design work that was done through the design review process. We also discussed it in the ecology evidence.
So there will be that bridge.
Yes.
Yeah, so that is a structure.
Certainly is, yes.
Yeah, okay, and it's bridges which are not the normal course of route for a road, which is precisely where maintenance payments, commuted sums are required, isn't it?
Yeah, though I imagine if you do need a bridge as part of a road, it is essentially essential to that road. But this is a discussion for future discussion via the Section 38.
What I mean is, I'm just trying to understand your resistance. So if it's about, the surface of a conventional road, then that might not fall into the category, or wouldn't necessarily fall into the category of normally required to satisfy safe and operational requirements. But once you start building bridges, then that is something more unusual. It's significantly more expensive, and it has ongoing maintenance requirements, doesn't it?
I wouldn't say unusual, and if it's needed to satisfy the safe and operational requirements of the road, then it's literally in line with what that says. But your point about it may have features, for example, like the green bridge element, there may be features of that bridge that are unusual. So I agree with you on that point.
Okay, now in terms of the relevance of the commuted sums, if you do include those, then we get to a difference between the parties of £150 million. And I just want to be clear about a couple of things.
So just to confirm, we have included, so our 229 million there does include the commuted sums. I guess you're saying if we took them out.
If you took them out, yeah, because I understood your case to be, but certainly it was said by Mr. Simons there was an objection in principle and to the calculation.
Well, it was, I covered that in my evidence in chief. So firstly, the guidance that you refer to says...
I'm really sorry, it's my fault, because I didn't ask a question, that's my fault.
Oh, sorry.
You are objecting in principle, aren't you?
Yes, in part.
Yes, yes, in part.
Because your client's proof of evidence says commuted sums are required, and our view is the guidance says may be required. So there's 2 different points there. That is a point of relevance, I think. Yeah. And secondly, we've made the case why that this is a strategic piece of infrastructure that delivers wider benefits, public benefits. Yeah, and I'm going to come to that as a separate issue, but I just want to be absolutely clear about your case, okay? That's all fine. A lot of this is just trying to do, really, is just be clear. Does the inspector report to the Secretary of State that, in principle, you oppose the commuted sums, yes or no? The commuted sums given, or the principle of commuted sums?
Principle of commuted sums.
I think we have object to the principle of them for the strategic roads, yes.
Yeah.
But
Okay.
we have said we were willing to discuss that further with Kent.
Okay, so at
I
the
think that's
moment,
important. It is caveated.
yeah, okay. Well, at the moment, it's object, and so we would take those sums out. That gives us the £150 million difference. So, in terms of addressing that issue, we've already looked at the consequences of that. It would obviously, make the schemes completely unviable because it would eradicate all developer profit. This is leaving aside entirely the issue of what Everett says in the land promotion agreements. But
I'm sorry. So we have our FVA does model your commuted sums within it to show the development is viable if it did have to pay those with our costs.
no, not just the commuted sums, the £150 million.
Oh, sorry.
Okay,
We
we agreed
sorry.
that yesterday about the consequences of that. Now,
Yeah,
I
we
just
did
want
go
to-
into a
just-
bit of detail
just
on the
let me
Northern
ask the
Relief
question.
Act,
So, that £150 million apart.
You're being a bit slow here,
If
but
you look at the blue and the pink diagram from
Yep.
their witness, there's 366 million against 229.9, so 230 million.
It-
Okay, but included in that is the contested, I think, about 17 million of the commuted sum, 16.7 million. If you deduct the 16.7 million from the 230 million,
Yep.
then obviously the figure reduces and the gap between them is around 150 million.
Absolutely correct on the maths and fine to do, but all of our numbers have assumed that those commuted sums are paid, all of our financial viability testing, all of our costs planning. So, I mean, but we can obviously, we can make that number bigger.
And I know you said 150 million apart on that basis, but you've also said literally the sentence before your numbers may be lower. So it's a range, right?
These are the difference in the figures, okay? And I just want to be absolutely clear about your case, right? £150 million difference, and if you exclude the commuted sums, and you've just agreed with me, the position is, do you object in principle? Yes. So the inspector knows the scale of the difference. If you want to come to the table and talk about that more, then that's fine on Friday, right?
that
I'm not-
150, sorry to interrupt, but that 150 million
Yeah.
is the difference between 366 million and 229, isn't it?
No,
Oh,
no.
it's not. That's the problem. He's
doing.
doing Mr. Young's doing another
Oh, I
subtraction.
see, and then doing the other subtraction.
So if you look at
I
the
see, okay.
15.1
Yeah.
million and the 1.6 million together, they add up to 16.7 million.
Yeah.
And then just to simply do the maths, because it's not on this chart, 229,952,465, and crucially 42 pence. And if you deduct from that 16,700,000,
So we.
you get a figure of 213 million. You've heard this figure before.
Yeah.
252,000. I haven't worked out all the various decimal point places or the lower figures, but just if you work on the basis of 213 million, and then if you deduct 366, deduct 213 from 366 million, you get 153 million. That's the difference if the commuted sums remain out of it. I appreciate my friend's point. They've tested it and looked at that, but what we're talking about is the headline figure, and based on the previous answer you've just given. Okay? Now, with that, it makes it unviable. We made that clear yesterday. Part of your case, which I have genuinely struggled to understand in light of what you and Mr. Simons have been saying through the inquiry, is this. Are you saying to the Secretary of State, to the Inspector and to the Secretary of State, if Kent are right, if the road costs are more than we've suggested, not obviously the whole 366 million, but they work out to be more, then we will absorb that by a commercial view about reducing the developer profit below the 15% that's been agreed in the Statement of Common Ground. And just a yes or no on that, please.
So, yes, but also
we wouldn't. You're looking at this as a singular issue. We may, as Mr. Mitford-Slade set out, there may be other. If cost inflation, there may be sales values increases that may generate additional.
Just leaving it as it is now.
On a pure basis of if the road costs were higher than we put in our work, so in our FEA.
Yeah.
If it turned out that the road costs were higher, obviously the affordable housing is fixed, the Section 106 is fixed. How would we, the master developer and the landowners, fund that?
Yeah.
If nothing else changed, that's what you're saying. Nothing else changed.
Yeah.
So I'm saying there would then be a commercial decision on the two applications, obviously two different applications here, of what to do.
Yes. And the question was, the variable is you would reduce the developer profit, yes?
That is a variable, yes.
Yeah, well, it's the variable because you can't change the affordable. You made that clear.
Yes, yeah.
It's only the variable on the assumption that nothing else changes.
Yes, yeah.
I mean, so to make the question fair, it's the variable on the assumption that nothing else changes, like values or anything else.
Yeah, and that's what.
So we haven't, it's good.
You do an FEA on the basis of the information at the day you're looking at it.
Yeah,
so what you don't do, forgive me, is you start changing everything else or thinking changing everything else gives you an answer. You just work on the figures here. The Section 106 fixes the affordable housing, doesn't it?
Yes.
The Section 106 fixes the cost of the education, doesn't it?
It does, yeah.
Yeah. It fixes the other contributions, yes?
Yes.
They are hard edges to your case.
Yes.
Yeah. So the only two things that can change, if you keep obviously all the costs and all the sales the same and try and be clear in what you're saying, is you can lower the developer profit, yes?
So if I don't change any other item, so
We've
fixing me, so I can't change. So the earthworks costs nothing's changing. Just one thing we're looking at here for your purpose of your exercise.
Well, obviously the earthworks have changed because all your costs have gone up because the inspector prefers our evidence from our cost consultant to yours. So of course all of those have changed. But if those costs correspond more with our costs, then the only two variables that are available are the developer profit, yes?
So I need to go back. So can we open up Mr. Mitford-Slade's
you can do.
figures?
You can do
I just think it's useful because if we open...
It is, because I wasn't clear about your
CD
case.
13.5.
Any clarification you can give would be welcome.
So can we? So what?
CD 37.13.5.
Right. Okay. Just a minute. Just a sec. Let me just clear this out of the way. Right. Hold on. Okie dokes.
So I just want to check, you're assuming here that, because obviously we've got the cost in here of 111 million for the 6 kilometre road, the 49.575 for the junction. They're the road costs, but also in here we've got allowances for strategic FOW, strategic green infrastructure, site-wide ecology, utility infrastructure, site prep and enabling works, internal roads, archaeology, sports hubs. So in your assumption, all those costs are net exactly to that sum, so we don't have any wriggle room in any of those numbers there. That's your assumption here.
No, there wasn't how I put the question, but I am keen to get an answer.
You were telling me
I'm just trying to understand if the costs go up, you've got nowhere to go. You're fixed on, forgive me, you've got 15% as the developer profit. You've got fixed Section 106. You've got fixed affordable housing, okay? And then you've got your costs, obviously, and your revenues. And then what we say is if the road costs increase, okay, they might increase by 20 million, 50 million. They might increase by 100 million. If those those costs increase, then there's only two sources of information on the available viability appraisal at the position now that you can rely upon. One is the developer profit. And I have to say, it was said by Mr. Simons that in the real world, a commercial decision would be taken about the developer profit. Okay, so just help me, please, with if that is your case. Are you suggesting additional road costs would be absorbed by a reduction in the developer profit below the figure in the statement of common ground?
I'm suggesting they could be. However, there's £339 million of construction costs there. So we're working on a very large site. You know, your road costs may increase by 10 million. Your site-wide ecology costs may come in at 6 million. There's a 4 million over allowance there.
That's not the question. The question is
well,
to understand. Mr. Simons, please, just you know how important this question is. Just try and let that. You must do that. You have suggested several times a reduction in the developer profit, and to be honest, it would be easier to nail jelly to the wall to understand what your case on this is. Please just focus on the question, okay? The question.
For the question to be fair, you need to put it. You need to tell him. And he's asking you to clarify it, and for some reason,
let's do that.
No, he has asked you to. Is your assumption in your question that is apparently very important? So let's clarify it. That he is to assume, for the purposes of your question, that nothing else on this whole sheet of paper changes other than your road costs.
Yes.
There we go.
Okay. So on the assumption that everything else we've costed at that point is fully in line with this. I can't touch any of these other allowances towards the road, even though I could.
Just a yes or no, honestly. Even your barrister just put it in a straightforward way for you.
But it's
just try, really try.
No. So let me
just a yes or no to start with, rather than all the preamble, because the Secretary of State probably wants to know the answer.
So as I said last time, yes. Profit would be one of the things you would consider if you reach that scenario, and that would be a commercial decision to make after in the round. But you would be in that would be of the basis of wider construction costs, and there's also, as we discussed and Mr. Verstade said, there are opportunities that if build costs go up, sales values go up. There's all sorts of. This is a point in time financial viability assessment.
It does tend to have to be, yeah. So
exactly.
So when Mr. Simons referred to the real world, and when he refers to commercial considerations, or you refer to commercial consideration, what the Secretary of State can note is if the costs are assessed as being greater for the road than you anticipate, then the appropriate way to address that issue is a reduction in developer profit.
That wasn't the question you asked, and it wasn't what he said.
I don't even know if it's. Sorry. I'm not even sure if that's is a planning matter for the Secretary of State. I think that's. I don't know if that's the Secretary of State can look at. Just
please, okay, just focus on this. I've got a yes to my question, and you said, well, it all depends, all right? Yes. What is your case to the Secretary of State if the costs of the road are more? Is it? Well, we will reduce the profit. You've said yes, but then you qualified it. You need to be really clear to the Secretary of State that the funding, if that scenario exists, okay, the funding is coming from a drop in developer profit.
I think
because that's how your case was articulated.
You're asking a question, an assumption that maybe isn't for the Secretary of State to answer.
Okay, so
I don't know if I can answer that, because you're saying the Secretary of State's going to ask the question that you're putting. Yeah, it's not my role to decide ask that question.
No. The position is the inspector is reporting to the Secretary of State. Yeah.
Yes.
None of us can know, first of all, what the reporting will say, because that's all to be determined. But the inspector is obviously considering both parties' case. She may think, for a variety of reasons, the costs of identified in Mr. Parks' evidence is to be preferred because of various different factors. If she prefers that, then you are unviable on the basis of the 15% profit. However,
just to take you back a second,
your
assumption there is that the Secretary of State, the Secretary of State should be looking at our costs.
No, it's not ours.
We're the applicant.
Oh right, okay. So it shouldn't look at anybody else. Shouldn't look at Mr. Parks' costs.
We're content with our costs.
This is interesting. You're saying the Secretary of State shouldn't look at Mr. Parks' costs.
Well, this isn't planning.
Just a yes or no on that, please. You're saying the Secretary of State shouldn't look at Mr. Parks' costs.
Well, I said I didn't know if the Secretary of State should be looking at Mr. Parks'
but that's how you've approached this whole case, isn't it? There are only your costs because you're the developer.
Well, if we can go back to the. Yeah, sorry about that.
So just into.
did say there'll be two variables, so I presume the second one is funding, is it? Is it?
The second one is the landowners.
Oh, I see, right. Are you going to go on to that?
Yes.
I will, yeah. Would you like me to go to that now?
Well, I don't think you're going to get any more.
No,
actually.
I agree.
Thank you.
Okay, all right. Thank you. So the other thing is that the landowners are obviously part and parcel of this whole proposal, aren't they?
They are, yes.
And what you've said is there aren't two sales, in effect, that if land is sold, it would be sold directly from the landowner to the house builder.
The plot purchasers, yes.
Plot purchasers,
yes, yeah,
it's a
but
better-
house
better
builder, plot
phrase.
purchasers,
Okay.
I think that's interchangeable.
All right. As a consequence of which, the landowners, if the profit for the developer doesn't change, if that's fixed, or the developer isn't willing to reduce the profit, then the landowners, their figures could be reduced as well, couldn't it? Their expectations could be reduced.
I think that's a commercial matter between
Okay.
the master developer and the landowners.
But you haven't contemplated that scenario.
In what, on what basis?
The idea that the landowners get less because, well, I haven't seen your contracts, and your contracts, I don't know whether they set a minimum land value, but if the landowners have a minimum land value, then I presume you can't go below that, can you?
Well, we've said that we're not
I think
getting
these
the
are
promotion
commercially
agreement,
sensitive.
aren't we,
I
really?
don't understand.
I was going to say these are presumptions, and I'm not commenting either way. So, yeah.
The opportunity was there to provide the promotion agreements. You don't have to. Nobody can make you do that, and so that's not being provided.
We made clear an answer on that yesterday.
Okay, and we're not going to know. So we can't obviously anticipate any difference, and the figures that the landowners get in the exercise that we've looked at is to make sure the residualised price is greater than the benchmark land value. Yes.
That's how the FEA works to ensure that the level of affordable housing and contributions is correct based on all the inputs.
Yeah, but obviously that doesn't tell us what if any minimum land value it is. It just says it's a benchmark figure.
It's exactly that. It's a benchmark figure for the purposes of an FEA.
Yeah. Okay. Good.
It's a fairly standard figure.
Just a couple of things about some of the other sites that are talked about. So Chilmington Green, you've commented on that.
I commented in response to your comments, but yes.
Yeah. So Chilmington Green is a smaller development than this. Is that right?
Not massively. I think it's between 6,000 and 7,000 homes.
6,000 and 7,000. Okay. And Ashford in Kent, is that right?
Yes, correct.
And the position is, the point of distinction you made is that the landowner or the developer bought the whole site.
Correct, yes.
Yeah. And the application that's been made, obviously in terms of removing Section 106 contributions and other obligations, isn't the original planning permission. They're exercising their right, which they have, to seek to remove those, yes?
Yes, I understand that 5 years after planning permission is granted and 106 is signed, that right doesn't exist before.
Yeah, exactly right. And so as a consequence of which, that developer who effectively had bought, I don't know if they bought it, but they got a planning permission with various obligations, and then they are now seeking to get out of those obligations, aren't they?
I don't know the detail. I think they were a part of a number. There were a number of parties together that sought planning permission. So there was a group, a conglomerate, whatever. They got planning permission. One of the parties, which is Hodgson, had to or chose to buy the others out. So they essentially bought the land. So they now own all the land. They've submitted a Section 106B, I think you said, application, which is, as you said, they're perfectly entitled to do. And I think that, I don't know if that's to get out of contributions or to reorder them or make other change. I don't know the detail. But from judging from what's been discussed, a lot of it's to do with the bond requirement, I think, to do with the A28 works.
So is it the case that that is a large site that got planning permission with various obligations, but now the developer is seeking to renege on those? Is that a scenario? Is that the scenario we're talking about?
It does appear to be that case.
Yes.
Yes.
Okay.
Yeah.
Looking to see whether a proposal is viable at the point of planning permission would obviously help to overcome that problem, wouldn't it?
It would, and that application I don't think was subject to viability work, but obviously ours is.
Yeah, and you make the point. Look, Kent haven't been looking at this before, but they've chosen now to look at it. They've got some issues arising on other sites. Kent County Council want to avoid problems in the future, so they're taking proactive steps. Otterpool Park, now that is one obviously you know about.
Yes.
That was identified as an allocation, is that right?
Yeah, so it was promoted by the council who purchased the majority of the site. They then worked it through the local plan process. At the same time, it was working through the Garden Communities programme with MHCLG.
When was it broadly? When was it allocated?
Between 20, I think the local plan was adopted in 2021, maybe, or 22, but the allocation work started in 2016.
Okay, and that site, as I understand it, unlike Chilmington Green where they started building the houses, Otterpool development hasn't started, is that right?
That's correct.
Well, again, one of the issues and why Homes England are involved as well as being a landowner is there are viability issues about delivering the site, is that right?
I understand there's cash flow, but it's a viability point, yes.
Yeah, okay, all right. So again, that would be another reason why Kent County Council, who obviously is the beneficiary of things like schools and contributions, might want to be and want to understand viability at the planning application stage. It hasn't reached the planning application stage.
No, it's got a planning application that has a resolution to grant already.
Oh, okay. How long has it had that?
2 years.
2 years. Okay.
Maybe less, but yeah.
And so the cash flow in.
It's had a resolution to grant, but they haven't issued the permission.
Yeah, because the Section 106 isn't signed, and
That's
one of the
right,
issues is the cash flow and the overall viability of the proposal.
Yeah, and I think actually, just picking up on that point, I think that partly relates to the phasing of, for example, KCC infrastructure. So it's, important, I think, to make sure that that is considered.
Yeah, it's so important at this stage, really, to consider things like phasing, grampian conditions, cost of infrastructure, all very relevant factors, yes?
Well, not just this stage, probably going back a couple of years.
But,
yes.
but at this stage, it becomes important.
Predetermination of the application, do you mean?
Yeah,
yes.
And in the context of the decision-making process on the application, it becomes to be honest, looking at Otterpool Park and looking at Chilmington becomes an important consideration.
Yeah, and it's an important consideration here.
Okay, thank you very much. Just a couple of points. In the Section 106, you highlight this in your proof. What will happen with the road is that there needs to be security secured before the road proceeds. Is that right?
Yes, I think that's the drafting of the 106.
Yeah, and I think in fairness to you, that that is a point which goes to, well, before the road work starts, then if you've got the security in place which reflects the cost of the road at that point, then you wouldn't end up with a road with a mile missing at the end. That's the purpose of the security.
I think that's exactly the purpose, yes.
Yeah, it isn't about the viability per se, because the viability is, looking at all the cost and figures. The security secures the delivery at the road at the point where the delivery is going to take place.
Yes, by that point, we would have had a detailed design, reserved matters approval, technical approval, all the risk. All that work. We would have costed it, contracts in place, you're ready to go, you're making sure you've got the securities in place so it can be done, yes.
The risk profile would be completely different, yes?
Yes.
Yeah. It'd be, a million miles away from where we are now, because, of course, the risk profile would be with all of to build it, with all of the relevant consents in place.
At that point, there is less risk, yes.
Yeah, good. Okay. All right. And we understand then the security. It's right that Mr. Birchill, I don't know why I'm pointing there, that's where he was sat. Mr. Birchill
Ghost is still there.
didn't get into that, and the inspector observed, he hadn't read the Section 106 to get into that. But that wasn't about contingency. That was about security delivery. Now, in fairness, he did raise a concern about the road not being built. And the only thing that would stop that once you've got the security is, for example, if the costs increased significantly above the level of the security. That's the only real risk there.
So I think the discussion with Mr. Birchall was, had he considered the fact that the 106 allowed that, because
allowed the road essentially not to proceed until all these measures have been met, and therefore risk would be reduced, and therefore why are you accounting for so much risk at this point? And that was the question that was put to Mr. Birchall.
Okay, so,
and then, sorry, could you remind me of your question?
yeah,
second
so the
part?
question is, Mr. Birchall was talking about the position of the road not being finished, okay? And I would suggest to you,
reputational
if
risk
you've got the
cases,
security in place, right, which is not to do with risk now or where we are in the project, but the security in place, you're about to build the road, Quinn are about to go ahead, and the only thing that would really affect it then is if the security wasn't enough, because actually the road ended up costing a lot more in the time frame of building the road.
From a Section 106 point of view, yes, I highlighted earlier in my own evidence in chief that you'd have all sorts of also commercial requirements tied up with banks and
Before
plot
you-
purchases, but let's not worry about those.
Before you started. I do
Yes,
get your point on that, okay? And then finally then, please, just back to this profit issue, I'm afraid. The profit issue, it is right, I want to put it to you fairly, that there is no written evidence from you about what level of profit your clients would accept or tolerate, is there?
Correct. Yeah, there's no written evidence on that other than the FVA.
Yeah,
and the work in Mr. Mips's
and the
work.
FVA and the Statement of Common Ground says 15%.
It does, yeah, for
Yeah,
the purpose
okay.
of the FVA, yes.
So the Secretary of State can't record, well, this developer would accept, a lower level, 10% or whatever, because that's not evidence you're giving.
I'm not sure if the Secretary of State will go into that.
Okay, all right. Thank you very much indeed, Ms. Gearing. Thank you.
Right.
I went quickly. Oh, sorry.
Yeah, I'm quite happy to carry on. I've kind of trimmed down a bit, so it might be about an hour and 15 minutes a bit.
Mike. Sorry.
Could we have a break after about half of it, do you think? Yeah. All right then, thank you.
So, good afternoon, Mr. Gearing, at last.
Good afternoon, Mr. Bell.
So, I'm not going to repeat, or try not to repeat, some of the points that Kent have put to you. There is some overlap, and a couple of my questions may seem a little repetitive, but broadly speaking, I think I've cut everything out. I want to start off by looking at some of the experience that Quinn has, and this relates to some of the points that you've raised in section 2 of your first rebuttal.
Okay.
And some of the projects you discuss within that. But just before I do so, one of the things that my clients have become interested in is quite what experience Quinn has in respect of compulsory purchase and the costs involved. Has Quinn ever had to seek compulsory purchase to be made by a public authority in any of its projects?
Not that I'm aware of.
And in respect of an understanding as to the costs involved in compulsory purchase, does Quinn have any experience of that?
Not that I can answer. I'm aware of, no.
Thank you. I want to turn now to the new town works, which I think it's the Ashford site that you talk about in paragraph 2.2.
Yes.
So my clients are aware of this site, and I just want to be clear. Is this the site that's coming forwards with the Ashford International Development Company?
Yes, so if it's helpful, I can provide a bit of background to the site.
That would be helpful.
So the site was previously first granted planning permission to Kia in 2004. I was actually working at Ashford at the time. So they were granted permission for a mainly residential scheme on the site. They built out a small section of the site for an affordable scheme. They then essentially mothballed the site. It went onto the market. Quinn Estates bought the site. We put a planning application in and achieved planning permission on the site. I can go into that in a bit more detail as well. And following planning permission being granted, the site a joint venture was set up with Ashford Borough Council, which is the Ashford International Development Company.
Thank you. In terms of the planning application that was put in for the site by Quinn, is that the application that includes a film studio?
Correct, yes.
And in terms of the film studio, the intention was, I think, was Netflix interested in?
Yeah, we were working with the Creative Improvement District Company, who owns studios in Twickenham and in the northwest. There was discussions with Netflix. Essentially, that's the case, yes. So we're working with them.
So it's kind of residential with the film studio.
Correct, yes. The residential element, I think it was 302 flats, which related to the conversion of the Grade 2 listed locomotive sheds. There are also engine sheds on the site, so a number of listed buildings.
And in respect of that application, was it envisaged that the film studio would bring forward some benefit to the area?
It would bring forward employment benefit. The site's actually allocating the local plan just for residential, so actually it was a departure application, but yes.
And was the idea that the film studio should in some way kind of be used to help fund any of the residential, or was it completely stand or fall by itself?
So the application was subject to viability assessment and essentially shown to be unviable because of the high costs of redeveloping the site. So from a kind of standard FVA point of view, it wasn't viable, and that was always known when it was granted planning permission.
Now, in respect of the studio, it's not envisaged that's going to proceed anymore, is it?
No, there's been a recent press announcement from AIDC on that basis. There's been a number of years of looking into it. The UK film studio market's really fallen away. There's been tax incentives taken away. There's been the writer's strike, COVID, etc. So essentially, the film studio market has not done so well, and there's been quite a few well-documented examples of other studios that have been granted permission that are no longer proceeding.
So as a proposal, the film studio no longer viable at all in a scheme that's already kind of been judged to be.
Well, yeah, I suppose there's no market demand for it at the moment.
And how was that scheme to be funded?
So it was a combination of private funding and it achieved levelling up funding that Ashford Borough Council led on. So it achieved £18 million of levelling up funding from government of a grant.
Are we talking about the whole site or just the film studios?
The whole site, I think.
It does relate to the whole site,
part
yes.
and parcel. And in terms of private funding, was that in the form of a loan from Ashford Borough Council?
Yeah, there is a loan from Ashford Borough Council to the company AIDC. That's public knowledge.
And do you recall how much that loan was?
I don't recall that amount.
In respect of the studio disappearing from the proposal, if that is what happens, I think there's an application going in or has gone in.
So I haven't got the most recent press report in front of us, but from memory and from my own knowledge of the site, the proposal is to relook at a residential-led scheme on the site. The conversion of the locomotive sheds has also been caught up by nutrient neutrality, because although it was granted permission and then implemented, the High Court challenge that affected conditions as well meant that site then got stuck as well. So you had a situation of large amounts of funding having been spent on archaeology, on-site drainage, decontamination, brick cleaning, repair works to the listed buildings. All of that work's happened, but there's no ability for any houses to be occupied because of nutrient neutrality until a solution's in place.
And in terms of the levelling up funding and the loan from Ashford Borough Council.
So just to confirm, Ashford Borough Council are the majority shareholder in that company?
So they've got, is it right, of the company, they own 65% and Quinn owns the rest?
I'm not sure of the exact percentage, but it sounds about right. Yep.
Okay, so in terms of levelling up funding, does the loss of the studio have any impact on that funding?
Not that I'm aware of.
Thank you.
I don't know the answer. Yeah, that's.
And so that's an example of a scheme that Quinn has taken forward and is aware that issues have arisen in terms of viability. And so would you say that Quinn have a good understanding of what the additional costs are when things go wrong?
So it's a scheme that was shown to be unviable when permission was granted, and in partnership with Ashford Borough Council, government funding was sought to unlock a brownfield site. So yes.
I want to talk about.
It was unviable when the planning permission originally was granted, you mean?
Yeah, so the financial viability assessment showed that essentially it couldn't deliver a land value because of the cost of doing the work. So essentially from a standard viability point of view, it's shown to be unviable. But obviously that doesn't preclude the granting of planning permission. And then the 106 agreement includes a number of clauses that if the values and the costs are lower, so essentially it's like a kind of reverse, essentially clawback clauses. So for 106 sums. So if it would cost less to deliver the scheme and the sales values are higher, there's a viability review mechanism built into that 106 that would recover some Section 106 costs.
And so in effect, kind of embarking on a scheme that's already been assessed as unviable, was it a bit of a gamble for Quinn to be taking that forwards?
We didn't embark on that scheme. In terms of building it, the scheme started once it was an AIDC project with levelling up funding. So no one commenced development on a scheme without having that funding in place.
So coming back then, just so I understand, so the scheme that was unviable, was that just the residential scheme? Not the application that Quinn put in?
The residential and studios was shown that essentially it couldn't generate a land value because of the cost of restoring listed buildings are very high. So it would still generate profit, but not to the levels that would normally be expected through an FVA.
The Sittingbourne street works were discussed yesterday, and I think these are the works that kind of involved, is it realigning the A2?
The Spirit of Sittingbourne project.
Spirit of Sittingbourne.
It's known, yeah.
Thank you. And I think, is it right that Quinn's role in that was focused on the highway works?
I think we did more than just the highway works, but we were involved in the project, yes. So delivering the project.
So was there a contractor, is it Erith or Erith, one of the contractors?
Yes, Erith were a contractor. It was most of these works were being delivered when I first started working for Quinn, so I think 2018 is about right, 2018, 2019. And I recall Erith being mentioned many times.
And so just to understand Quinn's role in that, so Quinn were overseeing the works and Erith was a contractor that Quinn had engaged?
Yeah, I think they were the contractor to do the works.
Thank you.
And our project managers, so our own team, would have been managing them.
So when you came in 2014... 18, sorry. Kind of were you involved in that as a project manager at all? Or?
No, I wasn't involved in that project.
And do you recall the works were scheduled to begin in August 2017?
I don't recall that because I wasn't working for Quinn at the time.
And if I was to say that they were due to be completed by 2018, September 2018.
Okay.
Does that sound right even?
I have no reason to doubt you. But I don't know the answer because I wasn't working on this project. It was an example of a large project that Quinn have delivered in partnership with Swale Borough Council and you and I that involved complicated works on a major road with Network Rail. And
complicated works on a road with Network Rail. And if I was to say it was actually completed in 2020, would you have any reason to disagree with that?
I don't think so, no.
So kind of in effect, around 2 years after it was originally due to be completed.
I haven't got the dates when it was originally due to be completed, but...
And so are you aware as to whether or not it came in on budget, that scheme?
I haven't got that information in front of me, no.
And if I was to ask you as to whether or not that scheme went to plan, are you able to confirm?
I think it's achieved its outcomes and has been quite successful. I think it's delivered what it was meant to deliver.
I mean, go to plan in terms of being delivered on time without undue extra costs.
I can't answer that.
I just want to ask you now about Cockering Farm. And for this, I think we need to turn up CD 26.1.6, which is the very...
These are the example of the Quinn projects?
Yeah, the Quinn Estates Building Your Future brochure.
Okay.
A track record of delivery.
This is a interesting project.
So, apologies, man.
Cockering Farm.
Cockering
It's not one
Farm.
that's been mentioned in my... I haven't mentioned it in my proof or in my evidence. Do we have a document reference?
Yes.
Sorry, Mr. Bell, do you have a page reference?
I do. PDF page 27. It's Cockering.
Thannington Park.
Yeah.
Yes.
So were you personally involved in this scheme?
No, it predated me on this one as well.
And do you, when you look at what is said in this brochure, there is at the bottom of the list of bullet points in the black box on the right-hand side.
The financial contribution.
Yeah, of 4 million towards the refurbishment and modernisation of Pilgrims Hospice end-of-life care centre. And then there's an explanation as to why that is important to Mr. Quinn himself underneath. Given your earlier answer, I suspect the answer to the next set of questions is going to be I don't know, but let's see where we go. Originally, were you aware as to whether or not what was envisaged was that Pilgrims Hospice would have a new hospice built as part of the project rather than a financial contribution?
I think originally it was planned to have the new hospice on the site, yes.
So, and was that to be delivered by Quinn?
I'm not sure if we were due to build it or if it was to be delivered by Pentland, who are building out the site in conjunction with the hospice. So I don't have the answer to that exactly.
So, kind of moving down from that, as we understand it, when the decision was made not to build the new hospice, there was then a suggestion of a £9 million contribution. Are you aware of that?
No, I think this is quite recent. Things that have been going on quite recently while I've been in the inquiry. But from my understanding, a decision not to build the hospice on site came from the hospice. And I don't know about the contribution amount.
So we don't know about the 9 million contribution. So if I was to ask you why it reduced to 4 million, you wouldn't be able to say.
I have no idea, no.
Thank you. Coming on to costs now, and I'm not going to repeat, as I said, all the level of detail that Mr. Young has gone into, partly because we don't have a QS of our own. But I want to have a look at the special structures category in the CB 37 14.2a, which is the side-by-side comparison, which I think is the easiest table to look at.
Yeah, sorry, give me a moment. I'll reopen it.
Sorry, could you repeat?
37.14.2a, I think.
Side-by-side comparison.
That's the old one. The new one is it's been superseded by 37.14.4a.
Might be me with the wrong reference there. Sorry.
0.4a, 0.5 is the new one, or the newer one.
I'm not looking to delve into the figures, but what I want to ask about is, in respect of Series 2500, the special structures, we've been trying to work out what is included within those special structures. Are we talking about the bridges, i.e. the Green Bridge, and the railway crossing in the northern site?
So there's different breakdowns. So the northern scheme has a separate cost altogether, and that special structures would include the bridge within the northern scheme. The Section 1 costs, special structures, would relate to the bridging structures for the Junction 5A, and the Section 2 to 4 costs will cover bridging structures, more than one bridging structure within that Southern Relief Road section.
Where are you getting all that from?
Just in my head, sorry. So sorry, if you're looking at
The northern scheme includes the railway bridge.
so the structures for the northern scheme are set out in the northern side and cover the structures that are needed for the northern site, including the railway bridge. The Section 2 to 4 structures cover the structures that are within the. Sorry, Section 2 to 4 is in the Jackson's costings, but that's the Southern Relief Road, essentially the KCC element of the Southern Relief Road.
Could I just help? I think it might help. All the things that are covered by special structures are all set out specifically in documents that we can give references to. So it is all there without needing to write it all down or go from Mr. Gearing's head, as it were. It's not that he said anything wrong, but the northern one, just for what it's worth, I'll just give a reference for Mr. Bell. The northern one is core document 37.14.4a.4, part 3, 37.14.4a.4, part 3, and that relates to the north. And just to sort of, there's only one thing, so I'll just say what it is. If we look down, don't suggest anyone does it right now, but just series 2500 special structures, proposed railway overbridge. So that's what that is in the north. And doing a similar exercise in the south, the document is 37.14.4a.2. That's 37.14.4a.2, which is another one of these Excel spreadsheets. And going to the tab that's series 2500, which is special structures, there are two items, a proposed junction land bridge, another proposed junction bridge over overland flow route. So there's two junction bridges incorporated in those special structures. That's what
So the green bridge.
the green bridge and the other bridge that
and
we've been talking about.
the
Bring-
bridge that might not be one.
Slash culvert, exactly.
Yes.
So there's basically three things in total, I think, that meet. One in the north, and two, I think, in the south.
When we say Greenbridge, slash culvert, this is in relation to the bank of culverts, I think, that were.
So sorry, there are two different things. So the green bridge is the green bridge.
Yep.
Not the pedestrian bridge. So the green bridge that is the crossing entrance by the science park, where you go have the on and off ramps onto the Southern Relief Road.
So,
And then I think it's to the east of the junction at the bottom of Highsted Road, Cromer Road. That's the point where, when we did our walk through the site where the house is to be demolished, that's the area we're all talking about as what the nature of that structure is there.
So
on the Southern Relief Road.
So the overland bridge that kind of crosses through Stones Farm, and you've heard the concerns that Councillor Borden has.
I suppose, so looking at the special structures that are identified for the Northern Relief Road, that is not recognised as an independent special structure there.
So where is that captured?
So my presumption is, and I would probably need to double check this, but my presumption is that will be covered in the wider highway costs.
I mean, we've struggled, as Kent has, to understand why you're giving evidence. Now, I understand that you're giving evidence about your internal processes and expertise and those bits, but we don't have a QS to be able to ask specific questions to in respect of how figures have been arrived at.
No.
So it's not, we haven't found this terribly helpful to us in particular in analysing your figures. And you would have seen how Mr. Gardner said, I think he said repeatedly, that he's had to make assumptions based on the material before him.
And there is a huge amount of material available though that we've appended, probably far, I don't think we've scrimped in any way on material we provided. There's a huge detail in that breakdown that's before the inquiry.
I mean, coming to the material that's been provided, we were surprised in respect of one of the drawings that appeared in Mr. Parks's evidence, and I can take you to the reference. Which is CD 39.7.2. It's his appendices to his proof of evidence.
Okay, yeah, I've got that.
And at PDF page 34 and 35. So there is a drawing of this junction at the bottom of Stocker Hill, I think it is. Sorry, man.
So this, yeah, sorry, it's the last 2 pages. So 34 is the.
So you have the
General
last
arrangement,
page,
yeah.
which is the kind of the chainage drawings.
Yes.
Draw a sharp intake of breath as I say chainage drawings. And then the penultimate page, you have this drawing of the road scheme there.
So
Now-
yes, that drawing shows the vertical alignment of culverts that are shown on the page before.
So is this drawing, as we understand it, the first the inquiry would have become aware of this drawing, and hence the Rule 6 is when Kent put this information in with Mr. Parks's proof. It doesn't appear anywhere else earlier, does it?
I need to recall whether it's attached as an appendix to my proof from Mr. Wild, but I will double check that. But if it isn't, then it would be this. But it's not a drawing that's seeking approval. It's a drawing to show...
No, not at all. I'm just drawing your attention to this on the basis that we say that there is information that appears to have been circulating between Kent and the applicant that we as the Rule 6 have been unaware of until it's disclosed within evidence after Mr. Gardner had provided his assumptions.
I don't know the answer to that. This came from Mr. Parks's...
Yes.
This is attached to Mr. Parks's evidence,
But it's come from Mr. Wild.
to which I provided... Well, but Mr. Parks sent it in. I provided a rebuttal to that, so I don't know the procedural position on that. Sorry, it's not really... I don't think it's really a question for me.
No, that's... I raise it on the basis that, as I say, we have had issues with trying to get to the bottom of your viability by not being able to interrogate the figures, and the fact that new information has been coming out as the inquiry has been going onwards. But I can move on.
I think just to explain this drawing, it was a drawing to show, in response to discussions with KCC as to an alternative alignment. We discussed this previously. Alternative arrangement to a 50-metre long bridge that could deliver the same solution from a flood risk mitigation point of view, but would cost a lot less. It's not for approval. It's just showing an alternative arrangement that would work.
I mean, this revised drawing is with a view to making a saving, isn't it, or identifying a potential saving?
It's not a saving based on our numbers. It's to provide an example as to why our structures sum on the Southern Relief Road is different from that produced by Mr. Parks. So it was produced with the aim of reaching a closer agreement with KCC on structures costs, because that's a large sum of difference between us. And then when you add in the contingency costs and the professional fees and the prelims as well, these just grow and grow, and that's part of the reason our numbers are so far apart.
I want to come back to the attenuation ponds that I'd started talking about earlier at Stones Farm.
Yes.
And obviously they're in the path of the road, and you have the road is going to have to come across the country park, the stream, the probable or actual chalk stream, and the valley, and then over the attenuation ponds.
Yeah, and we just to familiarise people, we visited that on the site visit, which was helpful.
And I think we're not clear in. I'm hoping you can answer this, even though it's probably not strictly speaking a cost question. It falls into what is going to become a question about costs. The idea is that that route of the road is to literally skim as it goes up, so it's just going to skim over the stream and the attenuation ponds. So with the stream, it's going to skim over. With the culverts, is the preferred approach, I think.
So I think Mr. Wild gave some evidence on the potential design solutions to the road in that location. The highway, I think from recollection, he said the highway drainage is already integrated into the road, so it doesn't need to connect into the Suds ponds. And he said that the different solutions would be looked at could be either kind of going over the Suds pond and not touching it, or amending the Suds pond, or something else, but that would need detailed design. So it's a detailed design solution that would need to follow.
And it's a detailed design solution that is potentially going to be quite an expensive detailed design solution, because it can't possibly be, in respect of the attenuation ponds, that you could just have the road going across them. If they're not realigned, if they're not moved, the road just going across it, because you're going to need to access, or someone is going to need to access the attenuation ponds to maintain them.
That would be for the detailed design, for the relationship between where it will cross the attenuation pond, whether the attenuation pond needs to be under the road, whether that, you know, all of those structural. It's a combination of highway design and drainage design that would follow.
Both of which things, of course, Mr. Wilde is expert in and was here to discuss when he was describing this precise structure. He talked about it. I just do make that point that it's not like we've not given oral evidence on this before from the right witness.
I said it would feed into a question on costs, and so the issue that we have here on my client's side is actually the engineering solution to being able to still access the attenuation ponds for maintenance is potentially quite a sizable figure when one's talking about building a road and leaving sufficient access to get to the attenuation ponds for them to be cleaned, presumably by machinery.
I don't know the technical matters relating to cleaning of attenuation ponds, but it's for future design and discussion.
Now, if one is looking, if I was to say to you that in terms of the stretch of road that would be needed to cross the attenuation pond, it would be 120 metres long, do you disagree with that? We can look at the chainage drawings.
I don't have an opinion on it right now because it's not something I've provided in my evidence, so we could go and look at it if you want. As I said, the detailed design will follow.
But it's a sizable length of road that potentially needs to be raised up to allow access to the attenuation ponds and the ensuing costs that come with that.
Notwithstanding, I don't know about the maintenance costs. It could be a sizable piece of road, yes, and it will have a cost associated with it, yes.
So, and they're not costs that we need to take into account now.
We've allowed £36 million for the delivery of the Northern Relief Road in our FVA. We're comfortable with that sum.
The clients have also been quite concerned as to where we can find the costs of the busway. Has that been costed separately as a whole component, or are we talking about breakdowns into costs of signage?
It's costed as part of the costing, so the drawings are measured and have been costed, and the measured drawings include the busway. So it's essentially a component of the costing that's been done by ADCC and JCE.
And again, can't really drill into the detail of those costs because we don't have a QS to ask those questions of.
No, but, well...
You did. I mean, Mr. Parks did as well. We've approached the busway in the same way that they did.
So there's agreement there, I think.
I want to ask you about the house build construction costs. And there was a discussion, I think, with Mr. Gardner over the costs to a developer for building a house and how they are to be assessed. You've already identified a number of developers who are willing to take on plots, and you kind of set out at 2.15 of your proof the 11 letters of interest.
Yes.
Appreciating they're not all in respect of residential. So we've got Fernham Homes who are looking to take on 150
yes,
to
300.
And
local SME, yes.
Hyde 1,000.
Affordable housing, yep.
Persimmon 1,500.
Yes.
Taylor Wimpey 1,500.
Yeah, this is, yes.
It's if you go to 2.15 of Mr. Gearing's proof, and I'm sorry I haven't written down the reference.
First rebuttal?
His first rebuttal, yes.
215.
215.
I can't really see anything that says about, oh.
It's the letters of support.
Oh, I see 11 letters of interest, but you were talking about some names.
Yes.
They were the companies.
Sorry?
They were the companies who've written the letters.
Yeah.
So are the letters somewhere?
They are.
In many, what feels like many days ago, I made a...
It says where it is in the proof. So it's 26.1.7. There's...
Oh, I see, sorry.
No, it's right.
I say it's my fault because as we were asking me that question, I managed to close Mr. Gearing's proof.
It was letters from different
Quite right.
different people.
So we have all of these, and I won't go through all of them, but we have all of these residential developers. Did you not think to approach them?
They just
to
said
ask
they're not all residential developers. There's
Okay,
a number
I
of-
said that at the beginning. That
Oh, sorry, I didn't mean to.
number of them there. So no, it's fine. But presumably, you could have approached them to ask them what their anticipated build cost would be for a unit at the site,
Why?
to be able to give a more accurate, reflective figure of the costings.
Our bill costs are in accordance with guidance and have been
BCIS.
agreed with the council and KCC.
I've got some questions around abnormal costs that Mr. Gardner expressed a concern were missing from the cost assessments.
Okay.
If I list them, and there are about 8 of them,
Should we have a look at his proof of evidence? Would that?
Mr. Gardner's.
Yeah. Rather than just reading them all out. It's page 21 of his proof, isn't
Yeah.
it?
Hang on a minute.
So we got his proof, Gardner's proof. I'm just.
Oh,
Oh, we could have a break now.
we could have a break.
You know, it's probably yes.
Yeah,
Yeah, it's okay.
yeah, of course. Yes, yes, of course. Yeah, yeah.
paying as much attention as I should be to
No. Okay, fair enough. Right, so it is 3:30. Actually, should we have a break until 10 to 4? Thank you.
Oh, can I just raise this straight away? So my case tomorrow has been listed at 2 o'clock.
Oh,
How exciting. Yeah, I could go back and tell the judge that's very inconvenient and would he mind just sticking with the original time, but I don't think that's going to work. I just say that I've just literally, that's, come on, so I'll have a think about that over the break.
do you have to be there in person then?
Yeah.
Oh, told you that's very old-fashioned.
Yeah. yeah. Well, there is a junior, but obviously the client is he wants you. Yeah. So
I thought what was all that stuff about how we had to prioritise this inquiry?
I know.
Can't believe it.
you'd like to write my letter to the judge?
Well, I do remember some weeks ago one of the barristers at this inquiry, but I can't remember who it was.
Exactly. I know.
Yeah, it is that is all true, and I'm gonna let the cat out of the bag. That was me. You honestly need to go and see somebody.
What time do you think you'd have to leave here?
I don't know. Obviously, I don't want to be late. I will find a solution that makes sure that somebody can go to the Maldives. Okay, I will find a solution somehow. Nothing wrong with a 7 o'clock start. No, there'll be a solution.
Well, we
And
can start at 9, aren't we?
yeah, it may be that Mr. Bashford just wants to adopt that part of the case, and then I could cross-examine him on it.
What's that?
Mr. Gearing just had the idea about cross-examining happening remotely, but I don't think that's going to work.
Well, he could if the worst came to the worst.
If worst came to worst, you could do your cross-examination remotely, I suppose.
The trouble is, I think, with the evidence in chief and so on, it's going to be...
You'll be here for evidence in chief then, potentially, and then...
well, I mean, I don't want to risk a train problem.
Oh, I see.
I will find a solution.
Okay.
Don't worry about it. There'll be an answer.
Thank you.
All right, will you tell us before somebody... All right, thank you. Absolutely.
That's what
If
it
you're
says on his
happy,
CV.
if you're happy with this, yeah.
Well, it depends what you say.
If I may, can I join remotely tomorrow when you start?
Okay.
I think my own friend said 2.5 to 3 hours, so we started at 9 o'clock, and then roughly arrive at the end of evidence chief around midday. And then, provided it sort of works, and I'm sure it will, that I ask my questions, which are no more than 30 minutes, in that first period after evidence in chief.
Are you going to come all the way over here?
He'd be doing
No,
it
no,
on,
no.
Or do it
on the big
remote?
screen.
Oh,
Potentially.
yeah.
So I'll be in
Okay.
chambers in London,
All right.
and then I can, and I finish that, even if we get to 1 o'clock,
Is that all right with you?
then I can go across to the,
Hop over to the High
RCJ.
Court.
Yeah.
That, just to say, that's fine. That,
You're all right with that?
more than, yeah, absolutely.
Fine, that's accommodating.
Accommodating. Much appreciated. And it's just that sort of pragmatism for which he's known, of course.
I'm sure everybody would agree that's all right, would they?
Yep.
Mr. Bell, you happy with that?
Yes. Fine.
And Mr. Pereira?
Yeah, of course, yeah.
Yeah. All right, Mr. Young, thank you very much. Oh, yes.
Thank you. So with apologies, I think Mr. Simons was possibly preempting where I was going to go with this, but it's very helpful to open up Mr. Gardner's proof of evidence. And if I can take you...
So could you just give me the reference again? I hadn't quite...
Oh,
opened
yeah,
it.
sorry, 42.8.1.
Thank you. Yes, thank you.
And we're travelling to PDF page 43, which is internal pagination on the document itself, 42.
Yes.
And this is Mr. Gardner's conclusions at section 8.
Yes.
And at the bottom of the table on page 42, PDF 43, you can see there's a row dealing with abnormal and infrastructure costs.
Yes, so this is for the Northern scheme, I think. Sorry, I think this is the table for the Northern scheme, looking just above.
Yes, I think he makes the point in respect of both. But what I want to kind of deal with is the conclusion in the final column of that row, where Mr. Gardner says, for a large strategic site of the scale and nature, where abnormal costs appear to be one of the main drivers of viability, I'd expect a detailed cost plan to support the abnormal and infrastructure costs. Can you see that?
Yes.
And when Mr. Gardner was giving evidence in chief, I asked him about some of the costs that he would have expected to have seen. And so what I want to do is just very quickly put some of these costs to you for you to say whether or not I can find them somewhere within the material that you provided. One of the areas that we think should have been costed is in respect of the utility upgrades on the site.
Would it help, sorry to say, but there is a list of what are called abnormals in this document on page 21 that includes utilities. I don't know whether it includes all the other ones. That's why I'm just mentioning. If it did, it would be a list.
It's more of a breakdown as to what we were expecting to see within those. So within utilities...
Oh,
Sorry, utility upgrades. Kind of a new pump station is required, isn't it?
So in terms of the utilities breakdown on the north or the south you're talking about right now?
I think it's the north, isn't it? It's the north. And there's a south one, the south.
I haven't got the report in front of me at the moment, so I haven't got that detailed breakdown.
Sorry, is it north or south?
The south, sorry.
There is there's an appendix to the flood risk assessment that includes some information about utilities.
Does that have the cost of the pump station?
I don't know if it's got the detailed cost, but I know it's certainly fed into the work that our technical director was doing.
So the costs are fed into the work?
Yes.
And the costs are fed into the work that relates to what we're dealing with now in this session?
Yes.
So
as I've mentioned, we have quite significant in-house expertise, and both on this project and other projects, they work with utilities providers, for water, for power, for others, and they then either use information that's provided directly into a specific project, or they use assumptions based on the wide range experience.
So where can I find the cost of the pump station identified.
Can you show me where the pump station's identified first? Can you take me to that?
Whereabouts was it? It's on that plan.
I think that's what he's asking, isn't it?
Well, no, he told me there's a pump station, then asked me where the cost was for the pump station. So can you just take me to the document with the pump station in it?
So it's there, isn't it? So it's located in Highsted Valley. CD 9.2.51, which is the environmental status statement, volume 2. I now need to open myself as well.
It appears, sorry to jump ahead, it appears to have been an agreed assumption, I'm just looking at the detailed cost plans, that surface water pumping stations are agreed, I think, to be excluded, along with VAT, inflation, planning fees and some other things as well.
What are you looking at now?
So I can give you a reference to where that is, just in case it helps. I don't know if Mr. Bell's already seen this or not. So the document is 37.14.4a.2, part 1. 14.4a.2, part 1, and it is this long series of spreadsheets that we've been at a few times on the different series of things. Sorry, 4.14.4a.2.
Well, it might have been agreed,
Oh,
but,
no, I think
but I think Mr. Bell is asking a question.
No, I just wanted to. I know. No, I'm aware. I'm
Whether
not
it's
stopping.
Agreed or not?
I'm not objecting to the question. I'm not objecting to the question. I'm trying to help with the reference.
It's helpful, but I don't think it provides the answer as to.
It may well not. I'm just trying to give a reference.
I think Mr. Bell was looking at the foul and surface water drainage strategy documents, not anything to do with the highway costs.
Oh, sorry.
That's-
In that case,
You asked me where the pumping station was located, and what I'm identifying is where it's located. But what I'm trying to find out is.
Sorry, I meant which document? Not where it was located physically.
1951. Let's just have a look at that.
So what was the document you referenced, Mr. Bell?
So CD 9.2.51.
9.2.51. So
That's not opening for me. No, there we are. Okay.
So there's a section below that as well, 9.253 and 9.254, which is the water resource and supply, and that includes some of the discussions that were held with the water companies. Those assumptions that would have fed into the allowances that we put in the FVA.
Which water companies?
There's some letters, I think, attached in those documents.
Well, hang on. Are we looking at the document? Which document are we actually looking at?
I think
9251.
Mr. Gearing's. Have you moved on to a different document, Mr. Gearing?
Sorry.
Are we looking at something else? It's
I
scary.
think I may accidentally be, yes. I think I'm at 9.2.5.4. So, sorry, 9.2.5.1.
No, just close that.
51, sorry.
0.551, yeah.
So I'm just trying to open that document. It's just struggling a bit. So,
You got that open now?
Sort of opens in part, doesn't it?
Yes, and if you have a look at on those two plans, so on the first one, I think the pumping stations.
okay. I have got it.
Well, sort of.
So you have secondary pumping stations, proposed primary pumping stations, and a proposed transfer pumping station. There's a whole variety of pumping stations.
So-
Hold on. Sorry. I was stupidly trying to enlarge it, and now
That's what I did earlier.
it's stuck with only a bit of it on the page.
I'm coming to Mr. Young's conclusion that it's actually easier to deal with things on paper.
So this is the,
Absolutely.
if I can talk to it, it might help. This is the preliminary foul drainage strategy sheets for the
Yeah.
southern application
Okay.
from
So
CNA
you have
consultant
these-
engineers.
You have these pumping stations, but where do they appear costed?
So there's specific lines in the financial viability appraisal for strategic foul. So if you look at the CD 37.13.5, which is for the south site, there's a strategic foul allowance of £21.45 million.
How much did you say?
21 million. And then on the south, on the north, which is CD 37.13.3, there's an allowance of 2.5 million for strategic drainage. So there
how
are,
much again? Sorry, say it again.
2.5 million.
And that's not broken down, is it, at all, into
Uh,
the individual costs of pumping stations?
No, because it's an indicative strategy at this point. So we've utilised the strategies and the information that's in the planning application to put allowances in the FVA.
So that the costs involved crystallise at the detailed stage is what I think.
Yes,
is
because you wouldn't know the exact cost until you had your detailed strategy.
So that's kind of effectively another unknown at this stage.
Yeah, there's allowances that we consider appropriate using our experience and our in-house expertise to feed into the FVA based on the information in the planning application.
And in terms of the foul water figures that you've just kind of presented, or you haven't just presented, it's there, but you've highlighted. Does that include the cost of sewage upgrades, sewer upgrades?
Yes, that would include the strategic elements, so the site-wide elements on-site and of the off-site upgrades that are needed if they're at a strategic level, yes.
But all just rolled into a
Into a s-
broad
broad
figure.
sum based on experience. So these are we work on many projects. So we're quite used to having allowances associated with foul water upgrades, surface water upgrade, surface water provision, and these are based on site-specific information, but also that.
So this is drawn from
Broad
the
experience.
in-house experience.
Yeah, I mentioned earlier we've got a technical director of over 20 years' experience as a civil engineer. Who's we've got QSs who've worked for house builders and now work for us. We've got construction director, etc. So they are delivering this both on our sites, but also when we do appraisal work. Before we sell land, so we have to make sure we get these figures right because it obviously makes a huge difference.
You can't tell me by response to a question as to how this figure breaks down or how it's been calculated, other than
No,
X
that was my
number of
answer.
years worth of experience.
Yes, so the information they've utilised the information within the application, the information from CNA, and they've used that to inform the figures in the FEA. I think Mr. Park said that's exactly what a cost consultant would do, is use their experience to come up with figures.
And one of the other areas that we're interested in as to how you factored this kind of costs in is compensation. We've had a lot of discussion about CPO, but I want you just to turn up Councillor Bonney's planning proof, which is 42.7.1. I'm not going to ask you planning questions. Councillor Bonney will obviously give this evidence.
Just a minute.
Yes, proof of the... Yes, I've got that, thank you.
Just a minute.
Sorry.
No, it's okay.
Mine's just frozen.
Oh, hold on a minute.
What is your proof? What did you
Sorry, what?
So, Madam, have you got
42.2.2.
42.7.1?
Oh. Right here. Oh, yeah. Okay.
No. Have you got that open, Mr. Geary?
Yes, yes.
If we go to page 74, PDF page 74, and it's paragraph 12.60. You got that?
Just getting there. Sorry, page.
It's PDF page 74. It's also internal page 74.
Internal page 74, paragraph 12.60, yes.
So here, and the paragraph references within the list that appears are references to earlier on in the proof. I don't think we need to go to those directly. But here you see the 5 parish groups saying that there are some associated costs that need to be included within the viability assessment. And this broadly relates to areas where the 5 parish group understands that compensation would be payable in respect of kind of land or kind of rerouting of utilities and that type of thing. Where is that all captured in your FVAs?
I think I previously answered. So do you want me to go through these on a line-by-line basis? Or?
You can probably give a broad answer at first, and then we'll see if we need to go through it
so
line by line.
12.60.5, compensation for routing southern water trunk main on SNRR. I think that's broadly covered within the utilities costs that we'd expect, and utilities infrastructure as a whole. So that's 12.65 and 66. But we have gone into detail on the relationship of compensation and CPO, and I think I've answered that previously.
I did say there might be a little bit of repetition. I am trying to avoid it, but it's a point that is quite, my clients are quite keen on.
We've explained the processes built into the Section 106 that ultimately would allow, if KCC agreed it, a CPO to take place for land that's not within the control of the applicant on the northern site, so Stones Farm, Trentport, and we're having a Section 106 session on Friday to discuss the nature of the Section 106s and some of those matters, I think.
So, but I think kind of summarise your answer is that
there isn't a sum of money.
Some of that is factored into things like utilities, but it's not kind of broken down so that we can see how it's
for utilities and things like that. I think it's different from the point you're making about land compensation. I think that's a different matter.
And you've already answered those points when put to you by Kent, effectively.
Yes.
It's about the acoustic barriers.
So the acoustic barriers to existing properties, I haven't got an answer right now to that question. I'd need to ask someone else.
I mean, we've not found the costing for that.
I'd need to speak to our acoustics expert on that point if it's needed an answer.
But is this?
We've got to. I mean, I don't even know if there is a requirement for that. So we've got acoustic fencing that's part of the relief road alignment, particularly the northern relief road alignment. But I'd need to understand that question.
But is this the type of question that, say, if Mr. Bell was here giving evidence, and I get very twitchy whenever anyone says Mr. Bell in an inquiry.
I don't think Mr. Bell would have a different answer. No. I think it's a very specific question to do with acoustic barriers to existing properties, and I need to know the answer. It's not something that's been raised before, now.
I mean, in terms of some of the other questions I've asked about the breakdown of the figures rather than just having the overall kind of figure, Mr. Bell would be able to answer that in a bit more detail, wouldn't he?
No.
Okay. I want to kind of move on to a discussion about delivery at this stage. If we can take you to CD 7.8, which is the design and access statement addendum for the southern site.
It's quite a chunky document. Yes,
it is. I'm not going to be delving into it in too much detail, but
hold on, I haven't got it.
Sorry, madam.
Just a minute.
Takes a while to open. That's what I was getting at.
Right. Okay. Just a minute.
It does open eventually. you have to trust it.
Just a moment. Yep.
Thank you. If we can... sorry, mine's now just doing its own thing. If we could just turn to page 7 first of all.
Yes.
And we've got the section that says the vision. And then the green box to the right-hand side, there's a number of bullet points. The last one being land secured and ready to deliver.
Yep.
And that's not quite correct, is it?
For the southern scheme, yes. For the northern scheme, land is secured or identified within existing Section 106 agreements or a policy allocation.
And in respect of the land in the country park that's transferring to Swale,
This is the southern DAS.
I'm using it as an example. We've said about the north, so I'm coming on to...
Sorry, so in relation to the north, you're referring...
Yes.
Sorry. Relation to the north, so you're questioning a specific line in the DAS, presumably?
Well, it's because you've moved on to talking about the north. So the backup, my follow-on question for that is, well, what about the land in the north that's transferring to Swale? Is that described as secured?
Arguably, once we have the Section 106 position and the Section 106 is signed that allows through to a CPO route, that does secure the delivery if that route's followed.
But it's not secured, though, is it?
Not at this moment, no.
If we could move on to page 52.
Yeah.
I am sorry, I am dealing the cards that I have left from the deck.
Sorry, what page?
Page 52.
What about the deck? What did you say?
Oh, sorry. I'm
Dealing from the cards
kind of where I'm suddenly cutting off and jumping somewhere else. It's because
the questions in the middle have gone. I get it.
my late nights again have been in vain.
52.
I shall use October to catch up.
So yes, this is the Southern DAS, again, page 52, and it
Thank
shows
you.
an illustrative example of the junction 5A on the
Yes, and I'm not looking at that specifically. I'm back onto the bullet points, which have piqued my client's interest. The final bullet point: delivery partners already placed, providing certainty of delivery.
left. Yes,
Which delivery partners are in place?
all the landowners, so our joint applicants.
Are they all in place? Are they all signed up to the 106?
They will all be signatories to the 106 and the Southern scheme, yes.
And you're kind of satisfied that provides certainty of delivery? Just having the landowners signed up?
So it's a high level of certainty, I suppose. I suppose there's, this is going into a bit of a theoretical question, but we've got evidence of the landowners being signed up for the Southern application. We've got a 106 that's progressed. We've got letters of interest from house builders. I think that gives a fairly high certainty level of delivery. We've got caveats to meet, clearly. We've got to get design approval for the Southern Relief Road. We've got to meet all the requirements for the Northern Relief Road in the Section 106 that we've gone through at length in the last 2 days.
Now, some of the land is under option agreements, isn't it?
In the
relation to
southern sites.
Oh, sorry. Apologies, madam. I said option agreements, not promotion option.
I don't know if I want to go into that, but I don't know if it's relevant.
So, it's relevant in terms of obviously how secure the land is in the option agreement and whether or not actually because we don't know what the terms of the option agreements are, do we?
No, you don't.
No, and we're not going to know, are we?
No.
So we don't know what the mechanisms are and how secure they are under the option agreement if a deadline passes, for example.
No. I think the local authority, the inquiry will need to be satisfied that the Section 106 is signed, and anyone with land within the red line that's relevant, such as that land, would need to sign the 106.
And
So I think it's covered under that
And
mechanism.
you don't feel that the terms of the option agreements are something that the Secretary of State or Inspector needs to have
No.
an eye to?
No.
I just turn to delay again. Sorry, I'm jumping through. I don't think it really matters. We had some discussion about delays in other Quinn projects when I started, and we've discussed delay, or Kent has discussed delay.
I think they're all joint venture projects with local authorities, but yep.
Yeah. So we accept that delays can arise.
Delays could always arise, yes.
In schemes, so we have the outline, we have the concept scheme, we've had some level of testing. So say with archaeology, there's been some trenches dug and they've been looked at, but potentially if more archaeology is found, that could lead to a delay whilst that's sorted out.
We have to look at the timing, because obviously we can twin track certain things, but yes, we've done hundreds of thousands of pounds of archaeology on site, which has reached agreement with KCC,
But of course,
subject to further conditions, which are standard
Yeah,
for archaeology.
it's obviously agreement with KCC, and you appreciate, although we've fallen into line with them in respect of viability, we don't necessarily fall into line with them in respect of the amount of investigatory work that's been done with respect to archaeology.
Okay. But I presumably you spoke to my archaeology witness about that.
But if there is further archaeology that is discovered on the site as works move forwards, that has potential to delay, doesn't it?
I'm not sure if it would delay because of the timeline and the way we're proposing, but it does have that potential.
It has potential.
Yes, yes. When we did the site visit, we looked onto the, I think it was the, was it Hyde or Orbit scheme, which had found the Roman mausoleum with the
statue of Neptune in the
statue of
roundabout.
Neptune. Yes, sorry. So late in the day. Yeah. So we had a discussion about that and how that was dealt with, and how it didn't actually lead to much delay, but led to quite a lot of work that was needed to resolve it.
I mean, delays in respect of that arise with works associated with the road are particularly problematic, aren't they? If there's a delay caused to the road being delivered on time, that has a particular issue with your funding.
Well, only if we start the road and start drawing down money to build the road and there are delays in the programme, because obviously we are able to do a lot of the work up front before starting building the road, including the archaeology. So you wouldn't start building a road and be doing the archaeology along the route as you went. Or certainly we wouldn't.
But you can't really tell, because you're not going to do an archaeological survey over the whole site, are you? There are chances you're going to turn stuff up as you start work.
Well, not necessarily. The usual approach would make sure archaeology, when you're building houses, is to make sure the archaeology is signed off before you start construction of that element.
Okay. But you appreciate that you can come across fines.
It's very unlikely if you've had the archaeology signed off for that area, and to the extent where, you may do. But I think normally archaeology is a phased approach.
I think interesting as this is, and it's probably because I've put a bad question, and as Mr. Young has said, and I agree that it's on the advocate, what I'm trying to get at is delay has an impact on funding. You've given that answer, which is, well, it depends if we started drawing down the funding at that stage.
Yes.
Now, if there is a delay, once you've started drawing down funding, what recourse do the developers have who have signed up on the basis that a road will be delivered on time, and then there is a delay? Is there a mechanism whereby they are compensated under their contracts?
Do you mean the house builders?
The house builders.
So I mentioned the stages of phase payments. So I mentioned the technical approvals requirement, and then phase payments relating to implementation and progression, and also that bank funding would also be released on the phasing of the project. So that covers that point off, I think.
But does it? Because the issue is, you have a house builder who has waited to start work, a road is coming on, there is then a delay that is caused by something unforeseen, or something that could have been foreseen had further investigation been carried out. But
I think we'd go with unforeseen, because we've already said we would do all the further investigation.
But is there a mechanism whereby house builders would be compensated for unforeseen delay in them being able to have their houses occupied?
It's not a mechanism that we have
required elsewhere or been required of us elsewhere, because there are also, the contract would set out a build period, and there are then step-in rights built into contracts as well. I see your point. What if the build suddenly takes 5 years instead of 2 years?
By the
for
build,
example,
you mean the road?
build of the road or any other piece of infrastructure that's required. But you would. This is why we said about doing the detailed upfront work and making sure all that work's done. You de-risk a project as much as possible before you start something like this, because it's very expensive. So I wouldn't envisage that scenario occurring.
But
it's
if
not
it
something.
did,
It's not something we're.
so it's not something you've cost.
It's not something that's been costed in the FEA. No.
Thank you. If I can move on now to the deviation from DFT Circular 01/2022, and it's I want to refer you to document CD 2414.
01/22.
Yes, it feels like a long time ago since we looked at this
kind
one.
of echoes of highway discussion.
Echoes of highways, but linked into costs in respect of the questions. I
Okay,
hope.
it's a nice thing to do.
I am trying.
Sorry, what was the CD reference?
So it is 2414.
Sorry, everything seems to be slowing down, including me.
No, it's the letter from the DFT, the one where they said they weren't going to explain to National Highways whether or not it was appropriate to deviate from the circular because they didn't want to prejudge the outcome
So
of the.
Is that the environmental assessment? Oh God.
It's the letter from Mr. Singleton.
Yeah. Okay. Yes, I have that. 14th of May. Letter.
Yes.
Thank you.
So, National Highways have explained that there would be a need to deviate in respect to the motorway, and that they were going to have to look into that. Now, if the DFT was to come back after this inquiry and after, say, permission had been granted and said that it wasn't appropriate to deviate from the policy, that's fatal for the road scheme in respect to the motorway, isn't it?
I don't think I'm the right person to answer that.
It would have been one, to be fair, for
I
highways,
did
but
put it
it's-
to your transport witness, but what I'm
You-
getting
fair
to
enough.
is in terms of that, what backup in terms of costings? Because presumably you would want to challenge a decision like that.
I think my first answer kind of covers that second question. I mean, ultimately, we wouldn't have commenced development. I think that's probably the important thing.
Thank you.
So, you know, so again, the so what comes in there, I think, slightly.
So the so what, as in so what, we don't move forward with the scheme.
So if the scheme doesn't move forward, then the scheme doesn't move. If the scheme couldn't move forward because of something that you've raised here that we, you know, as our highways expert considered, the question is then, what's the context of the question?
The context is it's an additional cost to deal with, because presumably with the money invested in this already, if the DFT says we're not exercising our discretion to deviate from the circular, you would want to challenge that.
I think it's a future decision that may or may not arise that probably is outside of the remit of the inquiry.
Thank you. I'm moving on to my last few points now. And now we come on to the issue of the promotion agreement. And I have a specific question. I don't want to get into the ins and outs of the promotion agreement. But to set the background, obviously Kent have invited you to disclose whatever promotion agreement is in place at the moment, and within your rights, your clients and the landowners are refusing to do so. Mr. Young explained that in respect of the previous promotion agreement that Rodmersham Parish Council would put in to Swale when they produced their objection. He wasn't too sure where it had come from. If we could turn up CD 1080, which is the Serda objection. It just says Rodmersham, doesn't it?
1080.
1080. So, and it's, sorry, I use shorthand to refer to it as coming from Rodmersham, but it's from Bapchard, Bredgar, Milstead and Rodmersham. I didn't want to
Yes.
do some of my client group down. But if we turn to page 47.
Yes, Stones Farm development.
Yeah.
Yes.
And at 11.4, this is SERDA explaining that their clients, the parish councils, have been able to get hold of a copy of the promotion agreement. And you can see there that it was publicly available through the land registry.
It's not something that was to do with us, but
No,
if it
but
was, then
presumably
okay.
when it was submitted to the land registry, it would have been known that it would be publicly available at that point.
It's not a submission we made to the land registry,
But it's recorded as a covenant.
if that's what it says, yeah.
Sorry, a charge, through a deed of covenant. And if we, just for the inspector's note really, if we turn to page 115.
Yep. This is I think this is a,
Yeah, this is the deed of covenant. So this is the document that they got from the land registry.
okay.
So you have the deed of covenant there.
So this is I think you referred to this as a expired promotion agreement.
I do in respect of page 122.
Yep.
This is the promotion agreement. Sorry, it starts at page 119.
Okay.
So in terms of where it's expired, of why we say it's expired, I think you agree it's expired. Page 100 and... Bear with me. I think it's clause 3, the planning long stop date on page 137.
Okay.
This is the clause that operates and is where we've got to that it's expired, but you accept it's expired.
So there's been further
Yeah, so it's
supplementary
been
agreements.
a
It's been
new one
replaced.
or a
This
renewed
is
one.
out of date, so this
Yeah.
is essentially irrelevant.
And this is the document that, within your rights, you're not disclosing.
Well, this is a out of date
The
document.
new one
Yes,
that I'm talking
yes.
about, that's the one you're not disclosing.
No.
And what we're just curious about is if the concern is about this new version of this agreement going into the public domain, why wasn't that concern there in respect of the previous?
As I said, I don't know the circumstances of why this document is in the public domain. It's not something that we've released. So the circumstances of why it's in the public domain, I'm not sure.
It's in the public domain because it's in the land registry. But
Yeah,
if we,
I accept that.
Yeah,
But I don't know. I don't know. I haven't read the agreement in detail here, but I don't know if it was meant to be in the public domain or how it's in the public domain.
But if we turn very quickly for the inspector's note to page 126, and at the bottom of that page, that's where the minimum land receipt is provided, and this is where the figure of 150,000 per gross acre is found.
See that?
Which is the figure I think Mr. Young referenced when he was cross-examining. I just flag that because I think it's helpful for the inspector to have the reference,
Yeah.
and as it's our document, effectively. I mean, again, becoming a little bit more repetitive, in respect of the current promotion agreement or form of agreement that's in place, have those costs of the minimum land receipt been factored into the costings we've seen?
As I said, I'm not able to discuss the up-to-date agreements and discuss them at all.
Wouldn't be a freestanding cost anyway in the FVA.
They're not an FEA cost anyway. You'd never put land value into an FEA. You always have to use a benchmark land value. So the guidance is really clear that you can't put assumptions over land value into an FVA. It has to be done on a benchmark land value approach that has to be agreed.
Without seeing the up-to-date, I don't want to labour this point, without seeing the current promotion agreements, we don't know what the minimum land receipt is your clients are hoping to receive.
No, I've made that clear.
Thank you. So, coming to the end, so our position is, or the 5 parish groups' position is, that the scheme isn't viable, and that the assumptions that were made by the 5 parish group in respect of their view on viability before KCC.
Sorry, just to confirm, so the 5 parishes' view is it isn't viable?
It isn't viable.
But that's not what your evidence says.
Sorry?
Your evidence in chief said it was viable.
You'll recall that following the disclosure from Mr. Mitford Slade and considering KCC's position, we made it clear that actually we agree with KCC.
Okay, sorry. Yes, sorry. I just wanted to make sure. Okay.
Thank you. So I'm just putting that to you. That's what our position is in respect of viability.
So is the position that you agree with KCC's position on viability? I think that's what was said.
Yes, in respect of... Yes.
Okay.
Now, we're still unclear as to kind of why you are giving evidence. Now, I appreciate that given your years within the planning system as a head of planning, you're obviously used to giving evidence in planning inquiries.
So I've been the project manager on this project for 7 years. If you remember, KCC provided proofs of evidence from Mr. Birchall, Mr. Finch. Arguably, they are kind of, well, Mr. Finch in particular is kind of taking a similar role for KCC. He's project managing KCC's response to this. I'm obviously taking a far wider view. Yes, I'm a chartered town planner, 20 years or so experience I went through, but ultimately I am the project manager and leading on the inquiry and the project. So I am well placed to oversee the project and have a fairly holistic overview. So obviously there are many moving parts of a project such as this.
And that's the basis for you kind of providing your evidence.
Yes. And that's why there are a number of
appending other proofs to your evidence.
At the time, this is kind of irrelevant, but at the time Mr. Young had said that he had 2 witnesses that he was going to call, Mr. Birchall and Mr. Finch. And then after the rebuttal date, a further witness was added. That's why we then added a further witness, Mr. Goodwin.
And so kind of would it be right to characterise your evidence as effectively looking to plug a gap?
It was a rebuttal, so it's a response. It's a response evidence to the evidence of Mr. Finch and Mr. Birchall, and then the second rebuttal is to Mr. Parks. So it was directly responding to those matters, and then there are a number of matters that came up through other people's evidence in chief, in particular Mr. Mitford Slade's, that required me to answer questions.
But so we don't get down to the nub of actually the detail of how the figures in the costings were arrived at, because you can't give us that information, can you?
No, we're content and we're happy that the figures in our FVA are robust. They haven't been challenged by Swale. Ultimately, Kent haven't challenged them. They've made some assumptions over whether they should have been provided with a cost plan, but the actual amounts were moved forward into their FVA. I don't know exactly the position that was reached with your witness on that, because it might. Yeah, sorry, I just haven't got that answer.
So, do you recall kind of a case from your time when you were head of planning at Shepway, case of Timothy Steer?
Well, I don't know if I have to answer this, but it was. Is this to do with Little Denzel Farm, perhaps? I don't know.
And it's to do with how Mrs. Justice Lang considered your evidence in that case. Do you recall that?
Whoa. Come on. This is good. What's this?
I don't know, no. It may have even been a case where...
You've not been given any notice?
I don't recall it, no.
Fair just to sort of drop that into...
Madam, I mean, it's a case that kind of my clients have recently kind of...
No, but there's nothing in your evidence about it.
Madam, I'll discuss it with my learned friend.
Well, it won't be a very long discussion, I'm sorry to say, because we're not letting any new stuff in. I mean, that's previous discussions about this.
I mean, are you sort of questioning Mr. Gearing's credibility?
Madam, we were coming on to question his kind of credibility. But, Madam...
Well, might as well get on and do that.
I'm not really sure that raking up stuff from, previous employment where he might have or might not have ended up. I don't know what it's all about, but it sounds like a High Court matter.
It's not right to.
It's not really fair.
I mean,
is
it's
it?
not. I mean, I've got obviously, literally no idea what it is, but it's not very fair not to give us some sort of notice so that I could have said something about it in chief or something. I mean, I don't know. I don't know what it is, obviously. But if you're going to question his credibility, then obviously you need to do that very, very directly.
So, in terms of the evidence that you've given, the position that my clients have formed is that you are here providing evidence, but you are unable to give the level of detail that is required in respect of the costing so that we can understand the viability in the level of detail that we should.
That's your client's view.
And my client's view is that it is deliberate that you and not one of your in-house QSs is here to give evidence.
It's deliberate that I've been chosen to give evidence. Obviously, every decision's deliberate. So yes, I am the witness.
Presumably, the idea is.
But I don't think it was on the basis you're suggesting.
Presumably, you put forward the best witness to be able to assist the inquiry, and in this case, it seems that the best witness, with respect, isn't you in respect of understanding the figures.
Is that a question?
You can say yes or no as to whether or not you're the most appropriate person to give evidence as to how the figures are calculated.
I think I have been appropriate to give evidence on that, yes.
Thank you. I have no further questions.
Thank you.
Thank you very much. Right, okay. I've just got a couple of questions. Not much. Please know, because I've been chipping in, as always. Actually, one more.
Yes.
And it's just a reiteration. Oh, it's gone off. It's just a reiteration, really. I think you were asked by Mr. Young about this, but I got the note of one, but not the other. So you say at the beginning of page 7 on the paper copy that you discuss it with a number of trusted contractors.
Yes.
Is that so? We've got obviously Jackson's, we know about them,
Yep.
and you said Volkers, Fitzpatrick.
Yeah, we worked with them for a number of years.
Yeah, and who was the other one?
Breheny, Breheny.
Right, and they're do they do?
They're a similar company to Jackson Civil Engineering. They are a
Tier
civil
one again?
engineering. There may be an argument over Tier 1, but they are a main contractor. So if you look them up
Main
online, there's quite easy to see some examples of their projects.
Okay. Right, so they were basically the three that you were discussing.
Yes. Yep.
Yeah. Okay. Thank you.
They're currently building the access for urban and civic with the county council in Cambridge for the major road access there.
Okay. Thank you.
Breheny.
Yeah. Paragraph 4.8. So there were, if you just turn, to page 4.7, paragraph 4.7,
Yes.
the, things I understand it, JCE, we're talking about preliminaries of projects varying from 16 to 18%. Is that right?
They were the 3 projects I appended.
Yeah.
They were all NEC contracts
Yeah.
for county councils and Homes England, and they had preliminaries from 16 to 18%. Yes.
Yeah, I just wondered why then, and you might have already been asked this, the figure of the preliminaries for the northern and southern relief road were quite a bit lower than that.
So they are, well, essentially they worked up their preliminaries. They provided a breakdown. So they worked up a cost estimate based on traffic management, night works and temporary works on a bespoke basis. And they then used a cost allowance, which is earlier in paragraph 4.7, of 5% for staff costs, and 8%, and...
So where are you looking at?
Sorry, in the paragraph above.
Oh, yeah, okay.
So essentially they provided a blended cost for their preliminaries between site-specific costs and then an assumption over staff and other costs of 5 and 8%. And I think the example of 18% was a design and build, which is the email I received from JCE recently, just to confirm on that point.
Yeah. Okay, fine. Thank you very much. Yeah, and it's sort of interesting in a way that Junction 5A had the highest cost, didn't it? And yet we've got the most information about it.
I think it's because of the nature of the need for interaction with the SRN.
I see.
And you've obviously got bridges going over, so you've got a potential night road closure, things like that. Whereas the costs associated with the Southern Relief Road, although it's a bigger project, are within a greenfield site.
Mm-hmm.
So I think there's less traffic management, for example. So those assumptions are the preliminary allowances from JCE that we've interrogated are based on discussions of the specific project. They're not kind of just general rates that have been set out. They've used the allowances of 5 and 8% and then done the detail. It's as per my proof.
Thank you. Okay. Thank you very much. Yeah, I was just 4.12. You were talking about the Junction 5A being mainly offline.
Yes.
And obviously they've got to build the bridge. Sorry, the contractor's got to build the bridge. Presumably that means closing the M2 altogether, that section of it.
I think I know there were detailed
Right,
discussions. Sorry.
No.
I know there have been discussions with Mr. Wild, Jackson's, and our technical director and team about the assumptions over that, and the idea would be that you would, and it's very similar to you see a lot of highway works, is you would be looking at, I think, a single night closure or night closures to do those works. So because you would have to deliver the parapets, I guess is the right word, essentially the work before the bridge is dropped in up front, either side of the bridge, and then you would then be able to drop the structure in.
Right, okay.
I've seen that on a number of times on projects along the M20, where I live.
So that, yeah, I've seen it along the A3 too. National Highways then were involved and I'm sort of happy with your assessment that the majority of it could be done offline, are they?
So National Highways reviewed our figures and they raised no concerns with our sums. Okay.
Just one other thing, and that is, paragraph 4.27. Is that a typo there?
Probably.
Well, it's just that you, 1, 2, 3, 4 up from the bottom, you refer to the SRR. Is that meant to be Junction 5A, by any chance?
Oh, sorry, yeah. So demonstrates preliminary allowance for JC of 76 for this. Yes, that should be Junction 5A. Yep, you're right.
Right, okay. So it's a yes.
Eagle eyes.
Well, I'm quite particular about those sorts of
things. No, it's important.
And the final question, actually, just arose from questions just been asked. I'm not going to go into anything about the promotion or option agreements, but could you just explain to me once again, perhaps, what the difference is, please? Yeah.
Yeah, I can answer. I can answer that. So a promotion agreement is essentially where you work with a landowner to promote the land, to get a planning permission or allocation, and usually there will be a fee, a kind of percentage fee associated with that promotion agreement. Whereas an option agreement is where you're not promoting the land. Well, you may be promoting the land, but an option agreement normally has a fixed price within it or a price mechanism for the land. So it's normally on the basis that someone then buys the land.
So you wouldn't be having option agreements then?
So option agreements would exist and do exist where there's additional smaller parcels of land, for example. So if you're working on a scheme and you had, I don't know, 90 acres of a site with one landowner you're promoting, and then there may be 10 acres, you may have an option agreement that has a price for that land. That means it can be purchased.
So might that, without
yes,
giving anything away, might that apply here?
Yes, yeah.
But what, on both sites?
Yes, yeah.
But it would be one or the other, would it? Or might both?
It would be one or the other, yes.
Okay, thank you very much.
It's the control of the land is the key point, I think.
That's my question.
Right then.
Thank you.
Thank you.
About probably 10 minutes or so. Are you feeling...
Good.
Yes, you're all right.
Okay, you sure?
We're nearly there.
Okay, have a drink of water or something and deep breath. Long couple of days.
Yes.
Okay, most of the things are Mr. Young. There's just one thing that's Mr. Bell. So the one thing that's Mr. Bell's about this promo agreement, which is what the inspector's just been asking about. It goes to Mr. Young as well. It's been said. Both of them have said you could have provided it. You turn your microphone on. You could have provided it. You've decided not to provide it, etc., etc. We don't know what it says, etc. All of that. Do you remember all of those questions?
I do, yes.
From both of them. Are the terms of what's in a particular promotion agreement relevant to financial viability appraisals under the PPG?
In my understanding, no, not at all.
Is it relevant in the lease then to deciding whether or not a scheme's viable under national policy and guidance for the inspector and the Secretary of State to know what's in these commercially sensitive agreements?
No, I don't think it has any relevance under the MPPF or MPPG.
Are you aware of any? I know you're not the planning witness, but are you aware of anything, any policies or guidance or anything at all that suggests that this stuff should have been provided at any stage?
No.
And did Swale ever ask to see these things?
No, and I don't think they would because they were working to the MPPF and MPPG methodology in assessing the FEA.
Okay. Mr. Young, then, cast your mind way back. And really, a lot of Mr. Young's questions were to do with the comparative approach between Jackson's and what they did on the one hand, Jackson's and you and others and Quinn's and everything on the one hand, and what Mr. Parks did on the other. There was lots of questions exploring the differences, if you like, between those two approaches.
Yes.
Let me remind you of a few of the differences that he asked you about. One of them was about the Jackson's work being essentially an amalgamation, I think was the word he used, an amalgamation of lots of people's work. So you had, and I'm just summarising what his questions were trying to summarise. The idea was there was engineers, there was cost consultants, there was scrutiny from Quinn's, there was different contractors, etc. There was different information that Jackson's
it was earlier today.
Whatever, all of that. That was the Jackson's stuff. If we just call it that. And then we have Mr. Parks and what he did. And you'll remember from Mr. Parks's cross-examination that he took no input from any other specific technical disciplines like engineering or programming or project management or anything like that. So you've got these two different exercises.
Yes.
So let me ask you this then. Is the wider range of inputs into the Jackson's work a strength or a weakness when it comes to trying to come up with robust costings, in your opinion?
I think it's a significant strength.
Why do you say that?
Because we're not relying on a chartered surveyor to measure some drawings and then apply standard rates. We're reliant on a multidisciplinary team, including the designer of the road, our in-house team, cost experts and cost consultants who work for a contractor, all to provide evidence. That evidence is then discussed and scrutinised. There's opportunity within that arrangement and those discussions to look at the wider information within the application, to discuss assumptions over things that the road designer may or may not have, and all of that
allows us to provide into the FVA something that we consider as a more robust than considered sum.
Things like whether the road plans show vertical alignments or not, if they're properly interpreted, things like that.
Yes, the 3D model, the vertical alignment, the fact that Mr. Wild and his colleagues at CNA actually worked out the exact geotech requirements for boreholes. That was their plan that fed into it, because everyone's working together from our side to try and have the right amount of information. I think that's a benefit.
So flip it the other way round.
Yes.
Is the lack of inputs, lack of wider inputs into Mr. Parks's work a good thing or a bad thing from your perspective, so far as the robustness of what he's done?
I think it's a bad thing, and that's maybe why he has such large contingencies.
What do you mean? Can you explain what you mean by that? Why do you mean that's what he might have had such large contingencies?
So if he's not relying on the information from engineers, from cost estimators, from all the people I've just mentioned, he may then have to make assumptions of higher numbers and put in higher contingencies.
A similar question, but for planning application documents, because you made clear in one of your answers to Mr. Young that the Jacksons and the team, Mr. Wild, etc., were aware of the wider planning application documents that went along with, and you've mentioned just now the geotechnical documents. Yes. And the other documents that went along. We know, obviously, from cross-examination with Mr. Parks, that he didn't have access for whatever reason to, I won't go over that again, but for whatever reason to any of that material, any of that wider material beyond that which was supplied to him by his client, Kent County Council. So here's my question. When it comes to Mr. Parks's work, is that a good thing or a bad thing from your point of view that he'd not had an opportunity to, whatever reason, review any of the wider planning application documents when it comes to the robustness of his work?
It's a bad thing.
And why do you say that?
Because it may have fundamentally changed the assumptions he made over costs. It may have, by having access to more information, the type of information that he said he would, under his own cross-examination, said he'd need to come up to a more detailed figure. That information was available, and part of the planning application was available to my team, who looked at it, and that informed our figures, not his figures.
Similar question, but about the exercise that was undertaken by Mr. Parks. You said to Mr. Young that Jackson's addressed their road costings in the context of the wider development scheme.
Yes. And
we heard from Mr. Which is to say, 8,500 homes, etc. Or the wider planning application. Yes. Whereas we heard in cross-examination from Mr. Parks that he did not do that, and he assessed the road scheme, if you like, on its own terms, solus, and he explained all of that in his evidence in chief, because that's what he was asked to do by his client, Kent County Council. So here's my question. Is the lack of a wider review of the thing which the roads form part, the wider scheme, is that a good or a bad thing from your perspective when it comes to the robustness of what Mr. Parks has done on costings?
It's a bad thing.
Why is that?
Because he's not costing the scheme. So he's not costing the roads within the wider scheme. He's costing it as a standalone piece of infrastructure, which means his assumptions over earthworks and other matters. So in particular earthworks, though. So because that's one of the main costs we've looked at, are going to be very different from our assumptions.
In the earthworks section of Mr. Young's cross-examination, we turn to, I'm not going to turn them up now, definitely not, but anyway, we turned to those spreadsheets that had different numbers in for different earthworks and all of that.
Yes, we did, yes.
And it was series 600. I think we can turn it up, but I'm not inviting anyone to, because it's very easy to get lost. And you were criticised through the questions for putting in sums for earthworks without knowing where the borrow pits are going to be. Do you remember?
I do remember that, yes.
Mr. Parks also allows for sums of earthworks on site to be moved around the site, cut and filled within the site itself. Not as much as we do, but he does.
Yeah, I'm Sorry, it's just the road actually. It's not the wider site. So the cut and fill that's referred to is on the route of the road. It would be wrong to
fair enough.
characterise that as somewhere else.
Fair enough. Okay, fine. In that case, that answers the question.
It's cut and fill related.
So he assumes that's right. You assume no borrow pits. Is that then? So the question then is why and how do you say that it's possible to assume a figure for earthworks and for borrow pits on the site without knowing specifically where at this stage those borrow pits are going to be?
So we know that there's over 345 hectares of open space within the site. We know that the area where earthworks are most predominant is in that area. So that's the area through the country park. We have had my technical director, who is an engineer, civil engineer, has reviewed the information within our geotech report, as have JCE, as has Mr. Wild in particular as well, and they've made an assumption and they've reached a conclusion on the information provided that they are content that it would be entirely possible to essentially use earthworks on that basis, so essentially borrow and move material in the site without a need to import and export material. And that's what then has fed into the costings, and that's the difference between the costings, because essentially you're paying to move material rather than export and import it. It's not the amount of material, it's just how it comes on and off the site.
You did assume 50% though, didn't you?
So that
Sorry, not you.
The 50% is what's usable before you have to move it. So once you're moving it, assuming 50% is usable, you can use it, but it doesn't mean you haven't got more material on site that is usable to cater for that. Yes, you're importing it from within the red line, not outside the red line. I think that's the simple term.
If it helps, the 50-50 is agreed between the parties. It's just they're saying we agree and they agree that the 50%, only 50% of the material is usable for the purpose of the earthworks. The difference is where you get on site. The question, I understand the question being put. The question is was asked about the documentation supporting this, and where is the information about the borrow pits and the haul roads. So it is right that there's a question in there. There was a question about where was it done. The question was actually put about the documentation to support that.
I was trying to respond to the question. I don't want to get the question wrong. I thought the allegation or the suggestion was that there was some sort of weakness in making the assumption that's been made about the quantum of earthworks or of borrow pits without identifying in a plan or something where those are going to be. I thought, but maybe I've misunderstood.
It's the costing associated with the earthworks, which doesn't rely on a document or something that we can read other than the entries into the Jackson's cost plan, if we call it that. So in other words, the discussions are just talking about there, where's the document to go to that say, right, well, we're going to do this, the borrow pits will be here, the haul roads will be here, and there isn't any documentation to that effect.
That's what I'm trying to say. So without a document showing the specific locations, just trying to take what Mr. Young said, of both borrow pits and haul roads, without borrow pits and haul roads, how can this cost be assumed?
So this was a detailed assessment and discussion that the team had. So they looked at the technical information that's the geotechnical information, and were satisfied that the soil material would be suitable for reuse within the site, such that we wouldn't need to import and export material, and that's an assumption that's been made based on experience of civil engineers.
Next question. Oh, sorry.
I just want to make sure I do actually understand this then. So basically, the applicants are saying that 50% can be reused of the within the route, and the other 50% would be got out of other bits of the site in the red line from borrow pits. Is that right?
Yes, and the 50% assumption was agreed, but it was agreed as a worst case.
Yeah, but Mr. Parks, I think, is saying that that other 50% has to be brought into the site from outside. Is that correct?
Importation, and hence the £40 per cubic metre.
So in my understanding of Mr. Parks, his assumption is because the road's being costed in isolation, you can't rely on any material outside of the corridor of the road to meet that requirement, and you have to import it from off-site, from somewhere else completely. Whereas we've got 350 hectares of land that we have an appropriate level of detail, we believe, that within that 350 hectares, we will be able to find the material we need to do it rather than importing. And then it's just a case of moving that material. And we'll be removing material anyway because we've got to deliver service land parcels, we've got to deliver the country park, we've got all the work to do, the topographical changes associated with that. So it's the difference in our assumptions, but it's a big difference in cost. And I think it's almost 15 to 20 million pounds worth of difference on the Southern Reef Road, so it's a huge sum.
Thank you.
Okay, that's it on Earthworks. Briefly, don't need to turn it up, but you were taken to the Essex Garden Communities North Essex local plan report thing, or series of reports. Sorry, there was a number of reports and a sequence. Yep. And you were taken to some comments that the inspector there had about things like optimism bias and the right approach to contingencies and stuff like that. And you said in your answers that you didn't think that it was a so firstly, do you remember all of that? Just turn your microphone back on.
I do remember, yes.
Yeah. You said in your answers to Mr. Young that you didn't consider that was a comparable situation to the situation that inspector was writing about and considering was not a comparable situation to the situation that we're in here. And so I wanted to understand really what you mean and to sort of drill into what you think the differences actually are.
Yes, so that was through a local plan making exercise rather than a planning application. So that's the key first difference. Secondly, the local plan work related to 3 broad locations. I don't think they'd even decided whether the land was for the garden communities at that point.
Where the land was? Did you say?
The exact extent of land that was needed for these garden communities.
So they were broad locations.
It was almost a theoretical exercise,
right?
Which was quite heavily criticised at the time. And
what about numbers? What you talked about? Do you know broadly what we're talking about?
47,000 homes in 3 garden communities
across broad locations.
Across 3 different district or borough councils, I believe.
Right.
So it's this was a local plan making exercise to try to allocate 3 very, very large garden communities without land secured, not at the planning stage, without a detailed understanding of exactly where the schemes are going, what infrastructure was needed. And so I presume at that point the inspector felt they needed some fairly significant contingencies, whereas we've got a planning application supported by huge amounts of information, indicative design of a road, foul water strategies, drainage strategies, all the strategies we've discussed. So I know it's been provided by Kent as if it's on a like-for-like basis, but I disagree with that view.
Okay, that's it on that one. I think lastly, let me just check lastly. Yeah. Lastly, questions about profit. Questions about profit. It was said to you, and I'm summarising, but just so the inspector knows what I'm asking about, I'm not intending to rephrase what Mr. Young actually said, but it was questions along the lines of, Mr. Gearing, if road costs go up, basically profit has to be what takes the that was the idea. He said it was the only place to go.
Yes.
That along with reduction in money that goes to landowners, and so really I just want, before it'd be something that Mrs. Dickinson talks about tomorrow as well in the context of what FVAs are and all of that, but just before we leave your evidence altogether. I do just want to take you back to where you took Mr. Young and just really examine whether or not the way that he put the question was realistic. So, Appendix 1, you took him to Mr. Mitford Slade's Southern Scheme MD appraisal. So that is 37.13.5.
Yes, I've got that here.
And it is, just everybody watching, 37.13.5, and it's PDF page 4. We've seen it many times before now, but it's it is the appraisal sheet. This is Mr. Mitford Slade's appraisal sheet for the Southern scheme, and I'll just let the inspector get it, and then I'll just ask you about it.
I'll just get it up on here, I think.
Yeah.
I don't think I've got it. 37. Oh no. Oh, 13.5, yeah. Okay.
Sorry.
Yeah.
Yeah. So it's the actual appraisal summary with all the. Yeah. Okay. So you were asked in Mr. Young's question to assume on this sheet that two of the things changed, and they changed upwards, and those two things, just to be clear, were the number for the link road, which is in at 111 million.
Yes.
Just make sure the inspector can see that, and then the number for the motorway junction at 49.5 million.
Yes.
And you were asked to assume that those two go up, as it were, towards Kent's numbers. And Mr. Young's point was, if that happened, then the only response to such a situation would be essentially that profit would have to go down, in a nutshell.
Yes, yeah.
So, firstly, then, really, your take on the realism of the question: a world where, as you mentioned in your answer to him, you're talking about you've got construction costs in at 339 million, and indeed another 58 million pounds then of finance costs on top of that. But a world where, should we be assuming, in your opinion, that none of these costs are going to change in real life?
No, and I did try to discuss that with Mr. Young, that clearly we have significant other sums that are intertwined perhaps with the road costs. So site-wide ecology, green infrastructure, utility infrastructure, site prep and enabling works. Site prep and enabling works is exactly moving land around. We have £26 million in there for site prep and enabling works that is separate from the road cost. So these are large sums that are also within our construction costs that are available and identified within the FEA. So the idea that the road cost could only be looked at in isolation, and I think I was asked to live in a world where nothing else changed, all those sums are the same.
That's the point of this question, yeah.
Yes, the values couldn't go up.
Well, I'll ask you about values in a minute.
So I was almost hamstrung into I guess that only those costs could go up. I couldn't change anything else, and therefore the outcome of that would be, the only outcome would be that potentially your profits could go down.
And how does the concept of value engineering over the course of detailed design play into this idea about whether these costs are going to be as they are here?
It's used because, make sure that's on, because this is a project over many, many years, and assumptions can be made about delivering the road, and the phasing of many of these other items here would all be considered alongside the cost of delivering the road, to make sure that from a cash flow point of view it works. You would never just look at each of these in isolation and say, oh, the road's gone over, well, we better stop. Well, that's coming out of profit. That's not how it works. We've got sums of money here identified that generate a significant sum beyond the highway costs.
And the next thing on this table that I want to ask you about is the revenue line, because you were asked to assume that the valuation, that the income received from the serviced land plots would be unchanged over time, and that the commercial land figure would be that the income side of it remains unchanged as well.
Yeah, we would kind of assume to be in a world where costs are increasing but income isn't increasing.
Right. So what are your reflections on that, on the sort of robustness of the assumption baked into Mr. Young's question?
I think it's unlikely, and we've done our own sensitivity test that assumes if you had a 2.5% increase in infrastructure costs, which are across the board there, but also a 2.5% increase in sales values on the plots, that would generate, I think, £16 million of additional money, and that would allow 10 million of that, because a lot of that would go into financing, would be available for infrastructure spend. So this isn't, although this is a point in time FVA, if things are changing in the future, it's very unlikely it would just be the road costs that are changing.
So if that's all correct, then where does it leave Mr. Young's suggestion to you that if road costs go up, the only way out for the master developer is profit loss?
I think it's unrealistic, and you would do a huge amount of work looking at phasing, value engineering, program, all these other matters before you, the structuring of deals and things as well, before you would start to look at profit levels.
He said to you, Mr. Young did, that I think he asked you, and again, I'm not quite going to get it right, but the idea was you'd failed to indicate how low you would go, essentially. You'd failed to indicate what percentage of profit, if not the 15% input as an assumption into the FVA. If it's not 15%, then what percentage would it be? Essentially, questions along those lines to you. He said that the Secretary of State, he said, would want to know what percentage profit the developer would accept in this case, he said to you. Do you remember that?
I do, yes.
So, okay. How long have you been a professional planner working in this industry?
Over 20 years.
Have you ever seen a case where the Secretary of State seeks to fix the amount of commercial profit that a developer would actually accept over the delivery of a multi-decade mixed-use development?
I've never seen that, no.
Thank you. Those were all my questions.
Thank you very much, everybody. Right, you must be relieved, Mr. Gearing, that you've finished, I should imagine.
It's strange for a meeting on Friday.
Don't know what to do with yourself.
Yeah, I'm pleased we finished today. Thank you for making sure we could do that.
No. So we're now free to start Mrs. Dickinson tomorrow morning. I suppose we better start at 9 o'clock, can't we?
I'm no more enthusiastic for that anymore, but I think just to make as sure as we possibly can that we're ready at 12-ish or 12 and thereabouts for Mr. Young to dial in, that would be safest.
Yes, indeed. But you said you're going to be listening to the morning, didn't you, as well? You'd be dialed in anyway, won't you?
So I'll be in chambers and I'll listen from there.
Yeah, all right then. Right, is there anything else before we... Right, okay, thank you all very much. So see you at 9 o'clock tomorrow morning. Inquiry's adjourned, thank you.
So sweaty.